Lord, may I have apology. Lord, may I have my Lord's kind leave to grant of leave for moving a matter, urgent matter tomorrow, my Lord, after service, my Lord, because the election is going to be held, my Lord. It is not with regard to any political issue or panchayat, my Lord. It is with regard to a society, my Lord, where I was a member and I was suspended without following the due process of law. I have made an application before the competent authorities who are apartment owners association under the act, my Lord, in the month of December. Reply was
When
given,
is the election?
my Lord, on Sunday, my Lord, and I was waiting.
Will you come on the last day?
My Lord, my Lord, will kindly be. I am not cutting a sorry figure, my Lord. I was waiting for the competent authorities' order that would have settled the issue. But then the competent authority has not passed an order, and the election is going to take place on Sunday, and I'll not be able to participate, nor I'll be allowed to vote because I am a suspended person, and I was suspended from the committee without following the due process of law. So, my Lord, I will serve everybody.
Very well. Come back tomorrow, but I do not know. Without the authorities' decision, how can this be done? And
My Lord, what we are wanting is, my Lord, let the authority pass decision. But till that time, the election should not take place. Let that, because authority is in session of the matters in December. My Lord, and then what is...
anyway, you make your submission tomorrow upon service of notice of all to all the parties. Let us see.
I'm
I
grateful.
have your lordship's kind leave to mention a matter, my lord. This is appearing as item 519 in your lordship's list today.
Item?
519, my lord.
All right.
My
Is
lord,
it an
this is-
application?
Yes, my lord. It's pertaining to interim orders, a tender that is to be floated by Coal India, my lords, any day.
Yes.
Pertaining, my lords, we have filed the CAN application. We mentioned it, my lords. Your lordships had indicated to have the other
Yes.
side, my lords. We've given a notice.
Come at
And-
2 o'clock. Not 2 o'clock. 2 o'clock, I'll start with the applications. After I take up the regular applications, I'll take up these mentioned matters.
Yes, my lords.
Give
My lords,
the
if your
number.
if your lordships grant us leave, we'll also send them another email or another
Yes,
notice.
please do.
Yes, my lords.
What is the number?
My lords, 519.
519. File the barcode, Raghavan.
With
Yes.
Milord's
My lord,
kind,
your lordships kindly may I permit to mention, my lord, item number 474 of day's list.
Contempt.
Contempt
Bring
application.
your other side.
My lord,
File. Yes,
At-
474.
474 at 1 o'clock.
No. 2 o'clock, I'll take.
Yes, yes, two.
2 o'clock, I'll take up applications.
I'll-
After regular applications are taken up, the mentioned matters will be taken up.
My lord,
Please
I'll
follow
come.
the list. Your other side.
Yes,
there.
I
May kindly allow me to mention one matter that has come up with a grave urgency, my lord. I'm at the verge of being evicted from my residential property. My lord, the bank has obtained a Section 14 order. I have come up with an interim application, but certain material facts have been suppressed there. Now, we have submitted duly before the learned tribunal, but however, it has not been recorded. My lord, kindly gives a date, maybe next week, for the matter to be heard, my lord. Kindly.
Let them come, then you mention.
with Milord's kind leave, Milord, I'm mentioning one contempt application, Milord. Milord, this matter was directed to be listed on 17th of April, Milord. Since then, it could not be taken up. Milord, the difficulty here is that the private respondents have constructed. Milord, it's appearing as 493, Milord. I'm praying for upgradation,
Are
Milord.
you aware who your other side
No, Milord.
is?
That's why, if your lordship is pleased to upgrade the matter, I shall serve personally upon the contemners and come back on next week, Milord. 493, Milord.
49 next week upgrade.
Grateful, Milord.
May I permit to mention, Lordship, to move the matter on urgent basis, Lordship. This is matter, Lordship, of a student, medical student, Lordship, who applied for, Lordship, under the EWS category. Now, last year, Lordship, the EWS certificate was granted. Now, this year, Lordship, the counseling will be start from 30th July. In spite of, Lordship, applied inquiry has been completed in the month of June, Lordship. No certificate has been yet been issued, Lordship.
What is to be done?
Now, Lordship, EWS certificate is, Lordship, very much necessary for participating in the Lordship counseling.
I know it. Then what order will the court pass? When is the counseling going to be held?
30th of July, Lordship.
30th of July. Very well. Wednesday it will appear. You serve and leave granted.
Lord, with regard to Lord, item number 173.
My lord, I've got a very extremely urgent application, my lord.
Mm.
My lord, the urgency is this, my lord. The petitioner is a de facto complainant. At his instance, my lord, 3 cases were instituted in the year 2012, 2013, and 2017. My lord, the subject matter of the case is, my lord, defalcation of the sum of rupees more than 21 crores. Proceeding, my lord, being dragged on. Then, on the application of the petitioner, the authority concerned appointed special public prosecutor.
What is to be done?
What has been done, my lord? Just when the cases have reached at the stage of argument, the special public prosecutor has been removed.
Yes.
Now, my lord, kindly appreciate 27 is the date for argument of the case.
Yes.
And if in the meantime, my lord, the special public prosecutor who is in charge, so long, my lord, he was taking the charge of this proceeding. Now, if new incumbent comes, my lord,
Yes.
again matter will be dragged. So,
You do not get senior briefs at the argument stage. You get it? Senior counsels get senior briefs at the argument stage.
no, I am the de facto complainant.
In your regular practice, professional career, senior advocates get briefs at the last moment and they get prepared. It is same thing will happen.
The special public prosecutor appointed, my lord.
Exactly.
He has to get ready, my lord. He has
He
to
will
get
that is his
again
ability.
matter. And my lord, kindly
Special
appreciate, my lord.
public prosecutor.
There must be some reason, my lord, for
Why are you concerned?
what at my instance cases were instituted.
Yes, you.
And my lord, I am the
case.
sufferer of this case. More than 21 courts.
What are you here for? Obtaining leave? Are you here for obtaining leave?
Yes, my lord.
Please file it in the department.
With regard to
Lordship,
item
may I
number
please mention
120.
item number 449, your lordship, application, which I have given a notice to the other side. Your lordship had asked me to mention on
Right.
Thursday, so I'll get the other side after
Yes.
after the regular.
I have made my mind clear what is to be done. Please do item number
449.
449.
Item number 173 of days, this my lord.
Yes.
The urgency is the petitioner took house building loan in the year 2016, my lord.
No, but then what are you mentioning for upgradation?
No,
Sorry, sir, I'm not
Lord-
upgrading. Do not
My lord,
mention.
serial number 508. I have given notice to the,
Contempt.
no, my lord, application
Application bundle, it is there, 508.
508,
Bring your other side.
my lord.
Item number 394, contempt application. I've given to the other side.
Are you aware who your other side is?
Yes, my lord.
Slip is not required.
My lord,
My lord.
Madam, motion
50.
I have
Which item?
394.
394. All right, go.
The contempt application today in today's list, it is listed as item number 335. My lord,
Yes.
Intimate the other side.
Are you aware who your other side is? All right, bring your other side.
Milord, may I be permitted to mention a matter for inclusion, Milord? This matter is a group 9 matter.
Inclusion, I will not take today.
One difficulty, Milord. The matter was earlier heard by Justice Subhendu Samanta, Milord, but due to want of determination, the matter was released. So the matter thereafter did not appear in the list. So I'm very
When I take up matters for inclusion, please mention. It will be included.
This is an application.
No, sorry, please.
This is an application which I had mentioned. It has come back. It has come up in the list. It's item
Item
451, my lord.
Yes, 451, bring your other side.
Will do so, Lord. I'm very deeply obliged.
After the regular contempt matters are taken up, or applications are taken up,
My
you
lord.
bring your other side.
Contempt matter.
I'm very deeply obliged, my lord.
My lord, of your lawsuit, new contempt, my lord, for admission and to serve notice. Only I am praying.
No, this is not the time. This is not the time.
My lord, may I hand over this? May I hand over this slip, my lord?
No, no, no. Give the number only.
Will do so, my lord. It's 451.
Yes, yes, that's all right.
Deeply
451.
My lord, may I have your lordship's kind leave. My lord, I had mentioned this matter earlier. Your lordship had directed this to come up, but hasn't come up. My lord, your lordship.
It hasn't come up.
No, my lord. Inclusion in the list. My lord.
Inclusions will be done.
My lord, I'm suffering an order passed by your lordship in February. My lord, I'm a housing finance company. Your lordship has restrained me from creating any third-party interest
Right.
without obtaining leave of the court. My lord,
Yes.
filed an interim application in the interim. My lord, that hasn't come up. I was
You
humbly
want the
praying.
application to be enlisted?
My lord, application along with the writ petition, my lord, may kindly be together disposed of. My lord,
I understand. When did you file it?
when was it? Filed?
March.
My lord, application was filed in March. My lord, 30th.
March?
Yes.
Give the number. Application.
May I hand over the last order?
Application date of filing, the app, give the date of filing of the application so that they can find it out.
Lord, I'll mention it.
Please do.
I wrongly filed before the land matter, man. We release the matter, man, you also kindly.
Inclusion? Next month. No, sorry, please.
This is not a very German problem today, not digital arrest.
Digital arrest?
Digital arrest issues.
Yes.
Digital arrest.
Yes.
Not a very, the director of a particular government organization, she demitted office. Thereafter, she was, unfortunately, she fell prey to digital arrest, and 40 lakhs rupees has been siphoned off.
All right.
Out of which 10 lakhs has been returned. Somehow it has come back to the account. But the remaining 30 lakhs, nothing, no steps are being taken, and the police are sitting tight. The bank is saying,
Why? What are you? You want leave?
we want leave.
No. File it in the department.
I'll give the number, let's.
It will appear in due course. When I take up upgradations, mention, I'll upgrade.
It's a, may I
First Monday of the next month, upgradations and inclusions.
may I permit to mention a restoration application matter? It was
Just now I mentioned. First Monday of the month, come, inclusions and upgradations.
I am grateful, my lord.
If you mention item number 160 to 165, this matters relates to conservation of the Chotra bill. Now, after filing
Conservation of
Chotra bill area.
Oh, yes, yes.
This matters after filing Miller. These matters were mentioned by learned senior advocate Mr. Lahiri to your lordship. The lordship was pleased to direct the matter today under the heading urgent motion. And for some reason it is appearing under the heading new motion. Kindly take this up matter tomorrow under the heading urgent motion. Kindly, there are some urgency Miller.
Item numbers
160 to 165.
160 to 165.
Yes.
Tomorrow is urgent motion.
Miller, along with this Miller, other 4 matters, it is returnable tomorrow, Miller.
All right.
Miller,
Yes, give. Yes, give.
Lordship, paying for non-prosecution, lordship.
Give.
But for upgradation, but I'll come back.
My learned friend starts. The last occasion I made a wrong submission, my lord. So far circulars are concerned, municipal commissioner circulars are almost uploaded.
Then this is what you submitted and that has been recorded in the order.
Almost uploaded, not everything, but almost various circulars have been uploaded.
All right.
Only the other circular, DG circulars are not been.
But it is mentioned that in all departments, if I am not.
All departments.
That includes the DG. DG, it is.
Departments regarding municipal circular, municipal commissioner circular. But that is the mistake I have committed, my lord. I tender my apology, my lord.
Contender has led to the municipal commissioners according to for uploading all the circulars of all the departments. Will it not
Yes,
take into consider the
very well,
DG?
that remains there. It will enable the department to upload all these.
Milord, only one thing, Milord, I have filed a GA
Where?
in connection with the contempt application. Milord, may that GA, Milord, GA number 1 be also, Milord, tagged with the main file. Milord, I have pleaded for, Milord.
Who are you?
Milord, I am the, Milord, promoter. Milord, the promoter who was a party to the writ petition against me, allegations were made. Now, today, Milord, there is some order made by the special officer building which has been questioned. No, Milord, I will only beseech your lordship if I can be formally added in the contempt or Milord, some steps be taken, Milord, so that at the time of disposal, Milord, your lordship will kindly hear or Milord, do whatever, Milord. At least, Milord, my application be heard.
That application I think is not in the board. Neither have.
It is not in the board. I am saying what has been served.
Two things.
What is to be done today?
Milord, I will first argue that despite the circulars that the municipal KMC has produced, my lord, the contempt remains.
Oh, what?
It's an order of court.
What has happened? Just let me see.
What has happened is, your lordship, my lord, in the first round when I had filed a writ petition, a report was filed by the KMC saying that unauthorized construction is there.
All right.
Your lordship directed the executive engineer to, my lord,
Take steps.
Take steps and pass an order with regard to the unauthorized construction.
What has been done?
The special officer building, instead of the executive engineer, has a bit of power and gone ahead, despite several letters saying that you are not the authority, the executive engineer is the authority, that is the director of the court.
Yes.
But he has gone ahead and passed, and clearly after admitting that unauthorized construction is there, he has recognized major unauthorized construction. Number 2 things. I will say, despite the circular, it's an order of court. And if the municipal commissioner thought that despite the order of court, he will ask somebody else to take, he should have made an application or he should have mentioned and got a modification. Modification, number 1. Number 2, I am saying, my lord was hearing another matter, similar matter, Rohina Nandini Mehrotra.
Yes, it's due to appear in the list tomorrow.
Yes, my lord, I am saying, my lord, we are all waiting for that decision of your lordship, because the same argument I am going to make.
Very good. Let his application also come. I'll post it next week.
I have
serving a copy of the application.
I have submitted only one thing.
Serving a copy of
to direct the executive engineer deal with the matter. He has what he has understood, I don't know. He has prepared the file and sent it to the higher authority, who sent it to the special officer for disposal.
Hmm.
How this word deal with, how it will be interpreted, that has to be decided, Your Lordship.
Hmm.
Whether the examiner hear it or not, or to deal with the file and send it and take the appropriate steps in terms of the circular.
What is your stand?
This is the estate's property, madam.
And somebody else is coming and making construction.
No, not some.
Estate has made construction. Who has made?
Developer has constructed.
Yes, and you are not.
There is unauthorized construction.
You also say there is unauthorized. You are the estate. You did not engage the developer for making construction.
Yes, my lord.
Did you?
Yes, my lord. But what the agreement was, the developer has constructed, my lord. What?
Beyond
Yes.
what the agreement is. But that is a private dispute between you and the developer. That is different. The court is concerned only with regard to the unauthorized construction that has made.
Corporation has already submitted report, my lord, that there is unauthorized construction.
Yes. It has to be seen how soon it is to be demolished or what is to be done with it.
No. The corporation has now passed an order.
My lord, no, Supreme Court is very clear.
Yes,
They
yes.
not want. I not want.
Let us see what is to be done.
Well, now-
Your application number also be given?
I'm not yet filed, my lord. Your lordship, kindly give me liberty so that I can file.
No, certainly not. It is your choice whether to file or not to file. Why the leave is required?
My
Leave is not-
application is not
I'll
G1.
file.
Yes. Acha.
Give me 1 week time so that I can file.
When did you file? You not filed it? It has not been numbered?
Not yet numbered.
Then
The
how
ask-
where from you are getting the number?
নাম্বারটা কত?
One.
The moment number is given,
Hmm.
it is auto-generated in the CIS and it is there in the list. So,
কি বলছিস?
no, wrong submission. Early in the morning,
No, no.
wrong submission.
No, he said. it has been-
GA
it's mine.
number,
It's mine.
GA number. It has not been numbered.
I take it on myself. কি বলছিস ভাই?
হ্যাঁ,
তোর কোথায় নাম্বার কই?
নাম্বার তো আসেনি।
নাম্বার আসেনি
Let
বলে
matter-
ফাইন দিতে হবে।
Let the matter appear in the list for further consideration on
No,
24th.
It was filed on the formed on the 10th of July.
But I am appearing for one of the private respondents.
আরে হ্যাঁ, don't take it. Of course.
এসে যাবে।
Essential purpose.
Whatever, we are not looking into all these things.
On the next week, I will.
Next week is 20. Why? You take your time. No, certainly not.
Grateful, sir. দেখছি।
I'm grateful to your lordship. Well, that matter, your lordship will hear first. The other matter,
That has been hard.
only order required to be passed. I am grateful to your lordship.
My lord, I am for the
All right.
My lord, on the previous day,
Decision by whom?
my lord, from the bank,
All right.
I am paying for leave.
Affidavit in opposition by the bank filed in court today is taken on record. Stop. Learned advocate for the petitioner seeks time to file a reply to the same. Stop. Released on. What is the matter about?
There was a letter from the bank manager where my mother personal by
To issue NOC in its favor as a petitioner waived from the respondent. What is the stand of the bank?
My lord, the NOC has been granted by the bank and
Has been granted.
already has been granted.
Let me see. Dekhi opposition ta.
they have annexed the NOC we have not received, but they say.
Let me see the opposition a minute. Show me. Please show me the NOC.
Lord, my lord, page 15 of the affidavit in opposition.
Waiver of corporate guarantee. Why do you want so much of time?
Because it was not handed over to us. They say it has been filed in the affidavit. They say it has been filed before the ROC direction.
আচ্ছা ঠিক আছে আজকে তো
Yes, your lordship.
very well 23rd.
Lord, I beg to appear for the petitioner, my lord. Lord, this is a writ petition, my lord, challenging a decision, my lord, taken by the respondent bank, my lord, declaring the account of the company as my lord, classifying it as a fraud, having the penal consequence on me directly, in violation of the, my lord, judgment passed by the Honorable Supreme Court in Rajesh Agarwal. My lord,
Why hearing was not given?
no hearing, my lord, was given to me. The
Show cause?
my lord, the show cause is a reiteration of the forensic audit report. No copy of the forensic audit report supplied to me.
All
My lord,
right.
the final order, my lord, is a mere reiteration, my lord, of the show cause notice which was issued to me. My lord, no reasons, absolutely devoid of reasons.
All right.
My lord,
Yes.
fourth point is, my lord, there is no constitution of the identification committee. The branch manager, my lord, issues a show cause notice. The branch manager himself conducts the hearing, my lord, and passes an order.
Alone?
Alone. A single member committee, my lord. But that is also violation of the order, my
Yes.
lord, of RBI.
So cause was given, my lord, and also.
Who issued the show cause notice? Who issued the show cause notice?
It appears branch manager, but I have to check whether committee has given.
But I have annexed the show cause notice at page 81. It's by the branch manager. It not appears, my lord. It is by the branch manager at page 82. But page 81 is the show cause notice, and the issuing authority is at page 82, my lord.
Please come. The petitioner is aggrieved by the steps taken by the financial institution in classifying the petitioner's bank account as fraud. Paragraph.
Can they allow me to discuss document if there is any? Can they allow me to discuss document if there be any? Kindly allow me to discuss document.
Disclose document. All right. The petitioner alleges that the order passed. Now, the order has been passed by the branch manager, who is not the competent authority to pass an order in respect of classification of fraud stuff. There is no constitution of the identification committee has not been constituted in accordance with the master circular issued by the Reserve Bank of India. Stop. The forensic audit report was not circulated to the petitioner. No opportunity of hearing was granted to the petitioner. Paragraph. These are the 4 points.
The final order is a reiteration of the show cause notice.
The final order is a reiteration of the show cause notice, which contains the details as mentioned in the forensic audit report, which has not been served upon the petitioner. Next, learned advocate representing the financial institution seeks time to file a report. Stop. Let report by the respondent be prepared and circulated by 31st July, 2 weeks time. Release the matter on 8th August.
But in the meantime, my lord, may I pray for an interim order, my lord?
The order passed. Now, the impugned order passed, classifying the petitioner's account as fraud, shall not be given effect to till 14th August 2025 or until further order, whichever is earlier.
Item 4 is my application. My lord, it's a short issue, my lord.
My
My
lord,
lord,
I
I was a customer of the State Bank of India. When may I find my affidavit, sir? It's already there, my lord.
You were a customer of the
State Bank of India.
State Bank. You
State
are
Bank
for
of
the
India. My lord, State Bank is perhaps not the necessary party here. Reserve Bank of India is the necessary party here. He's been served, my lord. Can I just indicate of the affidavit of service, my lord? 11 July it's been received.
All right, then.
My lord, short point, my lord. Here, I had filed a complaint under the RBI Ombudsman scheme. The State Bank of India writes back to us thereafter saying certain documents are required from my client's end. I provide those documents. I'll show, my lord, the State Bank of India in their communication does not provide any deadline as to by which time I will be able to supply those documents. They send me a notice on 22nd April. I reply on 30th April. No other communication received from the Reserve Bank of India, nothing. Thereafter, I am shocked to receive on 30th May
closure report of the Reserve Bank of India stating that I was to reply to the State Bank of India within 3 days. I will show, my lord, there was no such time limit prescribed. I have written to the Reserve Bank of India thereafter saying that no other
What is
communication.
your complaint against the bank?
Yes, my complaint is, my lord, there were certain bank guarantee charges. I had taken bank guarantees from the State Bank of India for my own business purpose. That apart, I had a loan account. My lord, my claim is overcharges on account of the loan account and also the bank guarantee charges that have been charged. Even after closure of my bank guarantee, the State Bank of India continued to charge me for that amount. That is squarely a deficiency in service in terms of the RBI ombudsman scheme. That is my concern. That's my complaint. That complaint is not considered on merits. I am only praying, my lord, let the Reserve Bank of India consider it on merits and pass a reasoned order. That's all. And that's as per the RBI ombudsman scheme.
If the bank is able to satisfy that your grievance cannot be
My lord, of course, my lord, that can be decided here as well. I don't stand in the way, my lord. Of course.
What is your stand?
My lord, kindly come to page number 38 once. Page number
Is
38.
this the document prior to you starting? Please show me the document that you were to reply within 3 days.
Yes, madam. First, madam,
Or
may I
no
just show-
time limit was given?
Yes, yes, madam. Madam, under the RBI ombudsman scheme, I have to first send a notice representation to the bank. That is at page 38, 7th March 2025. I send a representation to the bank. Page 38, madam, will find that. I have stated my disputes as to what amount, according to me, is overpaid by my client. Thereafter, they don't reply. I then I file a complaint on 17th April, page 40. That is after a month. That is as per the timeline stipulated under the scheme. I file this complaint. Malad, I cannot have a copy of this because this is typed out into the computer. This is the acknowledgement receipt. Thereafter, Malad, the bank replies, page 42. Page 42, Malad, we'll see. They ask, point number 1, as per bank service so-and-so, if the purpose of the BG was issued has been completed, then the BG commission charges for the unexpired period cannot be refunded. Now, this policy, bank service circular, I asked them to produce this. They do not do so, but that is a different point. Point 2, with reference to excess LC issuance charges, we request you to share a copy of the accepted sanction letter, so-and-so, so-and-so. No date. Malad, we can read the entire letter. There is no date at all specified. And Malad, this is marked a copy to the Reserve Bank. Towards the bottom, Malad, we'll see copy to the Reserve Bank.
Sanction letter. Compared interest charged.
No date.
All
Thereafter, I reply on 30th April. I don't take undue time. On the next page, I'm sorry. Page 43, I reply stating my contentions, and I also state that I'm an MSME concern. Therefore, certain exemptions are applicable to me. Thereafter, Malad, immediately I received the letter of closure of the State Bank again replies on 7th May. But this letter is also not considered by the RBI. I'll show that from the order itself. Malad, the next page, 46, is the closure report. 13th May 2025, RBI writes to me. Malad, will take 47. It states the disputes, and then 47, may I read from Malad? Also the bank, the sentence starting with also the bank has requested the complainant to furnish relevant sanction letters for the relevant periods for further investigation as to the complaint covered a long period. The reply furnished by the bank was shared with the complainant via email dated 24th April. No such email was received. I've stated that on a contemporaneous reply as well, with advice of his offer of advice to offer his or her comments within 3 calendar days. But I've seen the reply, there's nothing of that sort. However, no response counter comments were received by the complainant within the timeline. Apparently, there is no deficiency of service, so and so. And Malad, here the Honorable Division Bench of our court, Malad, has held that sufficient reasons. This is a quasi-judicial body. They have to provide sufficient reasons. My only grievance is there was no timeline provided in the 22nd April letter. I have replied to it. That has not been considered. 7th May bank replies. That has also not been considered. This is not a decision on merits. And also, Malad, we'll see towards the bottom, paragraph 6. This is a non-appealable order under clause 16 of the scheme. I've annexed the scheme as well. I'll take Malad to that. Non-appealable order. Thereafter, Malad, I again resubmit. My client's instructions are, Malad, the RBI officer had requested us to resubmit. This is my instruction, Malad. Consequently, they've also again rejected, saying that we've already closed.
Exactly.
I'm
Page
sorry.
47
Yes,
does
yes.
not say so that you can resubmit.
No, this is on oral submissions, my lord. This is my
So it
instruction.
will be
Let that be, my lord. I'm not on that.
reiteration of
My
the
lord,
same thing.
that is I'm not on that. My main grievance is page 47, 47 is my main grievance. Today I am only seeking my complaint to be adjudicated on merits as to whether there is a deficiency in service or not. And my lord, I'm covered by one judgment of the
And
honorable.
page 38
I'm
is your principal complaint before the State Bank.
Yes, my lord. Yes, my lord. Principal complaint, there are several other letters. I've referred to, my lord, will kindly see 38 towards the bottom, my lord, will see other letters I've been writing to them since 2024. These are crave leave. I can produce it.
Allegations are the same.
Yes, yes, my lord. Yes, my lord. Yes, my lord. Because I close.
Your reply to page 38.
My lord. My lord, kindly come to page number 38 once, my lord. I am reading with the second paragraph.
You better file a
However,
report. You file a report disclosing all facts and figures in respect of page 38.
but the only thing is that, however, since 2013 to 2024, my lord, this is a 12 years. It's a big time, my lord. My lord, the
Yes,
thing
yes.
is that I don't think so.
Every
Bank will
reminder
give all the bank guarantees.
You can?
I can give you all the bank guarantees which they are already created. There is a 12 years, my lord.
He wants bank guarantees for 12 years.
My lord, this is the only thing, my lord. These are the amounts which they are indicated that we are taking extra money for that, and they are want for the 2013 to the 2024, my lord. This 12 years period, my lord. This is a big period. And the second thing is that they have already take over the account from our bank.
Yes.
And after taking the account from our bank, they have filed a complaint to the RBI. After that, these things have been come.
All right.
This is
on
the main
that,
thing, my lord.
only the points that my learned expressed relied on.
You want information for 12 years?
No, my lord. I was a customer, my lord. 1 second, my lord. Perhaps, my lord, not full submissions have or full instructions have been given to my learned friend. I've been a customer of the State Bank of India from 2013 till 24. Admittedly, during that span, my lord, I take out bank guarantees on recurring occasion. I can show, my lord, several bank guarantees over the span of so many years, my lord. Several times I've taken bank guarantee. My only dispute is once I foreclose the bank guarantee, I cancel it prior to the date till which it is valid. I foreclose it. They still charge me bank guarantee commission charges for the unexpired period, which is against the RBI norms.
Very well. If
That is my only.
so,
Yes.
if that be so, then which is the bank guarantee which you foreclosed?
Exactly.
Well, that all details are there.
All means 13 to 24 is not the
there is-
details.
Well, I can produce all the records. It is voluminous. We have written to them
If you
several
have
times.
voluminous records,
Yes,
where
yes.
from will the bank get so many?
We'll provide them. Malad, we'll provide them the entire copies of all the bank guarantees. Malad will direct me here and now. I undertake within a week, we'll provide every single bank guarantee on which we dispute.
And
we provided detailed statements.
after you have foreclosed the account, after you have taken away the account somewhere else, you raise allegation against the bank.
Malad, that is,
Why?
I have been raising. 1 second. Malad, since 2013 itself, I have contemporaneous correspondence for the entire period. I have objected to it. My only grievance is this is a deficiency in service. My grievance relates to a period during which I was a customer. I have not raised any grievance for any action of the bank post my moving of the bank from the State Bank of India. For that period, there was a jural relationship.
When was the account
transferred
closed?
around September 24, I believe. Malad. September
This
2024.
Page 38 is March 25, so it's post your moving out.
My grievance relates to that period. I made the complaint after, Malad.
So
Malad, that
it
is not barred on
after you move out.
afterthought.
You
Malad, possibly not. Malad, will kindly see the last sentence once, Malad. A copy of our letter dated 6th August 2024, and I have all correspondence from that time. Malad, I'll produce here and now, Malad. These are original receipted. I've craved leave in my writ petition. Malad will have a look. Contemporaneous correspondence, even when I was a customer of the State Bank of India. I'm only saying this is a deficiency in service insofar as my client was overcharged.
where from do you say that your client was overcharged?
Well, this is my well, the bank guarantee is valid for a particular period of time. The bank guarantee commission charges are applicable only till that time. The bank guarantee commission charges are not applicable after I withdraw the bank guarantee and my end vendor to whom the bank guarantee is furnished is satisfied with my work. My only grievance is the State Bank has sought to impose those charges even thereafter. I can produce all records, Malad. I have no dispute.
Show me the law that it is not permissible. It is impermissible.
In that regard, 1 point, Malad. Here the bank refers to, Malad has seen page 42. They refer to the bank service change circular. They conspicuously do not enclose this. They do not provide me with a copy of
What
this.
thing?
Page 42, page 42.1. As per our bank service charge circular, if for the purpose so and so, I have asked for a copy of this circular. They've not provided me with that.
All right.
My lord, if they provide me with that circular today, I can file a supplementary affidavit bringing on record all the facts, my lord.
You
I
do
have
not know what is the charges. Only relying upon this, you file the writ petition.
My lord,
Where is the cause of action?
My cause of action is against primarily the Reserve Bank of India for violation of the principles of natural justice. My lord will kindly consider.
Listen, your primary allegation is overcharging by the State Bank of India.
My lord,
Show me you have been overcharged.
My primary allegation, my lord, subject to correction, my lord, I only say I filed a complaint that is permissible under the RBI Ombudsman scheme. The Honorable Division Bench has said the RBI must pass a reasoned order on that complaint. It might not be meritorious, my lord, but I say it is, but it might not be finally found to be meritorious. The RBI then comes up with a closure report saying that this complaint is not maintainable because I have not replied to a certain letter. I am stating on oath and I have shown from the records, my lord, no such timeline was provided and I replied within time. I replied within 8 days. I am only seeking to have my case that I have lodged before the RBI adjudicated on merits, nothing more, nothing less, my lord.
Yes.
It's a violation of the principles of
court
natural.
is adjudicating it on merits. Show me that.
My lord, my lord will grant me a week's time. I'll file a supplementary with all the documents.
No,
I had only.
No, certainly you cannot improve your case by filing a supplementary
My lord,
affidavit.
today my cause of action, my lord, will kindly have my reliefs in my writ petition once, my lord.
Whatever your relief
I have
is,
not
you
sought
have
any
to
relief
say,
against the State Bank of India.
You have to first show that there has been a deficiency in service.
Yes, my lord.
Show me that there is a deficiency, you have been overcharged.
Yes, my lord. My lord, the entire correspondence is here. I can hand up to my lord. I've craved
Your
in my writ
handing,
petition.
no. Correspondence will not do. Show me the law that they are not entitled to charge for the period, for the entire period of the bank
Yes,
guarantee.
my lord. On that, my lord, my only submission is they have to produce the circular. That is the State Bank circular.
So without getting
Apart
the
from that, it is a
circular, you
contractual.
say that you have been overcharged.
Lord, it is a contract. I've sought that, my lord. I've sought that.
If it is
And
a
the
contract, go before the civil forum.
my lord,
Why
the
before
RBI,
the writ
my lord, will
court?
kindly have the RBI Ombudsman scheme once.
Yes,
My lord, will
please.
kindly see. My lord, it starts at page 20. My lord, will kindly see deficiency in service, the definition of deficiency in service. Page 21, my lord, will kindly have.
Yes.
Page 21 means any shortcoming or inadequacy in any financial service which the regulated entity is required statutorily or otherwise. Under this, my lord, I'm fortified by a judgment of the Honorable Division Bench, even in respect of. My lord, may I hand up? I'll hand up a copy to my learned friend as well. My lord, here was a similar case where the Honorable Division Bench was considering whether the RBI Ombudsman had correctly closed the complaint in respect of contractual dispute. The entire submission on the bank's part, and this was a private bank, was on contract. The Honorable Division Bench turns down that submission. My lord, may I place from para 35 onwards once, my lord? My lord, I'm sorry. My lord, para 23 onwards. Para
23
onwards.
All right.
Clause 15. Well, this is dealing with the RBI Ombudsman scheme. Clause 15 deals with the award by the Ombudsman. After reading the said clause as a whole, this court finds that the Ombudsman is under an obligation to consider the records placed and afford a reasonable opportunity of hearing to both parties. The Ombudsman shall also have to take into account the principles of banking law, practice, directions, instructions, and guidelines issued by the RBI from time to time, and such other factors as may be relevant before passing a reasoned order. The Ombudsman in his award can also direct specific performance of an obligation by the regulated entity. Section 35 capital A of the Banking Regulation Act 1949 vests power in the RBI to give directions. Section 45L of the RBI Act gives power to the RBI to call for information from the financial institutions and to give directions. The 2021 scheme was framed under Section 35A of the Banking Regulation Act, Section 45L of the RBI Act, as well as other statutory provisions. To the mind of this court, the said scheme has statutory force. The Ombudsman has been vested with a power to consider complaint presented before it in terms of the 2021 scheme and take a decision. Therefore, the Ombudsman is a quasi-judicial authority and has to act as per the 2021 schemes. The principles of natural justice have also been incorporated in the said scheme. It is well settled that the quasi-judicial authority has to act judicially and assign reasons in support of its conclusion. When a complaint is lodged before the Ombudsman, such authority has to consider the grievance of the customer and the defense of the regulated entity, and after giving a reasonable opportunity of hearing to both parties, has to pass an order supported with reasons. Even while rejecting a complaint, the Ombudsman has to assign reasons in support of its contentions so as to enable the aggrieved party to be aware of the factors that weighed in the minds of such authority. The Ombudsman is a quasi-judicial authority. Thereafter, my lord, it read deficiency of service also is
Have
specifically
you
quoted.
annexed the scheme where the provision for a hearing is there?
Yes, my lord.
Show
My lord,
me,
page
please.
20 at page, one second. 29, at page 29. And this is judicially recognized thereafter. Award by the Ombudsman, para 15.
Yes.
Unless the complaint is rejected under clause 16, which is the case here, which I am aggrieved by, the Ombudsman shall pass an award in the event of non-furnishing of documents as enumerated under 14.4. I am also calling upon the Ombudsman to direct them to furnish the circulars. B, matter not getting resolved under 14.9 so and so, after affording, this is not part of B, after affording reasonable opportunity of being heard to both parties. Specific provision is there. Today, my lord, it's akin to me filing a suit or akin to a civil case before a forum. Reasons are to be assigned, and the Ombudsman is duty bound to consider my complaint on merits. That is all I'm seeking, my lord. My prayers in my writ petition are also restricted only to the Ombudsman, nothing against the RBI, not a single prayer. Not a single prayer against the SBI, I'm sorry. Mullah will kindly have a look at my prayers now, Mullah. I'm sorry. It also provides a compensation if I am found to be correct in my allegation, Mullah.
Where the Ombudsman first letter you showed, there was no
First.
timeline, you said?
Yes, Mullah, that's at page 42. 42. That's not the Ombudsman letter, Mullah, that's the RBI, SBI's letter.
No, you lodged the complaint before the Ombudsman?
Yes, Mullah, that's on 17th April, that's at 39,
Page 40,
40,
my
page 40.
Page 40.
Page 40.
Page 40.
This is an acknowledgement of my complaint. I'm sorry.
Thereafter, nothing.
Thereafter, nothing. And I've stated that immediately upon receipt of 13th May, I've written to the Ombudsman immediately. My lord will kindly have a look. My lord will see page 51. Immediately, I've written that no other correspondence. I don't know what you're talking about as to this 24th April correspondence. Page 50. Page 50, my lord will kindly see towards the bottom. I write on 14th May, 11:28, the last email in the trailing mail, my lord. No email has been received. And the next page, my lord, is the continuation.
All right, please come.
Let that one reply, my lord. This vexatious letter, upon that RBI or Ombudsman will act. That is on page number 38. This is the letter for which the Ombudsman have to be act. In this letter, nothing has been explained. Nothing has been explained. Only the thing is that since 2013 to till 2024, there are a number of occasions their excessive incorrect charge has been debited from our account. This is the only thing is there. How the Ombudsman will act upon this, my lord?
My lord,
this is the Ombudsman's answer. That is
Let the Ombudsman hear him and pass an order.
My lord.
Relying upon the division bench judgment of this court.
My lord.
The petitioner is aggrieved by the unilateral closure of the complaint filed by the petitioner without granting an opportunity of hearing. Stop. A complaint was lodged before the RBI Ombudsman on 17th April 2025. Stop. The petitioner was communicated by the Ombudsman.
Page 48, my lord. 46 is the email.
On 13th May 2025, that the complaint of the petitioner was examined and closed under clause 16 2A of the RBI Ombudsman Scheme 2021. See, 16(1)(a) mentions that the Ombudsman may reject the complaint at any stage if it is found to be non-maintainable under clause 10.
Yes.
Clause 10 contains the grounds of non-maintainability.
Yes, my lord. They've acted under 2A.
Right. So, according to the Ombudsman,
it's 2A, my lord. 1A
there is
not maintainable. They
not
found it.
maintainable.
So that I'm challenging.
अच्छा.
That's the only reason.
ঠিক আছে কি বললাম right 16 2A of this scheme mentions that the Ombudsman may reject a complaint at any stage if, in his opinion, there is no deficiency in service. Stop paragraph. The Ombudsman has not given any opportunity of hearing to the petitioner prior to closure of the complaint. Stop. There is nothing on record to suggest why the Ombudsman did not find any reason for non-maintainability. Ombudsman did not find any deficiency in the service of the bank. Stop. Next. Learned advocate for the petitioner relies upon the judgment delivered by the Honorable Division Bench of this court on 10th July 2024 in MAT 483 of 2024 with IA Can 1 of 2023, Axis Bank Limited versus Indian Cable Net Company Limited and others. Wherein the court inter alia held that the Ombudsman has been vested with the power to consider the complaint presented before it in terms of the 2021 scheme and take a decision. Stop. The Ombudsman is acting as a quasi-judicial authority, and the principles of natural justice have also also been incorporated in the scheme. The court went on to hold that even while rejecting a complaint, the ombudsman has to assign reasons in support of such conclusion so as to enable the aggrieved party to be aware of the factors that weighed in the minds of the judicial authority. Stop. The ombudsman has to consider the complaint after giving a reasonable opportunity of hearing to both the parties. Stop paragraph. It appears in the instant case that the complaint of the petitioner stood closed without affording any opportunity of hearing to the petitioner. Stop. Next. The reasons provided by the, the reason provided by the banking ombudsman in closing the complaint of the petitioner is a cryptic one. Stop. Next. In view of the above, the closure report of the ombudsman is set aside. Stop. The banking ombudsman is directed to reconsider the complaint of the petitioner strictly in terms of the scheme after giving a reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order at the earliest. Disposed.
One and two, my lord, I am for the petitioner, my lord. This is instruction from the petition number 2. He wants to withdraw, my lord.
Why?
Non-prosecution, my lord. He has said that he wants to withdraw the case, my lord. He does not want to proceed with the matter anymore.
What is the matter about?
The matter was about, my lord, the sale deed was executed between parties, my lord. Thereafter, it was going for registration. Stamp duty was given, but due to financial constraint, the whole stamp duty was not paid by the petitioner. And thereafter, in 2024, when the petitioner went to pay the balance stamp amount, it was reassessed and increased stamp amount was given to the petitioner. That is why writ petition was preferred. But now they are willing to pay. They have. That is why this. The instructions will be kept on record.
The learned advocate for the petitioner submits that his clients do not intend to proceed with the writ petition any further. Stop. In view of such submission, the writ petition stands dismissed as not pressed. Written instruction by the petitioner to the learned advocate be retained with the records. Both the matters?
Both the matters, 1 and 2.
I'm for the item number 2. No?
Yes.
Number 3. Number 3.
Or respondent number 9.
For release, why? For want of determination or what?
Want of determination, my lord.
It will go where?
1.
Group 1.
3, 4, and 5. All.
Acha. Learned advocate for the petitioner has brought to the notice of the court that the matter relates to group 1. Stop paragraph. Let the matter be released from the list of this court or list of this bench for want of determination and be placed before the bench having determination. 3, 4, and 5.
3, 4, 5. All.
3, 4, 5. I'm for the petitioner. That's it. Yeah, I'm for the state.
Naam diya.
Okay. Yes.
Well, I beg to appear on the petitioner. This is under Surface Act, though I have filed this petition, malafide action on the part of the bank concerned, my lord. The bank obtained an order under Section 14 of the Surface Act in collision with the borrower, my lord, developer. My lord, without disclosing that there is a 31 flats already sold out by the borrower to the purchaser, different purchaser. Order was obtained January 2025. Thereafter, they said right over the matter, did not disclose anything to the occupier or purchaser.
Please show me the service.
Yes. Affidavit service. All are served.
Where is the service upon the GP?
No, there is no bank and district magistrate and police commissioner.
The district magistrate will not serve upon the GP?
Well, I have not, my lord. State of West Bengal was not party. District magistrate was party. That's
Yes,
why
the
directly I filed. Directly. Other cases also, my lord, I served directly to the district magistrate and commissioner of police.
Even if you serve directly, it has to served upon the GP's office.
No,
Otherwise,
if your
nobody,
lordship, once I
because nobody is going to appear in that case. You want the other side to appear, isn't it?
Yes, ma'am.
Then
I have no objection, but this bank served.
I am appearing for the bank.
All right.
Bank served.
Yes, proceed.
My lord, if your lordship turn to page, my lord, 170.
Yes.
This is the order passed by under Section 14. My lord, type copy 170A. Next page.
Yes.
My lord, that order was obtained, my lord, on 20th January 2025 against the borrower. Description of the property, my lord. They also, my lord, file affidavit. Property is not under lessee tenancy as per affidavit, deeds, records of all others relevant. And my lord, property was described, my lord, only land schedule of the property, my lord, page 170A. All that piece or parcel of land and building. No disclosure of 31 flats over there and already sold to the different purchaser. And bank suddenly this month, 4th of this month, affixed a notice in the, my lord, complex, main gate of the complex, that you have to vacate the flat by 18 of this month. If the bank, my lord, inform us immediately after the, my lord, order passed by the my lord district magistrate, then we could have, my lord, approached the authority, my lord, under the Service Act, under Section 17, my lord, disclose, my lord, agitating my grievance that I am the purchaser of the property from the, my lord, developer borrower. By valid consideration, valid deed is there, my lord, possession is under me, my lord. But after 5 months obtaining order, suddenly 4th of this month, my lord, affix the notice. We have no time to, my lord, approach the, my lord, concern, my lord, debt recovery tribunal, while ventilating our grievance that we are the purchase of the property, 31 flats already there. The borrower, developer sold.
Why are you not going before the tribunal now?
My lord, we do not know anything.
What will you know?
If the bank disclose us the about the, my lord, mortgage or other thing, my lord, upon, my lord, searching by the state bank, we obtain loan from the state bank and purchase the property, my lord.
Yes.
My lord, my humble submission, my lord, give me some time to approach the, my lord, debt recovery tribunal, ventilating our grievance, my lord, under section, my lord, 17 of the, my lord, act. In the meantime, my lord, no, my lord, coercive step may be taken up. Nothing more. I know, my lord, the act. But possessory right is, my lord, better right than, my lord, tenant or lessee, my lord. Your lordship knows. Yeah, we are the bona fide purchaser from the, my lord, borrower.
From the borrower.
But bank did not disclose they are in my 31 flats.
Why will the bank disclose it to you? You have got no
No,
relationship with
Not
the
me,
bank.
before the district magistrate, only land with building.
Yes, it is a land with building. Then,
But the borrower, my lord,
anyway, yes, what is the stand of the bank?
I'll tell you, Lordship.
When are you taking possession?
My lord, I'll tell you, Lordship, my lord. If your Lordship takes the cost title once,
Yes.
none of them have been made parties. The principal borrower, I'll tell you, Lordship, this is the project finance. My lord, there is a company by the name of Saket Construction. They are the principal borrower. And the land, which is about a little in excess of 1 acre, was owned by a group company who had mortgaged the property and is the corporate guarantor. Now, my lord, this is a construction loan. So under the construction loan, it is land and building. So all the inventory, all the flats which are constructed are all, my lord, mortgaged along with the land. So now, my lord, there is a escrow account under the, my lord, the credit arrangement that when the flats are being sold, they have to obtain a no objection certificate from the bank, which is the developer and the owner, mainly the developer, and on the basis of the NOC given by the bank, they will sell the flats. My lord, total 155 flats have been constructed. Out of the 155 flats, 87 flats have already been sold. The money has come into the escrow account and the money has thereafter been given to us. So, my lord, out of the total exposure of which was a little in excess of 20 crores, my lord, today our dues is in excess of 8 crores. Now, my lord, the 30 flats out of the total 155 flats, I have not given NOC. So the bank or the borrower or the mortgager could not have sold it. Now it appears that the flat which my learned friend says that he has purchased, it falls or it's a part of that 30 flats. Now what has happened is the principal borrower and the guarantor has approached us for settlement. Well, the settlement did not come through. They initiated Section 17 application before the Debt Recovery Tribunal in the year 2022. Well, no application moved, interim application not moved till 2025. Now, thereafter, we approached the district magistrate under Section 14.
You approached?
Yes, the bank, for the purpose of taking possession of the remaining 30 flats, in respect of which I have not given the NOC. So I retain my security interest in respect of the 30 flats. Now, when I get the order from the district magistrate, that order is challenged by the principal borrower before the Debt Recovery Tribunal.
Oh, a second.
Yes, challenged.
Yes.
No interim order.
Right.
On the contrary, my lord, the Debt Recovery Tribunal says that till I hear the application, if subsequent steps are taken by the bank to take possession pursuant to the order of the district magistrate, put them on 14 days notice.
All right.
So, my lord, the notice that my learned friend is referring to,
Is
the
that
4th of July, is that notice.
All right.
So, I have pasted that notice. I'm going to take possession of the 30 flats.
See the case number pursuant to which that notice was
Yes, my lord. I'll
affixed.
give your lordship the order date as well, my lord. Kindly gives me a moment, my lord. Bullshit. My lord, that application
You have a copy of the order? Then please hand it over so that I can see.
Yes, my lord. I'll try and get.
DM order?
No.
No.
I'll tell you,
The
lordship.
DRT's
27th of,
order.
yes, my lord. It is in SA 335 of 2022.
No, the second one you said?
Yes, but SA is the main surface appeal.
Right.
And in connection with the appeal, they took out an interlocutory application, which is IS 722 of 2025.
All right.
And the order passed by the Debt Recovery Tribunal is 27th of May 2025.
All right.
Well, this is the order. Allow me to hand over to your lordship a copy of the order. Now, there were some other documents where lordship for that. This is the IA, the new IA. This is the order. Now, kindly take. We master data damage.
In the comment. Where from does MSME come? MSME is the promoter a MSME?
No, no. These are the unfounded allegations made by the principal borrower.
Has
Well,
also
they
taken
are now
regarding
they have
MSME.
approached us 10 times for settlement. Well, it is them. Well, if your lordship kindly has a look at that IA application I have given to your lordship, well, kindly see the IA application. It is their contention that from time to time they have obtained NOC for the purpose of sale of certain flats. So in respect of this particular flat, if he has sold, it must have the NOC from the bank. How could the flat be sold which is mortgaged with the bank? Now,
Why have you not made the owner or developer a party?
I'll tell your lordship why. I'll tell your lordship why. They haven't purchased it from the developer. Your lordship looks at the pleading. They have purchased it from a company by the name of Fraser.
Who is he?
Developer will transfer
To Fraser. So Fraser is nothing but an alter ego of the developer company.
Please come.
Same directors, same promoters.
The petitioner is aggrieved by the steps taken by the bank to proceed to recover the loan amount without putting the petitioners on notice. One petitioner on notice. Step. Learned advocate for the petitioner submits that the petitioner purchased a flat inside a complex upon payment of valuable consideration. Step. Without any notice.
Page.
Payment of valuable consideration and upon obtaining loan from the bank.
State Bank of India.
Next. Without affording any notice, comma, the bank is trying to dispossess the petitioner. Stop. Learned counsel representing the bank submits that the subject property, the subject flat is mortgaged to the bank.
Yes.
Stop. The bank is taking steps to recover the loan account in accordance with the provisions of the SURFACE Act. Stop. The developer, the promoter / developer of the subject flat has already approached the debts recovery tribunal, challenging the steps taken by the bank to recover the loan amount by filing SA 335/2022. Stop. The bank has obtained order under section 14 of the Act. Stop. Challenging the said order of the district magistrate, comma. An interim application has also been filed before the debts recovery tribunal, being IA 722/2025, and the learned tribunal was pleased to pass order on 27th May 2025 that the respondent bank will give 14 days notice before taking possession. Stop. Paragraph. In accordance with the order passed by the tribunal, comma, the notice for vacating has been affixed on the wall of the subject flat.
Correct.
Stop. Paragraph. On a perusal of the writ petition, it appears that the petitioner has not impleaded the seller of the property as party in the instant writ petition. Stop.
And the borrower guarantors also.
He'll say he doesn't know.
My lord, his conveyance says it. How it is conveyance mentioned? Yes, mentioned.
All right.
It conveys mentions who's the borrower, who's
Neither
the developer.
the borrower nor the developer / promoter has been impleaded as party respondent. Stop. There are several disputed questions of facts which cannot be entertained by the writ court. Entertained and adjudicated by the writ court. Stop. Next. The Subject issue in question appears to be pending consideration before the tribunal. Stop. It will be open for the petitioner to approach the debts recovery tribunal for relief in accordance with law, if so advised. The writ petition stands disposed of. Service is taken on record.
Some time may be given.
No, sir, they are acting in terms of the judicial order. Next.
কাগজটা দিলাম ওটা নিয়ে ওই যে যেটা দিলাম ওটা দেবে
Number 7.
Lord, matter was taken up yesterday, my lord, we could not appear and your lordship was.
My lord, yes, it has been mentioned that it has been complied with and the payment has been made.
No, my lord, kindly sees, they have made certain directions. This was an admitted amount. If your lordship takes your lordship's order, your lordship had been pleased to hold that, my lord, divide order dated. My lord,
This deduction
19th of March, my lord.
1 minute, I do not know what the matter is. Let him say.
Kindly sees 19th of March order passed by your lordship.
19th of March.
Order passed by your lordship. Paragraph 5 and paragraph 6.
Respondent company has agreed to pay 26,63,000 to the petitioner positively by yes.
My lord, and they have paid, they have made, my lord, what compliance they have done, they have deducted amounts and they have provided
Which
a
has
chart,
been deducted.
83,000 something, and
That must be the taxes,
Lord, it does
statutory
not add up.
deductions.
My lord, kindly sees point number 5, it does not add up. Tax deductions are. Lord, let me
Wait, yes.
kindly sees tax TDS is 14,000.
Where is it?
My lord, page 2, paragraph 5 of their compliance submitted before your lordship yesterday.
Yes.
Kindly sees 14,500, 856, 10,000
Yes.
and 3,000. It does not add up to 83,000. What is the rest of the amount?
Your calculation
My
is
lord,
not proper.
yes, this calculation.
First, what?
14 and
Not correct,
10.
my lord, but
14 and 10 comes to 24, 25, 26, 27, maybe 28,000. How does it
kindly see
83?
annexure R2, page number 5. There is the original deduction.
Yes.
Which calculates IGST TDS 45,045,139.
Where is that figure?
Last column.
Yes, yes, 45,000. So you have wrongly mentioned 14,000.
Yes, ma'am.
You got page 5?
My lord, I have got page 5. My lord,
Yes.
LD, which says 35,966.
Yes.
LD does not feature in this.
This may.
What is LD? This is not statutory deduction.
What's this?
I have to take instruction regarding the averments, my lord, LD and 94Q, but this is the original amount
And-
deducted.
And one more thing, kindly sees the orders paragraph 5 with regard to the interest charge. They are yet to pay any interest. That is separate.
You have got something?
Well, got something. Your lordship
Yes,
was
they were not allowed, they were not agreeable to pay anything at all.
even after admitting.
Then what can be
Well, I
done?
have got something. Kindly see the interest part. Your lordship had kept it open for
Yes.
decision.
Yes.
Lordship kindly decide that part, and with regard to this, how they are deducting this amount.
Yes. What
does
is
not add up.
what is LD?
My lord, I have to take instruction with this averment.
Call over the phone. I am keeping it. Prior to rising, please come.
Yes.
115.
Statutory interest is 24%. That your lordship kindly decide. Grateful.
Yes. 115, please come. With
115.
the instruction.
I narrate my line for the petitioner, my lord. But after going through the report filed by the district magistrate Savitri Parganas, there is some discrepancy in the report, my lord. I want to file an affidavit on that report of the district magistrate, my lord. There is some misappropriation, I may say, call, but there is. I want to file the affidavit, my lord, on this.
Please come.
Yes.
Learned advocate for the petitioner seeks time to file an exception to the report filed by the Chief Technical Officer, EKWMA.
District magistrate report.
Acha, District Magistrate. District Magistrate and Collector South 24 Parganas. Let the exception be prepared. by
1 week, my lord.
আচ্ছা তাহলে হচ্ছে by 25th released on জানাবাবু আমাদের আর একটা ওয়েটল্যান্ডস এর মামলা আছে কবে ওটা ফিক্সড আছে বলুন তো নাম মনে আছে নামও মনে নেই নম্বরও মনে নেই ডেটও মনে নেই কিছুই মনে নেই A similar matter is there. I'll place it with that matter.
Your Lordship, I'm being led by Mr. Ansarman.
Your name will be recorded. Call the next one.
Respondent number 15. 15.
কোন মামলা সেটা কি বুঝতে পেরেছেন Nine. I'm appearing on behalf of state. Respondent number 1. Yes.
My lord, this the separate counsel, his appearance is required because of lords directed to take instruction. So now, my lord, he said.
Where is he? Why did you not phone yesterday?
Like yesterday also, I tried to, my lord, taking his mobile number. I could not find out. If your lord say adjourn for 1 week, then I can directly, my lord, serve a notice to the, my lord, the authority council. Otherwise.
The matter is being taken up for consideration on regular basis. Stop. The respondent numbers 2 and 3 remains unrepresented on repeated occasions. Stop. Let a notice be served upon the learned advocate representing the respondent numbers 2 and 3, intimating that the matter will appear in the list on 24th, next Thursday.
No, my lord, I can serve the notice upon the authority council. Because of that, the learned advocate who appeared in this matter, I could not trace out his address. That's why.
Acha, tale 31st, 2 weeks.
1 week is sufficient. South Chobbish.
Then next 24th.
Next.
24 তারিখে করে দিন 24th July.
24, my lord, is the start upon the learned advocate instead of learned advocate to the respondent number.
আচ্ছা, to the respondent numbers 2 and 3 যেখানে বলেছিলাম upon the learned advocate ওটা কেটে দিন ওখানে লিখে দিন upon the respondent number 3.
Grateful.
ঠিক আছে released on 24th.
Grateful to lord.
Grateful lordship. One.
I am applying for the petitioner, my lord. May I please?
It was supposed to file a report.
Appeal service served upon all. And they have received.
Yes.
Well, kindly see my lordship's order last date as passed.
Oh.
In paragraph 3.
Circulate this inquiry report. My lord, I have got 3 reports. I have given to petitioner. So one more copy I will xerox and give it to private.
Sorry, but I will take the.
Yes, he will obtain photocopy from Mr. Jana. You do not have to give anything. Please come. Peruse the report forwarded by the Revenue Inspector.
Oh, nothing.
Jerthan. Jerthan. Jerthan and number 5 block, Igra 1. Wherefrom it appears that encroachment has been detected over government plot of land. Stop paragraph. In view of the above, the instant writ petition is disposed of by directing the assistant engineer within bracket PWD roads to take immediate steps for removal of the unauthorized encroachment, strictly in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 12 weeks from the date of communication of this order. All right, disposed.
They have moved the writ petition for demolition of my writ petition for demolition of it. Vice versa. হ্যাঁ আমি শুনে আছি মাছ রেস্টুরেন্ট
বলছি নামগুলো দিও।
I'm
Yes.
For the state, my lord. On the last occasion, my lord, we had given a report.
Did you go through the report? What does it say?
Lordship, only the first page of the report. They says that as per section 17A, they are entitled to get fees. But if your lordships kindly peruse the section 17A, that is section
Yes.
17 and onward, section 17A. Lordship, kindly tally that section 17A, whatever written in the statute and what they said in their report, Lordship.
Section 17. Really complete.
Yes. What is the material over here? Commodity? Cashew. All right.
That is admittedly agricultural product. Lordship, but only my point is that section 17. As per section 17, Lordship, I am not
Entitled to pay any marketing fee.
I am not within that ambit to provide any fees.
Notwithstanding
They
anything
are not
pertaining
entitled to get any fees.
to
Statute totally debarred them.
on the agricultural produce purchased or sold in the market area.
Purchased or sold in the market area, Lordship.
Right.
My entire business is to import and export, and only the what can I say that to hold that agricultural product for the purpose of processing. I am not engaging any business in that particular market area. Which I have already submitted before your lordships from the very beginning. The agricultural product comes from the outside of the
The
jurisdiction.
market committee shall levy fees on any vegetables purchased or sold in the market area.
If section 17 lies, then section 17 A, B, C will come.
Not considering what is the stand of the Jila Parishad? Because not the Jila Parishad, Jila Regulated Market Committee, it says that
Actually, my lord, the
he
Jela
has to.
Marketing Regulatory Committee has given this to the DM, and accordingly they have handed up, and I have given to his lordship. This is the stand they have taken with regard to
So
section
that is incorrect stand. Please come.
Section 17B.
On a perusal of the report forwarded by the Secretary, Purbo Mednipur Jila Regulated Market Committee, dated 10th July 2025, it appears that the committee is levying fees on the petitioner in terms of section 17 caps A, read with section 2 within bracket 1 within bracket small a of the West Bengal Agricultural Produce Marketing within bracket Regulation Act, 1972. Stop. Specific case of the petitioner is that the petitioner is neither purchasing nor selling the market product, market produce, no, market, no, agricultural produce, agricultural produce within the regulated market committee zone. Stuff. The petitioner merely imports cashew nut, processes it within the jurisdiction of the regulated market committee and sells it off elsewhere. Stuff. The petitioner refers to section 17 within bracket 1 of the Act, which clearly mentions that notwithstanding anything contained in any other law relating to taxation of agricultural produce in force, the market committee shall levy fees on any agricultural produce purchased or sold in the market area. Step. According to the petitioner, as neither purchasing nor selling of the agricultural produce takes place within the market area, accordingly, fees cannot be charged. Step. The stand taken by the petitioner appears to be in line with the provision of the Act. Step. The authority ought to first decide as to whether the fee will be payable or not, and thereafter charge fee. Step. In the instant case, the authority has acted mechanically and has levied fees upon the petitioner. Step. The said action of the regulated market committee appears to be illegal. Step. Any money taken? Where?
যেটা দিতেন সেটা তো এখনো দেওয়া হয়নি সাপ্লিমেন্টারি জিএস না এগুলো এখানেই না that I have not annexed, Lordship, as because from time to time it was taken by that authority, and while pendency of this writ petition, Lordships, to release the vehicle, I have already handed over. The receipt is not, Lordship, annexed with that writ petition.
But nothing has been stated in this writ petition also with regard to any levy has been paid or received or not, my lord.
কোথায় দেওয়া হয়েছে? দেওয়া হয়েছে পিটিশনে অ্যানেক্স করা ছিল।
How is the DM connected with the market committee?
No, his lordship's desire.
Otherwise, he is not connected. The market committee has a chairman and a vice chairman.
They have
chairman is that
because they have never appeared. That's what his lordship asked me. Below.
There is a functional chairman over there in the market committee. Are you aware?
But I don't know, Lordship, because the DM is holding the chair of the chairman, Lordship.
Yeah, DM is the chairman.
DM is the chairman, Lordship.
As the chairman of the market committee is directed to review the matter.
Lordship, may I placed one document.
What it shows? The chairman?
No. That is the
yes. All right. Is to review the matter and return any money collected from the petitioner on account of market fees upon inquiry as to whether the submission of the petitioner that the agricultural produce is neither purchased or sold within the jurisdiction of the regulated market committee. And if it is found that the submission of the petitioner is proper, then refund the amount paid by the petitioner. Stop. A decision shall be taken by the chairman within a period of 6 weeks from the date of communication of this order, after affording the petitioner a reasonable opportunity of hearing. The writ petition stands disposed of.
Great, Pretty. Grateful.
May I take back the book?
Yes, yes.
I appear for the petitioner, my lord. This is my writ, my lord, challenging, my lord, an order awarding me a tender holiday, my lord. My lord, this, my lord, on the previous occasion, my lord, a report was filed, my lord, showing that there was one show cause that was given to, my lord, the petitioner, my lord. My lord, may I place that show cause, my lord?
Yes.
My lord, the show cause was given, my lord, according to the respondents, my lord. It appears at page 18 of the report, my lord.
Do you intend to file an exception to the?
I have, my lord. I have. My lord, it has been filed, my lord. My lord, it's filed before the department, my lord.
Oh, it's filed in the department?
Yes, my lord.
It has not come. All right.
My lord, page 18 of the
Page 18 of the?
Of the report, my lord.
All right. Yes. Yes, please.
My lord, this is the email that states as to why such lapse in mobilization within stipulated period as per terms of contract, my lord. My lord, this was with regard to, my lord, a 2023 contract, my lord, which was awarded to the petitioner, my lord. My lord, if I may place a copy of the exception, my lord, for my lord's perusal
Yes,
right
here.
now, my lord.
What is your stand?
My lord, that despite this show cause, my lord, this was replied to, my lord, and the work was completed subsequently, my lord. My lord, they were awarded subsequent contract, my lord, which was cancelled, my lord, not due to, my lord, the fault of the petitioner, my lord, but because, my lord, there was some, my lord, lapse in the contract itself, my lord. There was a reference, my lord, to an independent external monitor, my lord, that was with regard to the term, my lord, the award of the tender, my lord, and not with regard to the termination, my lord. That has also been pleaded in the report, my lord. My lord, after that, my lord, despite that, my lord, no show cause was given, my lord, to the petitioner, and my lord, this tender holiday was given. My lord, and the reason why, my lord, the tender holiday is prejudicial to the petitioner, my lord, is because, my lord, the tender holiday also, my lord, is a prejudicial order, my lord, in the nature of a blacklisting. My lord, I can show this from the, my lord, the policy of
that impugned tender holiday order?
Yes, my lord. My lord, that would be at page 30, my lord.
জানা বাবু এই
Page
রিপোর্টটা
30 of
ফাইল
the
করেছিল ডিপার্টমেন্টে, দেখুন তো এসছে কিনা। Can you give the date of filing of the report?
Yes, ma'am.
Give the date.
It was filed on 11th of July.
11th July ফাইল হয়েছিল ডিপার্টমেন্টে।
Sorry.
এক্সেপশনটা এখানে দিন। কি দেখতে যাচ্ছেন ওখানে? এইটা চাই না আমার, ওটা চাই। দেখুন ফাইল রিপোর্টটা এসছে কিনা। Yes, page 30.
30 of the petition.
Yes.
The writ petition, my lord. My lord, this is, my lord, it states a minimum period of 36 months, my lord, in which time, my lord, the firm shall not be allowed to attach with GRSE for any new business, my lord. My lord, if I may place the policy of the GRSE, my lord, in this, my lord, at the time of, my lord, registration, page 94 of the petition, my lord.
Tell me one thing.
Yes, ma'am.
This 26th March 2025 tender holiday notice has been given to you without affording any opportunity of hearing.
Yes, my lord.
This
No.
is your case.
Yes, my lord.
All right. All right. Then.
My lord, at page 94 of the writ petition, my lord. My lord, clause R. My lord, even my lord, a tender holiday, my lord, it has a negative aspersion on the petition.
Yes, please.
My lord, our contention is, my lord, twofold. Number one, my lord, the writ petition is not maintainable because there's an alternative remedy that's provided for in the very policy that my learned friend refers to.
Yes.
I have specifically stated, and my lord, if my lord has my lord's first order that my lord passed in the writ petition, I placed the provision. May I just place that again? This is not a blacklisting. First and foremost, my lord, this is being termed as a blacklisting. It is not.
Yes.
My learned friend refers to a 2023 show cause notice that I have issued. That is the only, I must be candid, my lord, I can't improve upon my facts. That is the only show cause notice that I have issued.
23.
23. I can't improve upon that. I'll just indicate what has happened subsequent to that. 2023 is awarded a work order and he is in the business, my lord, may I just give some background? He's in the business of, my lord, providing humidifier units in defense ships. My lord, I, as GRAC, my lord, we manufacture
Tell me one
defense
thing,
ships.
why will an opportunity of hearing not be given to him prior to passing this order?
I don't stand in the way if my lord passes that direction. Only one thing, my lord, in our policy itself, it is provided that he can make a representation. My lord will kindly consider that once, my lord. My lord, page 83 first, my lord will kindly take once as to the effect of this tender holiday. This is not a blacklisting. It does not affect his
It
business.
is a debarment order for a period of 3 years.
It is a debar. May I just indicate, my lord, this is only restricted. May I place that line of my policy itself? It only says that GRAC will not contract with him. No other PSU. It's clarified. May I just place that one line?
Why will GRAC not contract with him?
My lord, because he's subsequently his purchase orders have been cancelled on repeated occasions due to failures on his part.
Very
Subsequent to
Here
one
you can
second.
pass this order.
I don't stand in the way. Only one thing. I'm sorry, my lord. Page 85, my lord will kindly consider clause 6.14.
Yes.
This is my only clause by which 85 clause 6.14. This
Yes,
is a
please.
review of the restriction of business.
All
It is open to GRAC. As soon as he makes a representation, we will grant him an opportunity of hearing because he's not made a representation per se, my lord, against the blacklisting. He can make a representation. We will dispose it off. My lord can fix a time frame. I do not stand in.
If, my lord, one more thing, my lord, this blacklisting, my lord, the order itself, my lord, sorry, the tender holiday, the order of tender holiday, my lord, it does not it goes beyond the purview of the policy, my lord, because, my lord, it states, categorically states it is a minimum period of 36 months. My lord, the policy itself has a maximum punishment of 36 months.
So 36
My lord, that
months have
goes
been
beyond the
All right.
policy itself.
The petitioner is aggrieved by the notice of tender holiday
Reply.
and suspension of business dated 26th March 2025, issued by Garden Reach Shipbuilders and Engineers Limited. Stuff. The by the impugned notice, the Garden Reach, short form GRSE, has restricted business activity with the petitioner for a minimum period of 36 months. Stop. The aforesaid notice has been issued without affording any prior opportunity of hearing to the petitioner. Stop. Violation of the principle of natural justice has been pleaded. Stop. It has been pleaded that the maximum period for imposing penalty is 36 months. Stop. The authority has imposed the highest period as the minimum period of suspension. Stop. Next. The petitioner further contends that the tender holiday and suspension is beyond the policy of the authority. Stop. Next. Prayer has been made to set aside the impugned notice. Paragraph. Learned advocate representing the authority opposes the prayer of the petitioner. Stop. It has been submitted that there is a provision for submitting representation seeking review of the order of restriction of business. Stop. The petitioner has not applied for review of the said order. Stop. It has further been contended that a show cause notice was issued to the petitioner in 2023. in 2023.
One more submission only, my lord. Post 2023, we have issued show causes in respect of other purchase orders, not in respect of blacklisting or tender holiday per se. That's also on record. My lord, we kindly have a note, page 26, it is there, subsequent to 2023 as well, for his latches. Just, my lord, will record my submission.
Several notices were given to the petitioner, highlighting his latches. Stop paragraph. I have heard the submission made on behalf of both the parties and have perused the documents placed before this court. Stop. It appears that the impugned notice is styled as a tender holiday and suspension of business. It has single quote se diye deben. Styled as tender holiday and suspension of business for a minimum period of 36 months. Stop. The same amounts to banning the petitioner from performing any business with GRSE for a minimum period of 36 months. Stop. The subject ban has civil implications. Stop. Not granting an opportunity of hearing prior to passing the prior to issuing the impugned notice amounts to violation of the principle of natural justice. Stop. The petitioner ought to have been granted an opportunity of hearing prior to passing any order suspending business or putting the petitioner on a tender holiday. Step. Next. In view of the above, the impugned notice is liable to be set aside and is accordingly set aside. Step. The petitioner is granted leave to apply for review of the subject notice. Now, review of the restriction of business in terms of the, what is it?
6.14 formula of the
in
vendor
terms
policy.
of the policy, in terms of the vendor policy. No, no, likhun GRE policy on vendor development. GRSE policy on vendor development. ठीक है? The concerned authority of the GRSE shall consider the same in accordance with the relevant rules / guidelines / policy and afford an opportunity of hearing to the petitioner and thereafter proceed to dispose of the same.
And all points kept open. If one obligation.
All points are left open to the authority.
Obligation.
No, not authority, to all the parties to be taken at the time of consideration of the review application to be filed by the petitioner.
My lord, would it be my lord's pleasure to keep a
Yes,
time
my
period
lord,
for-
that's my prayer as well, my lord.
How soon will you file?
My lord,
How soon you will file?
My lord, I shall file within the week, my lord. If
All right.
My lord will grant us 4 weeks to dispose of the matter, my lord. Only
The
4 weeks.
authority shall dispose of the application made by the petitioner at the earliest, but positively within a period of 4 weeks from the date of filing the same.
grateful.
Obligation.
My lord, the affidavit of service, my lord, has been made for abundant caution to the exception also, my
Very
lord.
well. You take back this.
Yes, my lord.
That's a photocopy of the, no, not photocopy. The exception of the petitioner to the report filed by the respondents have been filed in the department on such and such date. Let the same be tagged with the records. Affidavit of service is taken on record. It
Deeply obliged.
Thank you.
My lord, I appear for the private respondent.
Yes.
Yes, my lord, I beg to appear on behalf of the petition.
Animesh and Mihir both stand on the same footing or they are different?
No, no, my lord. Animesh,
Don't stand. They want same.
Oh no, not Mihir. It is Shorkar and Animesh.
Yeah, prayer is almost same.
Achha. Yes.
Now, my lord, may I submit one thing? My lord, the dispute in question is, my lord, installation of petrol pump. First, my lord, if your lordship kindly sees that the report filed by the IOCL, I shall rely upon the. Madam, may I tender my report?
Oh, give.
That is in respect of Sarkar fuel 11363.
And did the National Highway Authority also file a report?
Both filed their report and exception by the writ petitioner.
Already I have filed. My lord, if your lordship kindly come to straightway page 75. Page. No. Okay. Yes. My lord, if your lordship kindly come to page 12 once. This is the brochure published by the oil companies. Why should I say? Because, my lord, HP, Bharat Petroleum,
Yes,
and
all,
Indian Oil.
everybody.
Now, my lord, here identification of locations. My lord has got it. May I read, my lord? Locations for setting up or retail outlets are identified by the respective oil company based on commercial minimum volume consideration. Accordingly, regular and rural outlets are set up by oil marketing companies as under regular RO, that is regular outlet. Location on the highway, national highway, state highways, and urban semi-urban areas within the municipal limits of a town. Well, here, regular outlet, subject to my understanding, regular outlet will be location on highway, that will be national highway, state highway, and urban or semi-urban areas within the municipal limits of a town. That will be treated as regular. Now, rural. Location in rural areas, but not on highways and outside municipal limits of a town. That is the interpretation of the brochure. Now, my lord, if your lordship kindly sees the NHAI authority, what they say. When it comes, because in this case, the private respondent have been granted a license indicating that is a regular retail outlet, as it is in front of the national highway. Now the Ministry of Roadways, what they say, our repetition. Sarkar fuel millet. Yes, I am giving. The brochure says, kindly come to page 28.
Brochure, same brochure?
No, Milord, it is on page 28 of the writ petition. Milord, that is Milord Sarkar fuel. That is the guideline of the Ministry of Roadways, Transport and Roadways.
Yes, page 20.
Milord has 1.2. When the cross slope of the country more than 25% and so and so hilly area, where national highway passes through a town of population town. I am giving the emphasis on this particular part, town of a population 20,000 and more census, so and so the stretch shall be categorized as urban stretches. Now, Milord, rural, they say 2.2, clause 6. Rural, Milord, below 20,000 will be treated as a rural. Milord, clause 6, undivided carriageway 300 meter, divided carriageway 1000 meter. But that means, Milord, in a same site, if there is undivided, then 300 meter. If there is, Milord, divided carriageway, that means they are same site. For such reason, he has to maintain the distance 1000 meter, or he has to prepare a service road connecting towards the national highway, maintaining 1000 meter distance. Well, kindly see, the interpretation is there. However, the restriction shall not apply in case access, egress for all such fuel stations are provided through common service road of 7 width and not directly to the NH. Further access of fuel stations at closer proximity than above, distance may be allowed provided entry and exit of the both of the fuel stations are provided to service road 7 meter width having sufficient length. Further additional length of such service road shall be constructed at the cost of the latter fuel station owner company so and so so and so. Now, my humble submission before your lordship, that when this particular station, fuel station, has been allotted on the national highway, then, my lord, the guidelines of the national highway has to be considered first, because they are the appropriate authority who will provide the no objection certificate. For such reason, NHAI issued a memorandum that has been annexed by the NHAI authority. They have used the affidavit. I am relying upon them that NHAI report দেখো একটা ইয়ে দিয়েছে আচ্ছা পেজ আছে জানতে চাইলাম এখানে কোথায় যেন ক্লারিফিকেশন পাইছি yes Lord, annexure J, page 21. Bottom last three lines. Last three lines. Lord. This is the divisional address to the divisional retail head to the IOCL. Now, Lord, what they say. It is suggested to submit a proposal amendment with provision of service road on RHS NH2 from the existing retail outlet, Mrs. HPCL. Lord, that is my case. At 360.482 kilometer 361.145 as per ministry's guidelines so that no dispute or any allegations are faced in future. But if the private respondent constructs the same, I do not have any objection. He has to construct the same because it is adjacent to my plot, 568 meter distance in between. My
same side.
Same side. Now it has to. Now if it is in same side, then service road has to be prepared so that 1 kilometer stretch, 1,000 meter stretch at least be maintained. But if it is done by the private respondent, I do not have any objection. Because I cannot have any objection because the NHAI authority, they have issued this memo. In response to that, the IOCL, what they did, if your lordship kindly sees, last 75. They have they made the response in another manner. Beta, IOC letter কোথায়? দাও IOC letter দাও IOC letter যেখানে ওরা বললো এটা just I'm giving just because they have indicated that it is at urban area and I'm just giving কোথায় গেল ছিল তো 20,000 লোকের উপরে বললো ওরা আমি এখান থেকে দুটো আছে yes page 75 of the IOCL if your lordship can see
page 75
of the report of the IOC.
75, yes.
Manoj has got it?
Yes.
Yes. Milord, when the clarification has been sought, then they, Milord, at the bottom, since the population strength
is more than 20,000, that is urban.
Can be categorized as urban stretch.
Yes, hence he is requested to.
Now, Milord, if it is treated as
expedite the process of obtaining tree felling approval and to grant further permission for construction of approaches of the proposed retail outlet. But this 1,000 meter is not there in the initial one that you read, the page 28.
It is not there.
Page 20?
Yes.
Page 28 of the writ petition, Milord.
Yes.
Yes.
It's only if it falls under rural, there is a requirement, not otherwise. And
no, 1,000 meter divided carriageway. 1,000 meter.
Yes, it falls under the rural stretches of the national highway. You do not fall within the rural one.
Now I am submitting before that is the Milord. They are trying to settle the issue.
All right.
Now, if your lordship kindly sees.
Only one interruption. One second. No. Nothing merit. Who is he? I'm saying.
Yes.
Lordship was referring. He never participated.
He already has an existing.
He already has a petrol pump. Only that.
I'm running.
He's an existing pump holder over there.
I am agreed.
Right.
Only that.
Yes.
Now, Milord, if your lordship kindly sees. According to the definition of urban, as defined in the company's brochure, that is IOCL, HPCL, whatever it may be, then it has to be within the municipal limit. But if your lordship sees once again the brochure published by the IOC.
Why? This is within which limit? Panchayat?
This is Panchayat. Now the issue remains the total stretch when they have made the advertisement that I have annexed in my exception, that Gajol to Moina, in between Gajol to Moina, totally it comes within the highway, national highway, 11 kilometer stretch. Now the Panchayat area having 44 square kilometer radius. But assuming for a moment that if a person travels 10 to 11 kilometers to avail is put the fuel in his vehicle, is it a possible thing? And now the NHAI authority duly established thing that I have annexed in my exception, if your lordship kindly sees, that Moina, the Mouja, Bade Moina onwards, 5 Moujas are there. 90% is the Shali land. 10%, only 6 to 8,000 people are there. For such reason, NHAI authority duly constructed a particular bus stand for that. Moina bus stand. I have given, I have annexed the same page 12. For such reason, NHAI authority duly indicated, issued the memorandum. Please clarify it. According to them, this is rural area, NHAI. I have to rely upon the NHAI authority because when it is coming within the purview of the NHAI authority, according to them, it is coming within the urban authority. It cannot be. But urban definition says it has to be within the municipal area. And Gajol block, they are saying that entire Gajol block, it is 23 kilometers away from the Bade Moina and the Moina bus stand. Google says, I am not saying.
All right.
Now, I have categorically indicated that according to them, IOCL, they have given the entire sheet. That is at page.
What is
page
the
73.
way out? What
Now,
is the solution?
Solution is, Milord, the distance has to be 1,000 meters. I do not have any objection. Suppose it situates within 2 meters from my plot. But I have brought the plot entire Moja map. It appears it is the distance between 2 petrol pump is 568 meters. Now, Milord, if he constructs a service road, I do not have any objection because the way in and way out, it has to be independent one. Then automatically there will be a distance of 1,000 meters. For such reason, NHAI authority has given the proposal. You have to prepare the 1,000 meter distance. Now, lastly, Milord, the IOCL, why Milord using this affidavit, Milord, they didn't disclose one memo. That is, Milord, I have indicated. That memo I have clarified. Let them produce this memo. They have admitted, IOCL. That is that I have indicated in, yes, Milord, page 4 in my exception, III.
Yes.
Oh, 3.
Yes.
III. Roman 3. It is very much relevant to mention in this context that this deponent has come to know from the reliable source that a memo being reference number so-and-so, dated so-and-so, issued by the Divisional Retail Sale of Indian Oil Corporation Limited, addressed to the private respondent herein, Milord, it has been indicated that it is suggested to submit the proposal amendment with provision of service road on RHS on NH12 from existing retail outlet of Mrs. HPCL at 3 so-and-so as per the ministry's guideline, so that no dispute or any allegation are faced in future questioning the NUC to be granted to your case. Well, that is the memo that they have not annexed. I have that memo. I can show that this memo is there, issued by the IOCL. If your lordship saves me, I shall produce the memo. I have that.
Very well.
My lord, may I just say very fundamental thing. The advertisement was in November 18. The advertisement clarified what is rural and what is non-rural from 2 documents. My learned friend has shown your lordships one document. Kindly see that along with the other. Then only the picture would be clear. He has shown page 12. Kindly have a look 12 first.
Page 12.
This, it is there in the IOCL report.
Yes.
There are two categories. Category number one is regular RO. RO is
retail outlet.
Retail outlet. Now, regular RO locations on highways, that is my case, national highways / state highways, etc. Now, my learned friend wants it to be read, and it has to fall under urban, semi-urban area within the municipal limits. The moment Lordship looks at page, same advertise thereafter, page exception page 6. Kindly. This is the this is the exception
and there is
by the writ petitioner that he has annexed. In the advertisement, what was regular? Lordship may kindly see.
Yes.
It was at serial number 538. It was not a rural, it was a regular. Sorry. Serial number
No,
538.
he says it is regular.
Now it is regular. Now, if it is regular, then it comes page 28 of the writ petition.
Yes.
There are also two categories. Now, kindly take Mallet 1.2. When the page 28 of the writ petition.
Yes.
This is Mallet. When the cross slope of the country is more than 25%, the terrain shall be classified as hilly. Now, this is not relevant, but this is an indication that to be called a place to be hilly, it is not required to be Darjeeling, if I say metaphorically. Only a certain percentage that will do. Similarly, where national highways passes through a town, well, a town here, it means area. In the Black's Law Dictionary, I have copy also. A town doesn't mean as we understand as a town. Town of population of 20,000 and more in census 2011, the stretch shall be categorized as urban stretches. Now, kindly have a look at what IOCL sought for prior to giving me LOI. That is report of the IOCL, page number 59. It is for everyone else in the similar manner they ask it. It is not that the first time they are giving it to me. For everyone else, same thing. So therefore, the same common letter of the IOCL, kindly come to page number 59 of the IOCL, two queries from the concerned Gram Panchayat. Query number 1 was whether the proposed location is under the jurisdiction of the Alal Gram Panchayat, and number 2, population of the Alal Gram Panchayat as per 2011 census. The answer was given by them. Kindly see next page. 34,244. Therefore, it also comes under the urban. So it is a regular, not rural. It also comes under urban. And thereafter, my lord, this LOI was granted to me at page 53.
I just want to know
Yes.
that he is already operating over there for quite some time.
Yes.
You are the new entrant.
Yes.
If both the petrol pumps falls within such close proximity,
Yes.
it will cause damage to business, loss of business to both, not only to him, but to you also, because there is someone else by your side.
Yes.
There is a provision for a service road of...
But that provision is there even if there can be even side by side one.
Right.
Service road was in a situations, may I just clarify that? When one Animesh his associate filed a writ petition and he sought an RTI. Once that complaint and RTI was given, then a proposal was given. Let us not enter into any dispute, but no matter what happens, if a service road there, anybody, anytime, no distance, no difficulty.
Right.
But then I have to bear entire expenses for that.
Exactly.
Which is run to crores. Because I have already invested more than 2 crores after getting the LOI. My entire setup is ready. I can understand.
Now you, with your setup, if you are not able to generate so much of revenue, will it be financially beneficial for you?
For generation purpose, Lordship may kindly consider this. Today there is a restaurant, there would be another restaurant. Now, what Lordship
stop competition.
What Lordship is saying is perfectly right from the perception of us. Now, there is a perception of us versus there is a constant constitutional provisions being interpreted and judgment being delivered. May I just show exactly there the Honorable, if I can just say and thereafter show, there the Honorable Supreme Court has categorically found on the point of that Lordship is like any person would say in that way. That can never be a point. Like I'll take that today there are large number of interns they come, large number of lawyers they come. Now, what is the Article 19(1)(g) cannot be pressed into service to somehow change the free flowing of whoever wants to come, because that's the very acceptance. The Constitution does not provide that because somebody was there for some more time, there has to be some extra kind of change in existing laws. I do understand that maybe, let us say, he was getting the 100% of the carts and for fuels. That was his business. If a new business comes there, definitely the logical corollary would be, let us say, because he's the old one, he might be getting, let us say, 80%, or it could be 50-50. And thereafter, what will come is the quality, competitions, and others. In that light, if Lordship may kindly have a look at this judgment, there the Honorable Supreme Court,
I'll come to the judgment later.
And what my learned friend was relying on is this, that he was able to get hold of a document giving the population of a particular Mouja.
No, that he has not submitted today.
Now, today his submission is the alternative arrangement, what the IOCL or the NHI they are saying. That they said because of the pendency of the writ petitions and their complaint made under RTI. So all I'm putting this question to myself, well, forgetting that I'm appearing for this writ petitioner. All I'm saying is this, as a point of I'm running a business, can anyone say that there has to be modulations of a change in the existing which is pan-India is available? There are
let us see whether it is pan-India available or not, because the National Highway Authority has raised objection.
They have exactly not raised objections.
Yes.
What has
a suggestion has come.
What has happened? There was an RTI on the basis of, and there was a complaint by the other writ petitioners. Now, on that basis, it was like this. There is a complete no difficulty zone where if you make a service road, no matter writ petition is pending, no matter anything is there, so no distance is required, you can do that. That's a choice. Other is that I have to satisfy your Lordship that from the day one of the advertisement, I fall under regular, not rural. The entire process that happened, keeping in mind that clause 1.2 exceeding 20,000. Thereafter, whether a business rivalry, if I can say, whether he has the word, it's not my word, my lord, because I know Lordship's liberal view, that's not mine, but I'm referring the word of the Honorable Supreme Court. The Honorable Supreme Court is indicating that you don't have a locus to say that your business would be affected.
Yes, this is a very old, accepted proposition that you cannot stop competition.
And what I'm trying to say, my lord, it is the competition is the core of better development.
Absolutely, there is
it
no
is the
issue
core
with
of,
that.
now apparently there is the heart, there is a little bit of bleeding apparently, but from the holistic point of view, I don't think he has to grow, he has to have a better quality, he has
that is all, that is for him, whatever he
now
wants
as
to
far
do
as
or
the
not do.
NHAI and IOC both are concerned, and that I am required to, I take it that their Lordship would clearly see 3 documents. The document number 1 was advertisement at page number 12.
Yes.
Of the IOCL's report.
That is the document number 1.
Identification.
Yes. And that page number 12, that clearly it's being on the national highways. Lordship may kindly see, read also the Roman 2. Rural, there is an exclusion, that location in rural areas, but not on national highways. So therefore, whatever the paraphernalia, whatever the ABCD which are required, what my learned friends is really want to bank on, those are not there for the, if I fall under 1. And serial number 538 at page number 7 of writ petition as exception. Lordship may clearly see that falls under regular.
I have indicated that.
Now, once I fall under regular,
This is a national highway.
yes,
Exactly. On the national
on the
highway.
national highway. Say, what I try to say this, once I fall under regular, then those paraphernalias, those are absolutely non-requirement. And that can also be found from the fundamental facts of what the IOCL sought for. But tomorrow, if NHAI or the IOCL, they say that you have to comply with X for Y reason, I will comply, no difficulty. But for somebody who is running,
let me hear the NHAI.
May I just show, because this sentence is very good. I just thought, I know it's a very consistent. First is, this is 1971 SCC 575. There, paragraph 9. This Nagar rice, which has been consistently.
That is not applicable for.
Yes.
This is the possibly the first one on this point. Paragraph 9, Lordship may kindly see. Section 83C is merely regulatory if it is not complied with the applicants may sorry.
Yes, continue.
Be exposed to a penalty, but a competitor in the business cannot seek to prevent the appellants from exercising their right to carry on business because of the default, nor can the rice mill of the appellants be regarded as a new rice mill. Thereafter, my important competition in the trade or business may be subject to such restrictions as are permissible and are imposed by the state by a law enacted in the interest of the general public under Article 19(6). But a person cannot claim independently of such restrictions that another person shall not carry on business or trade so as to affect his trade or business adversely. Thereafter, Lordship may kindly have a look that 1992 1 SCC 168 in Mithilesh Gorg, paragraph 7. 92 1 SCC 168.
Yes.
Well, practically this Nagar rice flour mills, this case that has been echoed. There in paragraph 7, if Lordship kindly skip the first portion, and this is placitum just below placitum D. From right hand side, it will eliminate healthy competitions in this business, which is so essential to raise commercial morality. It will tend to perpetuate the appellant's monopoly of, that was regarding cinema business in the town, and above all, it will in effect seriously injure the fundamental rights of respondent number 1 and 2, which they have under Article 19(1)(g) of the Constitution to carry on trade or business subject to reasonable restrictions imposed by law. But thereafter, the instant case falls well nigh within the ratio of courts, the earlier case, wherein it was held that a rice mill owner has no locus standi to challenge under Article 226 the setting up of a new rice mill by another, even if such setting up be in contravention of Section 83C of the Rice Mills Industry Regulation 58, because no right vested in such an applicant is infringed. And recently there is not recently, sorry, there was even a previous judgment of 1951 SCC 1024. Only one paragraph. 1951 SCC 1024. Paragraph 13. This is in the context that paragraph 13, the language of the article shows that the issuing of writs or directions by the court is founded only on its decision that a right of an aggrieved party under part 3 of the Constitution's fundamental rights has been infringed. It can also issue writs or give similar directions for any other purpose. The concluding words of Article 226 have to be read in the context of what precedes the same. Therefore, the existence of the rights is the foundation of the exercise of jurisdictions of the court under this article. The judgment of the Orissa High Court under appeal, however, shows that the judges have decided nothing at all in respect of the rights of the parties. Rest is not required. In fact, in one of the matters which was upheld by the Honorable Division Bench, your Lordship's matter, where one of the points was relating to tender, somebody not being a participant in the tender process, and therefore he doesn't have a locus, because there are other zones of public interest litigation. So when you don't have a locus, you feel something else. Their Lordships delivered a judgment that is WPA 222 of 25. It's an unreported one. But it went before the Honorable Division Bench, and Honorable Division Bench upheld it. In paragraph 6, Lordship had noted it.
Yes.
Paragraph 6. The private respondents oppose the submissions made by the petitioners. It has been submitted that as the petitioner did not participate, like the similar case, in the tender process, accordingly, they ought not to be permitted to challenge the terms. Thereafter, Lordship also relied on another previous division bench of our court. Matter went before the Honorable Division Bench. It is also unreported. And in paragraph 14, your Lordship's judgment was upheld. This is just to paragraph 14 to show that it is upheld. My
But then he is not challenging the terms and conditions of the tender.
Right. All I'm saying is this. Lordship may kindly look at this. Either I fall under regular or I fall under rural. Now, if I fall under regular, assuming that NHI is saying something, IOCL saying something, I have to comply with. That's a separate chapter altogether. He began his submissions and he got the interim order on the basis of showing a certificate
Given
of
by
a
the
Moja
Panchayat.
populations.
Moja, yes.
So therefore, all along, the IOCL never seeks from anybody. The Moja, they ask from the Gram Panchayat, what's the populations? The advertisement, I could have understood that from the day one, I fall under rural. What he's trying to say, he's trying to take a middle path in a sense that, and my LOI was given in 21. All investment, everything is there. Now, because of his complaint and successive 2 writ petitions, 1 writ petitions, there he was not even made me as one of the parties. Other what was filed before your Lordships, there was a suppressions. I indicated, then Lordships tapped both the writ petitions. And both writ petitions, in another person, he doesn't have any locus also. He also doesn't have any petrol pump.
All right. Let me hear the...
My Lord, in this matter, my if your Lordship kindly allow me to place my report, my Lord.
Yes.
My Lord,
yes.
Page 6 of my report, my Lord, para 15. My Lord, before my Lord, if your Lordship kindly come to page 5 first, my Lord.
All right.
Para 14.
Yes.
My Lord, that may I read, my Lord.
Now, what you want to show from here?
My Lord, from Lordship,
it falls within the urban area?
My Lord, as per this Lordship, this report, Lordship, no.
It falls within the rural area?
Lordship. Because Lordship, that's why, Lordship, we ask them to resubmit the population.
That is their understanding. Sorry.
My Lord, that is, Lordship, we ask them to resubmit the proposal in the light of the Morth letter, my Lord. Lordship, we are bound by to follow the Morth circular.
Exactly. Yes.
My Lord, as per the circular, my Lord, I ask them, Lordship, to kindly to resubmit the proposal. So, after
ask them means whom?
To the IOCL.
All right.
My Lord, till Lordship, that proposal, Lordship, I'm waiting for their proposal. Lord, do resubmit this proposal. My Lord, that is, Lordship, page 6.
How do you come to the conclusion that it falls within the rural belt?
My Lord, that is our Morth guideline, Lordship, that is the circular.
Please show.
That I have placed.
Lordship, that my learned already.
I have in the writ petition. I have That is
page
the guideline of the Ministry
That
of
is the guidelines of the ministry, my lord.
Yes, yes, but where does it say so? If the population is more than 34,000, it has been placed.
That is in respect of আমি দিচ্ছি।
Where is it?
Yes, my lord,
Where
that
it
is at
falls
page 28.
Page 28.
28.
Yes. My lord, page 28, my lord, location of norms on rural sketches of national highways. When the national highway passes through a rural area,
It is not a rural area.
absolutely it is a rural area. May I submit, my lord?
No, you've
I
submitted.
will-
I'll
I will-
hear
That is
the.
also already annexed in my annexure C, my lord, page 28, page 10 of my report, my lord.
Yes, page 10.
My lord, page 10, my lord, of my report.
Yes.
That is the same document.
That is the same document. My lord, we are also relying upon, my lord.
It's the same
Yes,
document.
thing is, how are you coming to the conclusion that it falls within a rural area? The population is more than 34,000 or some more than 20,000.
My lord, as per the guidelines, if the national highway passes through a town, which is lordship that I indicating,
দেখাচ্ছি না ঠিক আছে আমি গাই বল আমি রিপ্লাই দেব।
Yes.
My lord, here, my lord, the later, my lord, the 10th June letter, my lord, though that letter has not been annexed, my lord, that 10th June letter, my lord, in that letter, my lord, we resubmit the proposal in the light of the moth letter, my lord. That letter is 10th June 2024, my lord. That letter.
No,
is
no.
not-
Why do you want resubmission? You have to clarify that. Why do you want resubmission? The population level is more than 20,000. Where from are you coming to the conclusion that it is a rural area?
In that case, my lord, that
And they-
letter is, my lord,
they
most
granted
important, my
NOC
lord. Well,
all they granted
What will
previously.
that letter do?
well, that letter, lordship, entirely mentioned the entire things regarding this ministry's guidelines and circular. That is 10th June 2024. Well, that letter is not been annexed here, my lord. That is, my lord, the difficulties. On the basis of that, my lord, we ask them to resubmit the proposal.
That is your trump card and you've not annexed it.
My lord, that is
What
my lord,
is
that-
this?
Lordship, that is the difficulties, lordship.
What
that-
difficulty?
That later, lordship, we are
আছে আমারটা দেখুন 69
Is it there?
24 তো
10th June 2024.
হ্যাঁ they are in 69 মানে
Yes.
my report page
Your
69
report will show. Page 69.
10th June.
my
10 June 2024 হ্যাঁ
আমার report
Yes, 10 June 24.
You will see it's entirely interpretation, nothing else. Because this
Let me-
NHAI already
Yes.
granted approval earlier.
Show me.
Now everything is at the instance of
2024 হচ্ছে এইটা অয়েল কোম্পানির এটা।
My lord, that has been, lordship, the clarification, my lord, the distance now mentioned in the ministry guidelines are considered keeping in view road safety at the paramount importance, and it is clarified that the stipulations mentioned in serial number 5 of ministry's guidelines are equally applicable to other properties as well. And all the documents mentioned in the guidelines are also required to be submitted by the applicants. As per para 2.1 of the appendix, the stretch can be categorized as urban stretch when the population of the town is more than 20,000.
Yes, so it's an urban stretch.
For which the certificate from the concerned urban local body authority shall be obtained, specifying that the proposed fuel station is falling in the urban municipal limit. It is
urban stroke municipal
My lord.
limit.
No, no, it's all right.
In
But
this
then
case, my lord, lordship, kindly allow me, lordship, here. In my report, my lord, page 16, my lord, here it is observed that the BDO Gazoli, if deemed to be concerned urban local body oblique authority, has not specified that the proposed fuel station is falling in the urban/municipal limit. Only population of the Gram Panchayat in which the proposed fuel station is located has been certified by the BDO Gazelle, which is not as per the MORTH guideline, my lord. That's why, my lord, we asked them to resubmit the proposal.
no, 1 minute. Where did you read?
My lord, page 60, page 6, para 16 of my report.
Page 6, para 16 of your
my
report. Yes, what have you stated?
they want one word by the BDO that he has to write urban. He cannot.
No, my lord,
It is over 1 minute. Observe the video. If deemed to be considered such and such, has not specified. You want the BDO to specify.
He has done page 73. He has
that
done
the
it.
proposed fuel station is falling with such and such. There is already on
My
record
lord,
that it is
on the
above
basis of-
34.
My lord, that is on the basis of this letter, my lord, 10th June 2024. My lord, we asked them to resubmit the proposal. Lordship, if they submit the proposal, my lord, we will do the according to this norms, Ministry of Guidelines, my lord.
But a video submitted.
Why is the resubmission required?
My lord, the resubmission required, my lord, that is circular has been changed in some way, Lordship, because
When was the change made?
my lord, Lordship, the circular.
The letter of intent was given long back. The advertisement was published long back.
My lord, it is, my lord, what the clarification has been made, it is submitted that the IOCL was by the letter dated, my lord, that is the populated strength was more than 20,000.
That is a categorical submission from the authority which says it is 34,000.
My lord.
Then it is more than 20, so it is urban.
My lord, that is the lordship that requires lordship from the BDO, my lord.
That is there, even from the video that is there. Kindly see page 73 of the IOCL report. Video has given page 73. It is the long arm of.
Yes, video has given
73. And that too, kindly see the date.
See, 11th February 25 was the communication, and video has given on 5th of February 2025. So it is already there.
Now they are showing the repetitions. They want it to be stalled. That's the thing.
Lordship, initially, lordship, we accepted their proposal and obtained this permission. Once, lordship, we received a complaint from the petitioner.
Only because of a complaint.
Lordship, asked them to resubmit the proposal.
Why? Why this? Somebody will make a complaint and you'll go on directing for resubmission. Why? You have got an independent mind. You are a independent autonomous body. Why will you not consider it on the documents which are already on record?
Populations in all these parts, lordship, it is not in our hand, my lord. We are depending on them, my lord.
Yeah, the document is there before you.
My lord, because of this writ petition, my lord, that's why, my lord, that is page.
Listen, I followed it. Yes.
My kindly says there are a lot of documents which I have annexed in the report, starting from the initial stage. The letter of intent, there was a selection, there was an advertisement based on.
No, it's all right. The petitioner here is not a contender. He is an objector.
Right.
Right. Now
Not
you
even
have
objector. He never made any objection. There is
All
zero
right.
objection. No representation.
He is relying on an objection filed by the
Nothing.
other writ petitioner.
This
Only
is
was
a
going.
petition showing before the authorities.
All right. Now, whatever, I take this as an objection.
yes.
But then you tell me whether.
This is the what IOCL did.
Yes.
IOCL after the selection, IOCL issued the letter of intent on 19th of June 2021, which is at page 53. After this, because Losses knows there is a as per the Petroleum Act and the rules, there are a lot of things to be done after an appointment is made. There, the main authority is the explosive department, that is the Commissioner of Explosives, PESO, who has to grant under the Petroleum Act. He has the appropriate authority to grant the license for the storage as well as for the selling of the pump, the petroleum products. Based on that initial approval of PESO, the constructions will be made. After the construction is made, then they will make another inspection for granting the final PESO license. After PESO license is granted, then
according to you, it falls within the urban area. There is no requirement of maintaining a 1,000-meter gap between the two petrol pumps.
Right, because that is why when we initially approached the NHAI, because the pump has to access the NHAI,
Right.
and unless there is no objection
Access
granted, access permission granted by the NHAI, nobody can access NHAI. That's why initially an application was made for an direct access to NHAI, direct access from the pump to the and that was granted. Now, when there was a complaint made saying that this does not come within urban or rural as per the NHAI guidelines, that's why NHAI immediately after receiving that complaint sought for a clarification from Indian Oil Corporation.
Right.
Now, based on that, Indian Oil has
Clarified.
already clarified.
And by giving this videos document
Right.
that it is 20,000.
Had already clarified, because we are also not the authority to find out what is the exact population. We have to depend on the local authorities. And accordingly, we have approached the local authorities for clarification. We got the clarification. Accordingly, we have submitted that clarification before the NHAI. My learned friend for the repetition has relied on that particular documents, the clarification that we have given. We have specifically said that our clarification, because they have asked whether this guideline which has been annexed at page 28 of the repetition, whether that guideline is at all applicable so far as this particular location is concerned. That is the only issue to be decided. Now, when that question was raised, and accordingly NHAI also raised sought for a clarification from us,
Then
whether
what did you do?
this guideline will be applicable for this particular location or not.
Right.
We depend on the appropriate local body.
No, that you've got it.
And we gave that clarification. Now, after we gave that clarification, so
as on now, there is no restraint order from any competent forum restraining you to permit the private respondent to proceed with the work. There is
no direction. The only direction.
Order of your lordship, there is
only.
No, that is by this code. From that, nothing.
There is one direction from NHAI, because when the clarification was sought, NHAI said that after that NHAI said that till the time the clarification is made, you submit your proposal, a reproposal for providing an access service road instead of a direct access to NHAI. You submit a proposal. What was the proposal to be submitted, which my learned friend is relying? The proposal which they asked to submit is whether we are ready and willing to provide a service road or not, to construct a service road or not. Till the time we provide that clarification, the construction of the service road had been stalled, not the retail outlet. Retail outlet has been constructed long back. PESO has granted license also.
Now, suppose a service road is to be constructed, then who will be responsible for constructing it, and on whose land will it be constructed?
The service road, if a service road is required to be constructed, then it will be on the dealer. Because this is the dealer's, this is B side. Because there are two kind of sites.
So
one is
this will
A
be
side,
dealer
which
side,
belongs to the
and the land will be of the
land has to be provided by the dealer.
Everything I have to arrange, so I may not be able to.
NHAI
I may not
adjacent to
be
the NHAI, that means
Had I been
NHAI
in
will
rural,
provide.
I had to.
How it can
That's
be?
the reason. Had I been in rural, I had to.
Because
That
that's
that
why
is
we
the
also
catch.
provided our
That is the catch.
clarification saying that as per the local body, this ministry's guideline so far as this particular location is concerned is not applicable.
Right. Yes, your reply.
Yes. Well, only three things I shall say. I have submitted very beginning that they have indicated the fuel station as a regular. The interpretation what I have done, that the first on the national highways, state highway and urban area, now within bracket, within the municipal limit, according to the brochure published by the oil companies. Now, when it comes within the NHAI authority, on the NHAI, then the guidelines has to be availed that they have provided Ministry of the Transport and Highways. Now, according to them, that above 20,000, below 20,000. Now, my lord, I have to indicate that whether there is a town or not. Now, my learned senior friend has indicated definition of town according to the Black's dictionary. What I know, subject to my realization, it depends upon a particular population. Suppose we know Malda town, but Gajol is not indicated as a town. And Gajol to Moina, where the particular fuel pump is now installed, that is 11 kilometers away. Now the population of Gajol has to be calculated, or the Moina has to be calculated as it is on the NHAI. Now the Panchayat authority, they do not have any authority over the NHAI. They are having the authority with regard to the population in respect of the villages. Now the brochure also published that when it is within the town, then the concerned Panchayat authority or the BDO will have the access to issue the certificate. It is absolutely coming at it is passes through a particular rural area. Gajol is rural area. Moina is a rural area. Each and every area is a rural area, not the, and the population as indicated, that is to be, my lord, within, for such reason, to minimize the dispute, the authority, NHAI, has issued a particular memo indicating them at least service road be constructed so that dispute can be resolved. That is their part. That is not my part. My issue is, but when it is within the Moina, then the particular Mouja has to be calculated whether it is having that particular population. Once it is within the Moina Mouja, there is only 6,000 population. That is published. They have annexed. IOCL has annexed. I cannot deny that. IOCL has annexed this particular report that Moina Mouja, Bade Moina Mouja, where the Moina bus stand is there, only 6,000, below 6,000 people are there.
All right, please come to the had submission made on behalf of both the parties. The combined exception to the reports filed by the respondents. Combined affidavit of exception by the petitioners to the report filed by the respondents in court today is taken on record. ঠিক আছে? List for orders on আজকে তো হচ্ছে 17 তারিখ 29th of July. These two judgments possibly will not be required where the terms and conditions, because that is not under challenge. 2 p.m. 2 p.m. now, 1:15. Yes, yes.
Your losses are kept the matter next day for orders.
Next to next week.
They have to obtain instruction. With
Yes,
regard
yes.
to
But LD means liquidated damages, my lord, as per the section clause 18 of the tender notice, my lord, which I have annexed to
Then
my
after admitting
Liquidated
you-
damages will be
written
disputed.
contract, my lord. This what had they have
They have admitted the claim before, even before this honorable court, and now they want
Anyway,
damages.
Damages this court cannot enter into or
Now
decide.
they are saying this, they are coming up with this. Previously, their own undertaking admitted claim of 26. Now,
I will give you leave to challenge this before the competent forum, but right now I do not think I will enter.
I can say once they have admitted
Yes,
the dues, can
I will not go into that. Please come. An affidavit of compliance has been filed by the respondent number 3. 2 and 3, annexing a chart showing payment made to the petitioner. Stop. The figures mentioned in the chart and the heads of deduction are disputed by the petitioner. Stop. As the payment has been made pursuant to a contract entered in between the parties, comma, the writ court would not enter into the same and adjudicate the dispute raised. Stop. It will be open for the petitioner to approach the competent forum for relief in accordance with law if so advised. Stop. The issue of payment of interest on account of delayed payment of the dues, comma, is also left open to be agitated by the petitioner before the competent forum. Writ petition stands disposed.
Next matter position
we have matter action number 15, my lord.
She was directed to give him the
Possession
of that bank matter.
My lord, today the possession will be handed over.
Will be handed over.
Today. In the evening, we have informed them by mail.
Yes.
That at 4:30 we will go there to hand over the possession.
All right.
Flat.
All right.
Let us come back tomorrow, my lord, so that necessary orders be passed, because we will be going and take the position.
Cold matter, eh? Which matter?
Next matter.
Oh, next matter.
Hey, because
You want it to be taken up when? Tomorrow?
Because today the bank.
Today it is already time. So tomorrow.
Come tomorrow.
By default, it is tomorrow.
All of us let that order be taken.
past 150 no
Sometimes
order.
his lordship takes up to 130, 145.
But this I will not take. Acha.
My lord, I'm constrained to mention, my lord, I have the other side here also, item number 20 and 21 of your daily list, my lord. My lord, this related to the election of the union in the postal department, my lord. The election is on Sunday. But the may be taken up on day, my lord.
Today it will not be possible.
My lord,
Yes,
3 p.m.
3 p.m. Wait here till 3. No, wait here till 4:45
My lord, then tomorrow
and see what happens.
then tomorrow at the top of the list. Because the
কালকে তুলে দিন তো
election is on Sunday.
20 and 21 কালকে উপরে তুলে দিন urgent motion.
Item number 16 of today's list, my lord.
Yes,
My interim order is expiring tomorrow. I have no other urgency.
yes, tomorrow.
Lordship,
Tomorrow, could it appear as to be mentioned, my lord? I'll
Not
intimate.
to be mentioned as urgent motion.
Lordship,
My lord.
item number 490, application 1. Lordship, I mentioned on 7. Lordship was pleased to include.
Bring your other side.
No, Lordship,
490.
490.
Bring
Content.
your other side. Are you aware who your other side is?
Lordship,
Bring your other side.
Lordship,
After my regular matters are taken up.
My
Side bar করে রাখবেন
my lord,
470.
my lord, item 122, my lord. My lord, with helpless condition, my lord, I am mentioning before your lordship, my lord. Today, my lord, 130, my lord, the receiver, my lord, visiting the property for taking the physical possession of the residential property of the petitioner, my lord, which property is still not mortgaged, not secured to the bank, my lord. Kindly allow me, my lord, for tomorrow, my lord.
All right, tomorrow 122. Tomorrow as urgent motion, serve notice. And ensure your other side is present.
Yes, my lord.
My lord,
I
item
am
number
grateful, my
16,
lord.
I'm sorry, my lord. My other side is here.
I'll take it up tomorrow. Now it's not possible.
Just for the extension, my lord. Otherwise, it's for hearing.
Extension tomorrow only.
Very well.
May I have
All the
my lord's,
application.
may I have my lord's kind leave item 178 of my lord's list today. My lord, my son is autistic and studies in a special school. My lord,
Why are you mentioning now?
my lord, the examinations are coming
But
up on
this is
20.
not the time to mention.
My lord, we had waited the first half only to see how far matters are called on because matters were called on serially. My only
78 was not supposed to be
No,
taken up.
my lord, my only urgency is that 22nd exams are beginning. My autistic son has been expelled from the school along with his shadow teacher, without whom he cannot appear. He's a class 10 student, my lord. The respondents, including the school and the principal, have been served. They are on notice that I will mention today, if even in the first half the matter is. My lord, I'm only praying for this much. Tomorrow, subject to my lord's convenience, any time my lord may take up the matter.
178 urgent motion tomorrow.
I will
Still
put them
notice.
on notice, my lord. I'm deeply obliged.
Subject to the leave of the court, under accompanying circumstances, item number 472. But the last occasion, this honorable court has directed me to serve the notice upon the SDO also. But while I went to serve the notice, then they told us, yes, there is no written, no notice has been served in a written condition. I then showed.
Sir, please do not mention in the midst of the
difficulty, my lord, only one thing, subject to your lordship's approval. Lordship kindly gives me a minute. My lord, my lord, this contempt application. My lord, your lordship has been pleased to direct certain steps to be initiated by the block development officer and the subdivisional officer, though they are not a party to the contempt proceeding. My lord, be that as it may, on 3rd, when the matter appeared, my lord, my learned friend, my lord, it went on to my client as if there is a dereliction of duty on my part. My learned senior friend mentioned this matter, my lord, out of turn. Your lordship, my lord, has passed certain directions to the subdivision. So, my lord, I'm only beseeching before your lordship the copy of this application. Since, my lord, your lordship has been pleased to pass certain directions, that may be served upon me, my lord. And my lord,
Subject to the leave of the court, while the contempt as arises before your lordship, and according to the direction of this honorable court, I have served the notice upon the contempt.
Let a copy of the application be served upon the learned advocate.
for
Stop
the
it.
state, my lord,
For
block
the-
development
of the state, and I
My
have
lord.
already served. All right, I will serve.
Please do.
And if your lordship kindly take up this matter today, because one notice has.
Sorry. 179, please call.
My lord.
না 179 না কোত্থেকে ডাকবেন কোত্থেকে
Item number 1, my lord, Mr. Bhaskar Rai Mahasar will appear virtually, madam.
Yes.
Petition. Bhaskar da.
My lord.
Yes.
Am I audible, my lord?
I can
Am I
hear you.
audible? May I audible, my lord?
I can hear you.
Lordship, this is a contempt petition, Lordship, and the order MP order was passed on 4th October. That is page number 20. My lord, the relevant point is page number 21, para number 8. Kindly, para number 8 of
Where
page
is
number
your
21.
learned
Lordship.
friend? Where is your learned friend for the authority? Contemner, Hirok Bormon and Bikash Singh?
They are also, I think, in virtual.
They are in the virtual mode.
Right.
Please check up. Please check up. I do not see. I don't see anybody from.
I have talked with Mr. Vikas Singh. He informed me he is in virtual mode.
Only let us see if he joins. What is to be done? No construction shall be made over the land of the petitioner without acquiring the same. What has happened?
Lordship, that has been para number 8. There is a clear direction upon the contempt. That is Deputy Director ARD and Kujbihar is directed to pause a spot inspection upon the notice of the municipality and the petitioner to ascertain as to whether the petitioner's land has been used for the construction of the. This part of it has not been done by the contempt, Lordship.
This has been done.
They have, Lordship, they have been filed an affidavit. They have been filed an affidavit. Lordship,
so what is left to be done? Record. What is left to be done?
No inspection has been done, but Lordship, they have been constructed in my pond. They started construction over my pond. And the picture I have been shown, that is page number 26, Lordship, 26, 27. Lordship, kindly see that they have been working. They have done working because there is a strict embargo on that one. They had not started any work, construction work. That is page number 10, para number 10. Para number 10. My Lordship has been directed, no construction shall be made over.
You please tell them to join. In their absence, I cannot decide.
The Passover, make it the Passover.
The Passover will be difficult. I'm making it not today. Please tell them to join next day. Call the next matter.
Lordship, I appear on behalf of the alleged contemner.
Yes.
As if she is the sole alleged contemner in the application, the BDO, Your Lordship. Your Lordship, there was a direction upon the BDO to process the pension file of the petitioner. Your Lordship, the compliance report, may I
give a copy?
Leave to file. Your Lordship, the alleged contemner has taken all steps.
PPO issued?
No, no, Lordship. No, Your Lordship. We had communicated all the order and the Your Lordship will kindly come to page 11 of the compliance report.
Yes.
Your Lordship, we had made the necessary communication on 2nd December 24. Thereafter, we were informed that there are certain documents which need to be submitted. Your Lordship, page 12.
Yes.
By the DPPC, PG. Your Lordship, we had communicated the same to the petitioners at page 20 and 21. Page 21. Admittedly, the documents have been submitted by the petitioners. We have processed that. Now, Your Lordship, Your Lordship will kindly be pleased to come to page 26.
Yes.
The DBPG now seeks a reasoned order to be issued by the Panchayat and Rural Development Department, and unless that order is passed, apparently they cannot issue the pension. They cannot release the pension. Your Lordship, my hands are tied as the BDO, Your Lordship. This request has already been communicated, Your Lordship, to the District Panchayat and Rural Development Department at page 27. Your Lordship, the alleged contemner, sole alleged contemner has taken all the steps necessary, Your Lordship. Rest is upon the DBPG to...
1 minute. Were you there for the state in the matter?
No, Your Lordship.
No. Somebody appeared for the state.
Your Lordship, one Hirok Bormon, Shumit Kumar, Shondeep.
All right, all right. So the state was represented.
Represented.
Now the Panchayat and Rural Development Department will also be defended by the learned advocate who is appearing on behalf of the state respondents, right? You are representing the block development officer. This is a contempt matter, but then it is the state authority who has to do it. Petitioner doesn't have a role.
No, Your Lordship.
Right.
Your Lordship,
Now the petitioner is a
DBPG
retired
the appropriate authority who has to
retired
take steps.
employee, and the pension ought to be paid to
Yes, Your Lordship.
the person concerned. So you will take all steps.
Your Lordship, as
Follow
a
it
BDO,
up.
I have taken all steps.
Follow it up with the Panchayat and Rural Development Department, and thereafter
Your Lordship,
issue file further compliance. Please come. The affidavit of compliance filed by what is your designation? Have you stated occupation service? Where is the what is the
Lordship, I am
designation?
the BDO.
The block
I'm the block
development
development officer of Ketugram 2.
Ketugram 2 development block. Stop. It appears that the terminal due of the petitioner is yet to be released. Stop. The alleged contender is directed to take all necessary follow-up steps to ensure that the terminal dues of the petitioner are released at the earliest. Released a matter for further consideration on 21st August 2025. Stop. The not the a fresh affidavit of compliance shall be filed on the urgent date. Next.
Affidavit of service, Lordship.
Yes, service is taken on record.
But we are for the municipality in this matter.
Madam,
184 and 185, my lord, your
Yes.
lordship directed the principal secretary of the UD department to appear virtually before your
Lordship, in
lordship.
this matter, Lordship, Mr. Sandeepan Banerjee is appearing on behalf of Howrah Municipal Corporation, Lordship. Please kindly allow us a short passover, Lordship. He is engaged in another court, Lordship.
Let me hear once. Mr. Das is here.
Before making any submissions, my lord,
Yes.
the principal secretary and the minister in charge both are attending a meeting at Bigyan Bhavan, New Delhi.
All right.
All the papers with me.
All right.
For abundant caution, I have asked the senior special secretary just to come before the court.
All right.
Well, kindly puts it after 2
All
weeks.
right. 2
weeks on 31st.
No, but then I want to hear what have you done?
Yes,
Well,
that is
What have you done?
everything is with him. Things are progressing, my lord, but until and unless he comes back, my lord, I have asked the.
One person will hold the department. How can that be?
Something has to be done through, and I have they have given me these documents today and tomorrow he is attending a.
Let him
seminar,
attend.
but-
He is holding a responsible post and he has a lot of responsibilities. That does not mean that he is not going to comply the court's order. The court is not going to accept this type of submission.
last day the report was submitted before your lordship that the
On
file is
19th of June, there was a direction that he will appear virtually today.
Appearance portion I am dispensing with. I want the order to be complied. What will the court do by looking at him? His presence was required only because there is a requirement of compliance of the court's order.
One instruction has been given to me.
Yes,
I can
please.
say that.
What is that? What does it say?
It says the details what has been done. My lord, kindly comes to the first page and
Yes.
Me. First page and paragraph 4.
Yes.
Remaining is.
In my humble submission, PPO have been issued for 55 number of petitioners and they are getting their pension. 21 petitioners are employees who are in service.
Signed today.
7 cases are under process for pension and 3 cases are found not eligible. But from the date, it is the period from which it is being.
every day, my lord, they will repeat and reiterate the same fact. When you
It is,
last 14, my lord, the cabinet meeting was done. Last
Thing is,
now
of this month.
I have no instructions regarding that. Is why I've asked the senior secretary to be present. At least she can apprise the court what is just internal departmental.
no, but then you are there. Why will I hear from anybody else?
I am there. Yesterday, I came to know that this gentleman is out of town. For abundant caution, my lord, I asked her since she is the second most senior person in the department now.
Do not make this submission until and unless your lordship.
That is why. Otherwise, I wouldn't have.
Directs the principal secretary to come down, lord, before your lordship.
Otherwise, I wouldn't have prayed like this. Yesterday only at late hours I have got this in sign. And this has been signed today, my lord. Kindly grants me. She is there. I don't know.
All right, let her speak. Let me hear. Yes, madam.
She had appeared once again. Before.
All right.
The principal secretary is in.
My lord, why is the order of the court not being complied with? This is the query.
My lord, delay in getting pension is one of the grievances, and out of 65 retired employees, 55 employees have already got their pension.
From a later point of time and not from what they are entitled to. The dispute is the date from which the PPO is to be made effective. You have made it effective from a later point of time and they are entitled to a previous point of time.
Finance already approved.
My lord, finance department has concurred that from the date of joining in Howrah Corporation against regular vacant post is the.
Both of us can't say. Second.
Yes, yes.
Is the date from where their qualifying service would be considered. And it is a fact that we cannot through it in the cabinet, but finance department has agreed with our proposal that not the project period. Normally, this is not a standard practice that project period is counted for.
I will not listen to all these things. There is already
the understanding.
There is already
before your lordship has
saying
saying that initial date of my appointment.
Kindly kindly
to
keeps it
approval
up
of
on
cabinet.
31st,
This
my lord, we have
responsible officer is
definitely
saying
come
that
with
this is the
better
interpretation.
particulars.
Milord, kindly allot.
Well, kindly fix it up on 31st. I ensure that we'll come with better particulars.
So then, Milord, the understanding of the UD is that the finance departments have approved from the date of our regularization. This is Milord the understanding? I do not know, Milord, where Milord we are. Milord, your lordship has made it clear. Others person has got it without approval of the cabinet from the date of initial appointment. Your lordship recorded times and again, 1.5 years back.
Please come. It has been submitted that the Principal Secretary, Urban Development and Municipal Affairs, is unavailable today as he is attending a conference in New Delhi. Staff request has been made to adjourn the matter for the day. Staff, in view of such submission, release the matter. 24th, next Thursday.
Could it be on 31st?
No, please.
With that is 24th. No, I will not be there.
Hmm?
So then, Milord, your lordship is directing the principal secretary to appear virtually.
Yes, yes.
Right.
Same order on
Same order.
Great.
Grateful, man.
This matter is also.
Yes.
আমাদের এরপরে কত আছে?
আমাদের
এখন নেই।
item number 4 to bring the other side.
Sir, it cannot be done in the midst of the list. I told you. I'll take up my regular matters and then I'll come to the mentioned matters.
For the container number 2, madam.
I'll answer the
Actually,
one.
on the last occasion, madam, the affidavit I filed, madam, that was not tagged with the record, madam. That's why the matter was adjourned, madam. Kindly, madam.
Container number 1 also filed.
Yes.
This is also
What is the issue over here?
Madam, before your lordship kindly go to my, madam, the last occasion lordship was inquired as to whether the criminal case, madam, for which the provisional pension was awarded was given has any connection with the service of the petitioner or not. Lordship, before your lordship kindly come to this supplementary affidavit, lordship kindly come to your lordship's order first for once, madam. Madam, the order is that.
Tell me whether it is connected or not.
Lordship, yes, madam. According to your lordship, kindly take the order for once, madam. For my
Tell me whether it is connected or not.
kindly. Lordship, the affidavit which has been filed, if your lordship comes to page 10,
What does it say?
my lord, this is what has been said, my lord, that the affidavit, my lord, the complaint has been given, my lord. This is a case of breach of trust. My lord, the person, my lord, who took the hush money, my lord, for the purpose of giving employment, he, my lord, why the money was, my lord, asked for the return, he has, my lord, official seal gave a promise to the petitioner that I will give the return of that money. Thereafter, my lord, he didn't refund, and that's why the case was registered. If your lordship kindly come to the complaint, the cause of action of this case come from the, my lord, the trust has been gained by using the official seal. Your lordship kindly come to page 10A, there is a typed copy.
Of your compliance?
Of my second supplementary affidavit.
Supplementary affidavit.
My lord, your lordship will take that supplementary affidavit which is affirmed, my lord, on 26th of March 2025. Your lordship will find in page 10A. And
how voluminous it is?
This is the affidavit which was, my lord.
I can see the affidavit on behalf of the alleged contemnor.
Back sheet of Somnath Raichur.
Yes, Somnath Rai Chaudhary. Affidavit on behalf of the alleged contemnor number 2.
That is the first affidavit, perhaps, to your lordship. But
26th of February.
No, that was not the affidavit. Subsequently, I filed the affidavit on 26th of March 2025. For tagging that affidavit and record, the matter was adjourned, my lord. No, the 26th of March.
Tag hoyeche?
That was filed. Your lordship was
My lord,
taking
contempt-
instruction. Your lordship, that has been recorded in your lordship's order dated.
Listen, the department says that there is no affidavit in opposition.
My lord,
My lord, there is a number. I have also filed the second affidavit.
26th
My
of
lord, that is filed on 28/4/2025. That filing number 3.
And it is a
I have received this information.
May I hand over to your lordship, my lord?
Yes, please.
That is one suffice the purpose. Without going to technical, it is only to get a copy also. My lord, this is the complaint, my lord. Your lordship will find.
Yes.
And your lordship will find that the promise was given to refund the money which you took unauthorizedly, my lord, that by using the official seal. And the breach of that, my lord, the trust was gained by using the official seal, and that was breached, my lord. That's why he went to the police and lost the docket, and from that, my lord, the criminal case, my lord, arose. And lordship, kindly take the next page, the statement recorded in the under 161. The concerned persons, my lord, also, my lord, the witnesses, my lord, also said, my lord, the same tune. That the refund of the money was promised, my lord, by using the official seal. That was breached, my lord. With regard to that interpretation, my lord, in view of Rule 52, I have, my lord, I have sanctioned the provisional pension. Your lordship, why I am saying, my lord, to take your lordship's order? Your lordship's order had a two part. And the first part was to proceed with the application for pension, and the second part was disburse the pension. But accordingly, I proceeded with the application for pension. But while I proceeded the application for pension, I received this antecedent report. My lord, on the basis of that, my lord, I, my lord, passed an order that you were my lord, entitled for provisional pension in view of this criminal antecedent. My lord, if he is, my lord, agreed by that order, my lord, it is open to him to challenge it in writ application. He cannot invoke the content proceedings challenging the legality and propriety of that order, my lord, which has been annexed. Your lordship will find first affidavit.
Is it page 14?
My lord,
The order of the
that has been marked in my. May I take the first page of my notice? Otherwise, difficult for me to. Don't take me, amiss, my lord.
No, it's all.
14. Lordship, I'm taking this one and then handing over.
1 minute. Let me see what the order was. Let me see what the order was.
The order is, my lord, the ordering portion is page 93 of the contempt application, starts from page 63. And the paragraph number 4, may I read, my lord? The consequent to the aforesaid conclusion, the prayer of the petitioner stands allowed. The disciplinary proceeding sought to be initiated against the petitioner is set aside and quashed. The block development officer shall take immediate steps to proceed with the pension application filed by the petitioner and do the needful to ensure that the retirement benefits of the petitioner are disbursed at the earliest, but the positive within the period of 4 months on the date of communication of this order. So the direction was to proceed with the application. Subject to correction, when the direction was there to proceed with the application, it was my duty to come to a conclusion. I came to a conclusion. Your lordship will find in page 23 of my first affidavit that I came to a conclusion that since I received the criminal antecedent report and this document in view of Rule 52, my lord, the person is entitled for the provisional pension only. So I passed the order. Your lordship will find in page 23 of my first affidavit. Yes, page 23. This is the order that I passed and I communicated to him. As per the direction of the district magistrate, my lord, this is the order passed, the provisional pension, and that has been paid up to date. But if he is at all agreed by this order, my lord, his remedy is to file an application challenging this order. The content jurisdiction cannot be invoked, my lord, to challenge the legality and propriety of this order. My lord, if your lordship, my lord, may I?
Don't rely upon judgments on this proposition, please.
My lord, that's why, my lord, I was not.
Please don't.
That's why I am not going to. This is not open to him to challenge this order in a content proceeding because no further direction can be sought for in a content proceeding. But I complied the order according to my understanding and what he has entitled for at this.
Not kindly take your lordship's order dated 27th of February. Your lordship, in that judgment, may I read for your lordship? Paragraph 3. Court directed the
block development officer to take immediate step to proceed with the pension application filed by the petitioner and do the needful to ensure the retailer benefits of the petitioner is disbursed earliest. Learned advocate representing the petitioner relies upon the judgment delivered in the Supreme Court in the matter of such and such, wherein the reiterated the principle that if the order passed by the competent court is clear and unambiguous and not capable of more than one interpretation, disobedience to the breach of such order would amount to contempt of court. It has been submitted by order dated such and such. It is clear and unambiguous that the retail benefit are to be disbursed in favor of the petitioner. Contemptor could not have withheld any part of the retail benefits. Reliance has been paid on the order by the Honorable Division Bench of this matter in such and such case. No, paragraph. Learned advocate representing the contemptor seeks to time to instruction whether pending criminal case has any bearing in the service matter or not. So it does not have any bearing. I know that if any complaint laws, the conduct of the petitioner is not good one. If subject to correction, it is to be tried in the different court. But whether it is connected, official seal, they are saying. Your Lordship dealt to it in page 18 of the judgment itself in respect of other criminal case or pending or such and such. It has been clarified by your Lordship. Page 85, running page 18 of your Lordship's judgment.
Yes.
That plea in respect of another criminal case was taken up.
All right.
Whether withholding of pensionary benefit is done or not in terms of Rule 10. Kindly read that.
Yes.
10.1. Governor reserves himself the right to withholding the pension or any part of the permanently for the specific period. Right ordering recovery from pension pecuniary loss caused to the government. So here let them show that any pecuniary loss in respect of my service
conduct.
Yes, it is there. Mere one allegation that somebody made an allegation that the official seal only complaint. Thereafter, no, nothing has been investigated, nothing done. Whether I have made any official seal, they have not produced anything. So in absence of now, kindly see the ordering person. Why they are withholding? Your Lordship will find there is a direction further. He is not reading page 894 of the content.
Yes.
Your Lordship made it clear that somebody should take the responsibility, whether during the service period or any step could have been taken against me or not. Your Lordship further directed. That prompted them to not to give. Kindly come to page 94, internal page 27. Court is of the opinion. No, may I read from the page 93? The judgment of the court could have ended here. I am starting from there. But the court is left wondering whether the delay in taking prompt action against the petitioner, despite his alleged misconduct, coming under the scanner nearly 2 years prior to his retirement, are deliberate or not. Should the inaction on the employer to take proper step indicate immediately upon noticing the alleged misconduct, the petitioner be not taken passive support to the petitioner to continue with alleged illegal act. It is not. It is the failure on the employer to proceed against the employee, despite noticing the misconduct on his part, liable to be dealt with appropriately. Will
Alright.
not be in.
I have followed.
Therefore, it is for that additional. They are trying to invoke to bypass my. If the order is unambiguous, your Lordship directed. They could not have made any application for recalling, review, or something else. Order sacrosanct till date. So I leave it to your Lordship. Pension should be released in any manner. Whether official seal.
What is the judgment that you read that it
Yes,
will be
I have handed over. Now, Supreme Court paragraph 11.
Where?
Now it is quoted in C. Elu Malai. No. একটু দেখে দাও ওটা মালয় যে সমেনশন এর আমরা সুপ্রিম কোর্ট জাজমেন্ট আছে I'm giving 1 minute.
Yes.
And in a contempt proceedings, your Lordship can proceed further to get the order implemented. That is the Honorable Chief Justice's judgment to Sanjay Kundu's case.
Give that also.
Yes.
In view of Rule 52 of the decision,
52 has been discussed in the original proceedings. You kindly go through the judgment entirely.
In this judgment, my lord, what I've read, this judgment was my learned friend, my lord.
Which judgment?
The judgment which has been relied upon by my learned friend on earlier occasion. there is a clear direction, my lord, to give employment, and the authority, my lord, takes some ploy, my lord, not to give.
No, listen.
employment. And I'm, my lord,
No, do not,
asking instruction.
there is no
Kindly
reason to
take
differentiate.
Can
Please do not differentiate, distinguish. Thing is, the issue of the criminal case was considered in the judgment in case of the petitioner itself. No pecuniary loss. Somebody goes and says that he has used the official seal for doing some illegal act. Where is the finding?
My lord, this is the
Yeah, there is a finding in charge sheet.
my lord, the thing is, my lord, kindly come to the charge sheet for once.
Charge sheet is there before the criminal court. Did the government lose anything because of the petitioner's act?
My lord, Lord, you kindly take rule 52 or 2 of the DCRB rule.
I am not looking at it. You tell me whether
The DCRB rule says, my lord, whenever the criminal cases are pending, my lord,
that has been discussed time and again. What exactly is the 498 AK proceeding?
even if it took a wrong interpretation of a law, my instruction is this: because of the rule 52, their hands are tied. They are.
Sir, 498 proceeding is a criminal proceeding. Pending. You'll stop pension.
Thing is this in this case, my lord, by their interpretation of the law, my lord, since they gain that is a case of breach of trust. The person came.
Breach of trust, not with the government. There was no breach of trust by the petitioner with the government. Some XYZ comes and says.
Trust was gained by using the official seal. He didn't go to the police station before the promise was given orally. The moment the promise was given it is the case.
Sir, I am not accepting your submission. When will the pension be released?
My lord, if your lordship give, this is my specific instruction. My lord, going
yes.
to my lord, address before your lordship. If your lordship, my lord, give a one line, a direction that to give the entire pension, I will read.
That is the direction.
The direction was to proceed with the application. My understanding, subject to correction, my lord, when my direction was to proceed with the application, I proceeded with the application, and my duty, when the proceed with the application, I have to come a conclusion. I came to a conclusion. It may be my lord wrong conclusion. But lordship, the wrong conclusion, if your lordship says that it's a wrong conclusion, I will be answerable to my higher authorities that in view of rule 52, my lord, I did it. Because the DM also directed that in view of rule 52, my lord, I have to disburse the pension. If your lordship says it's a wrong interpretation of law, I will certainly disburse.
All right.
I don't have any problem in
Please come.
Discuss page 8, 52 already.
This is my lord.
In judgment, 52 already argued. Discuss into page 75. Kindly see.
Wasn't any appeal carried from this judgment?
No.
Why?
Then
you could have carried an appeal.
This order, what he is citing, is other criminal case, my lord. This is not this criminal case, my lord. This I found after when I proceeded with the application, my lord. I sought for some information. It is a duty, my lord. It is a normal procedure. The police gave an antecedent report. I, my lord, saw the rule 52 under the rule 52. Whatever criminal, my lord, what I've read, my lord, the rule 52. If the criminal case is pending, he's entitled for provisional pension. If it's a wrong interpretation, lord, you kindly correct me. I will discuss, my lord. This is my specific instruction.
Wrong interpretation,
They
not
don't have it. Wrong
own
interpretation. But this is not a willful or deliberate violation. It might be even if the order spirit of the order has been complied with due to my wrong interpretation.
What were you showing? Page 50.
Page 75. Internal page 8. I argued they took this point.
Different criminal case.
This is a
Maybe.
different criminal case.
It's
This is not the same thing.
Maybe. Issue same. Second paragraph. It has been argued.
Maybe he is a habitual.
They have taken that plea itself. That has been turned down. Initiation of proceeding against the Gram Panchayat wrongful.
Rule 52 has been
Discussed.
discussed. Rule
Reopening the
52 has been discussed.
And that is why my lord page that page.
Thereafter,
Rule 10.1.
Ultimately, operative part was actually to
What is this for?
That judgment 11, paragraph 11 can see. If the order is unambiguous and clear, capable of not more than one interpretation, disobedience and breach of such a jarut amounts to contempt. Otherwise, it is subject matter of mockery. Overreaching the court.
In the ordering portion, I was directed to proceed with the application. I cannot blindly give the pension whatever it.
Paragraph 11 clearly says. Own understanding also amounts to contempt.
Acha.
Get.
The petitioner alleges violation of the direction passed in the judgment dated 18th June 2024. Stop. In the process of complying the court's order, whereby the court directed whereby the court quashed and set aside the disciplinary proceeding sought to be initiated against the petitioner after his retirement, and directed the block development officer to take immediate steps to proceed with the pension application filed by the petitioner and do the needful to ensure that the retirement benefits of the petitioner are disbursed at the earliest. Stop. The court, in the said judgment, took note of a criminal proceeding which was pending against the petitioner. Stop. The authority, at the time of processing the pension application of the petitioner, allegedly came to learn of a different criminal case, which is pending against the petitioner. Stop. The authority concluded that the said criminal case relates to breach of trust, and the same would fall within Rule 52
page 75 of the contempt petition
of the West Bengal bracket open Gram Panchayat Administration bracket close rules, 2004.
DCRB.
না না ডিসিআরবি ডিসিআরবি আলাদা
As amended in 2006.
52 টা হলো পঞ্চায়েত
And because of the pendency of the said case, criminal case, the complete amount of pension has not been disbursed in favor of the petitioner. Stop. The petitioner is receiving provisional pension. Stop. The contemner submits that pendants that the authority read the rule, the subject rule 52 in a manner that if any criminal case is pending against the retired employee, the pension cannot be released. Stop. According to the authority, an order has been passed by the block development officer for disbursing provisional pension. Stop. If the petitioner is at all aggrieved by the same, the petitioner ought to approach the competent forum for relief. Stop. The court sitting in contempt jurisdiction ought not to adjudicate correctness of the subsequent order passed by the authority in compliance of the direction passed by the court. Stop. The learned advocate for the petitioner relies upon the judgment delivered by the Honorable Supreme Court in the matter of নামটা লিখে নেবেন C. Elumalai versus AGL কিছু একটা
ডিভিশন বেঞ্চ
reported in
ডিভিশন বেঞ্চটা কোথায় গেল এইটাই
অনেকগুলো সাইটেশন আছে, SCC সাইটেশন দেবেন। এই যে 2009 4 SCC 213, wherein the court held that if an order passed by a competent court is clear and unambiguous and not capable of more than one interpretation, comma, disobedience or breach of such order would amount to contempt of court. Stop. There can be no laxity in such a situation. Otherwise, the court's order would become the subject of mockery, misunderstanding, or own understanding of the court's order would not be a permissible defense. The court also held that mere disobedience of an order is not enough to hold a person guilty of contempt. Stop. The element of willingness is an indispensable requirement to bring home the charge within the meaning of the act. Act এর জায়গায় Contempt of Courts Act. ঠিক আছে? It appears that in the instant case, Rule 52, relying on which provisional pension was disbursed in favor of the petitioner, was discussed. Stop. The authority never challenged the direction of the court before the superior forum and proceeded to act in accordance with the same. Stop. After
of DCRB.
After the court has discussed the issue, there is hardly any scope on the part of the authority to reopen the same issue of pendency of a criminal case against the petitioner solely for the purpose of not releasing complete terminal dues. Stop. The action of the authority appears to be contrary to the direction passed by the court. Stop. Next. The authority is accordingly directed to release full pension in favor of the petitioner without any further delay.
In terms of the pension payment order already issued, I am handing over that document.
Okay.
It was my lord,
In terms of the PPO,
Already issued on 22nd of August 2022. That is prior to my retirement itself. I have annexed those documents.
নাম্বারটা লিখে নিন তো একটু।
একটা কপি দেন।
আচ্ছা। Release the matter for further consideration on 28th of August to 8.
in case of rule 52, that is rule 54. I have my lord,
Of DCRB.
DCRB rules. My lord, I my lord, allowed the provisional pension on the basis of rule 54 of the DCRB rules. My lord. Your lordship has recorded rule 52.
Rule 52 is here mentioned in
rule
the order sheet itself, which
I
provides for initiating criminal cases against for wrongful act.
my lord, I passed the order considering rule 54 of the DCRB rules. My lord,
Right.
your lordship recorded that I issued a it may be
DCRB
wrong, my
is
lord. What
also
is that?
considered.
It's my submission that my lord,
DCRB rules considered in page 18.
That might be wrong. This is our my submission. You cannot tell to record. It is my submission that rule 54 of the DCRB rules, my lord, I allowed the provisional pension. I disbursed the provisional pension. It is not in terms of rule 52.
Page 85 of the contempt.
While your lordship recorded my submission.
Yes, yes, I have followed it. যেখানে 52 বলেছিলাম সেখানে রুল 54 of the death cum retirement benefit scheme, 1985. হ্যাঁ, যেখানে ওনার সাবমিশনটা রেকর্ড করা হলো।
Yes, sir.
আমার একটা কপি দে না
Of the death cum retirement benefit scheme, 1985.
দিচ্ছি কপি দাও নি
আগের দিন
Clause 49 of DCRB was considered.
Rule 54 and Rule 40.
in our first affidavit we have annexed. First affidavit last
Order,
page number 8.
order is at page.
First affidavit.
ঠিক আছে, আপনি দিন, আমি দেখে নেব।
Your Lordship will find in page 23.
No.
Is this on record already?
Yes.
Affidavit is on record.
Previous one. Yes, sir. Affirmed on Your Lordship kindly as 26th of February.
February is here.
That is the one Lordship has repeatedly directed to tag it on record. Well, I have filed, but Lordship, can I file it?
একটু দেখুন তো ওই যে নম্বরটা দিচ্ছে।
3 and 4.
I have also filed.
28th of April. Your Lordship has recorded in Lordship's order, earlier order.
ডিপার্টমেন্ট থেকে ওটাকে আনান।
Of April, filing number 3 for contempt number 1.
Give a photocopy of that filing number or something so that it can be found out.
My photocopy is with Your Lordship. I have handed over.
No, not the copy, the
Number I can provide, madam.
আছে না?
From the website we
Yes, website it is seen. এই আমাদের বলছে হ্যাঁ এটা ফেরত যাবে।
Can it be on the next 15th August? Can it be on
15th August?
16th August? Next to
15th is also holiday.
28th of August, 28.
Yeah, it will take some time, my lord, to this.
Yes, although I do not appreciate my client's conduct, it could have been earlier. It cannot be appreciated. Yes.
My lord, I am for the writ petitioner. My lord, Mr. Galevi is appearing. My lord, I served copy of the contempt application upon the private respondents and also writ petition upon the private respondents. My lord, it's a short matter.
Who are you?
I am the writ petitioner. First one, contempt be restored on
Contempt.
Sorry,
Restoration.
Sorry, restoration application.
This is an application for restoration. When was it dismissed? 25th of February. And you filed it on 7th of March. Yes. What is the reason for restoration?
I missed it.
You missed it.
Two affidavit of service. One CAN application and another is writ petition.
What is the matter about?
Well, matter is petitioner before your lordship is the he is the member of the scheduled tribe community. He has a land. And residential place there. And beside my land, there is public way, that is municipal way, pathway. That is at per record that pathway is 3 feet. But some private respondent along with the help of the local councillor, they are trying to dispossess and taken over my land, which is for that reasons I was beaten by them, and one criminal case also registered against.
What is your prayer in the writ?
Prayer is I made a complaint to the district magistrate and a district welfare officer, page 66. Accordingly, district welfare officer
Page 67 was issued. Then what happened?
Nothing. No inquiry, nothing. No
All right.
protection is being
Milord, twofold prayer, Milord. One is Lordship has already taken up the prayer clause
No, I have not.
at page 19, Lordship.
Yes. To make an inquiry?
Milord, Lordship, my learned friend wants that on the basis of representation submitted by the petitioner on 23rd October 2024. That is at page 66, not yet considered. That is fact, admitted fact. And secondly, my learned friend wants, Milord, kindly comes to page 20 and transmit the relevant record so that the conscionable justice may be rendered by him by taking steps based on order date 6
Yes.
March 2024. That is also, my lord, kindly see.
Did you receive any instruction?
Yes, I have, my lord.
What does it say? Was any
As far as the
inquiry
so,
conducted?
lordship, so far as atrocity part is concerned, compensation as per the provision in the act contemplated was given to him. That is one part of the story regarding compensation.
When was it given? During pendency of the writ petition
No,
or
it was
prior
given, my lord.
thereto?
May I respectfully invite your lordship to me to page, my lord, 14 of the report.
Yes.
That compensation part for atrocity committed on him was given on 2nd July 2024.
Hmm. Yes.
Page 14. So that is one part.
Yes.
And that was credited to the account at page 15. So
Right.
that is the compensation part for atrocity. But regarding land dispute, kindly see this, my lord, in my humble understanding, if your lordship kindly goes through the representation given to the DA, the
Not-
land dispute issue
Uh,
বলছে আমার পূর্ব দিকে উনি দখল করেছেন, পশ্চিম দিকে আরেকজন মানে প্রাইভেট রেসপন্ডেন্ট রিপ্রেজেন্টেড।
uh-huh.
So how can that be, my lord?
So whether it is a tribal land being occupied by a private party, it is only this is to be inquired. Nothing more. Tribal land.
So page 66 may be sent to the DM for, my lord.
67, my lord, the direction about the, my lord, district welfare officer.
Not done. This gentleman has not done anything. Kindly see the report, my lord, at page 2, my lord, what the DWO says. Kindly text up my report.
This gentleman means the video.
Video, he has not done anything.
All right.
Kindly see point number 2, my lord. Kindly see point number 2 of the.
Will.
For the municipality, madam.
What is your submission?
Is that in
Tribal land or what?
No, I am municipality.
Is it a tribal land?
No, I am the tribal, my lord.
He is not the at all owner.
Annex the, my lord, certificate also.
As per record of right, annexing the writ petition, he is not the owner, but he is in possession.
Tribal land.
Though he is in possession of the land.
Tribal land or what?
I am a tribal.
Landowner is not a tribal.
I am a tribal.
The land is a tribal land or what? It's not a tribal land.
Not owned by the tribe.
Not owned by any tribal.
Owner is a different person.
Owner is a different person.
As per record of right, annexing the writ petition. He is in possession, not in dispute that tribe. But the question is there. There is no question of any tribal.
Page 22, my certificate.
He is alleging that
Encroachment of.
private respondent.
I understand.
The local councillor
Let's come.
Wrote a letter to the, my lord,
In the meantime, what happened? Some of the private respondents, their allegation is that the road is 8 feet wide, and the allegation of the petitioner is the land is that the passage is
3 feet.
3 feet.
His is 3 feet. He says 10 feet. This is the
Basically, land of the petitioner is in the corner side. There is a front road. He is enjoying the front side, and there is a passage that is in the he is the first plot holder. There the common passage is narrow, and
Yes, yes. Then what happened?
they are alleging that and the one of the private respondent they initiated proceeding under section 133 of the code of criminal procedure before the
That is nuisance.
but the order was passed by the learned magistrate.
Yes, it's a nuisance. Removal of no. Yes.
The DLLRO to take the measurement and to take appropriate steps.
Yes. Has measurement been taken?
Yes, ma'am. I have annexed the, my lord, page 53.
Oh, then it's
Yes,
all right. Please come.
Right.
Please come. Please come.
My lord did not go through the record, page 53. That measurement is being taken.
Yes,
My lord,
but
as
the
per their
DLLRO was directed to take the measurement and take action.
rate of the entry point of the concrete
Okay.
road is 4 feet.
25th February 25. Order recalled.
Section 3F and G.
ঠিক আছে?
Protection is being given in the
The
statute.
petitioner prays for a direction upon the block development officer and the block land and land reforms officer to take steps in terms of the direction passed by the district welfare officer, comma backward classes welfare and tribal department, comma Nodia dated 6th March 2024. Stop. The petitioner claims to be a tribal. Stop. His allegation is that the private respondents are forcibly occupying the tribal land.
Violation of 3FG.
The district welfare officer has requested the block development officer and the block land and land reforms officer, Chagda, to cause an inquiry and take necessary action. Stop. The same has not been done till date. Stop. The Instant writ petition stands disposed of by directing the block development officer and the BL LRO Chagda to take steps to inquire into the complaint lodged by the petitioner alleging forcible occupation of tribal land in accordance with law. After giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. If it is found that any portion of the tribal land has been forcefully occupied as alleged by the petitioner, comma, then necessary remedial steps shall be taken. Petition disposed.
This report may be retained with the record, Lordship.
Report is written with the records. Affidavit of service also
Thank you.
taken on record.
Lordship. The zeros,
Yeah, just gonna say to the. Hey, Horo.
189, my lord, I am appearing on behalf of the petitioner, my lord. This is the affidavit of service. One mentioning.
What is it?
My lord, I am inviting your lordship and come to page 26.
Who is
Order passed by your lordship, my
who
lord.
is the contemner?
My lord, contemner is the Pradhan.
Very well. Rule issue.
My lord, order dated 10th.
Rule issue.
Yes, my lord.
Rule is issued.
No, my lord.
I'll issue it. Rule issue. Returnable on 21st of August. Requisites to be put in at once.
I am for the application. But I have a point to my lord. Agitate regarding
The contemner despite service. তারপরে rule issue. Yes.
But I have a
6 March 2025. I am filing the.
Yes.
my lord regarding
Who are you representing?
my lord, I am representing the subdivisional officer.
All right.
My lord, I have a my lord, I have a point to agitate regarding maintainability of this writ petition. My lord, I have seen
Petition. This is a
my lord, this
contempt
contempt
appeal.
application. Sorry, my lord, the petitioner, the applicant herein, he was the private respondent in the writ petition.
All right.
Now, my lord, your lordship has been pleased to uphold the order passed by the subdivisional officer without interfering. My lord, subject to correction, if my learned friend, being the respondent in the writ petition, is aggrieved by the alleged inaction, but subject to approval, your lordship's approval, the appropriate course of action would have been to file a fresh writ petition. Well, there is no specific direction by your lordship.
Let me see.
My lord, kindly seize the order.
After that, the petition of filed appeal. Your lordship order, then that appeal was also dismissed on merit.
There is no
Come at page my annexer page 33.
But first, your lordship's order, that is at page 25. This has been upheld.
Could also uphold the my lord order. After that, my lord, I communicated the my lord order on 30th April.
কোথায়
কমিউনিকেশন নয়, এটা হচ্ছে আমাদের সার্ভিস করবে।
এই যে
Yes.
Yes. My lord, your lordship's order is at page 25. My lord, the
Right.
operative part is page 31, 32, my lord.
Yes, yes. Then
Yes.
what has happened?
Now, my lord, this order is
Ashish
there.
Chaudhary went up in appeal.
Appeal. The appeal court dismissed, upheld your lordship's order.
Yes.
After that, my lord, I communicate to the Pradhan. My lord, can you come at page 36 annexer P3 for comprise my lord order. That is still pending. And in that, after that, my lord, this matter was heard on 6 March, my lord.
I contemplate the file.
to the contender
By
and
the
evidence
appellate for us in matter.
filed before your lordship.
In such
Page
matter
32, ma'am.
disposed by the court of ruling that the particular vocabulary recorded. Whether it is to assume the order of the STO in petition. It has been upheld by the division bench. Now what you want? What is the violation?
The petitioner by that constructed the ground floor divided the sanction plan to 212 square feet.
Yes.
First floor also my lord without opening sanction plan. That's why
Right.
my lord.
So you file a writ petition. Why a contempt? Please come. The petitioner in the contempt happens to be the private respondent in the writ petition. Being in a writ petition. Stop. The writ petition stood dismissed and the order of dismissal stood affirmed by the order passed by the Honorable Division Bench. Stop. The private respondent paragraph there contends that the the writ petitioner, the contempt petitioner contends that the writ petitioner has raised construction in deviation, not in deviation, contrary to the provision of law. ঠিক আছে? The contempt petitioner alleges illegal and unauthorized construction at the behest of the writ petitioner in the writ petition. Stop. Paragraph. It appears that there is no allegation of violation of any of the direction passed by the court. Stop. As the petitioner appears to be aggrieved by the action on the part of the writ petitioner in raising unauthorized construction, the contempt petitioner ought to approach the competent forum for relief. Stop. The court sitting in contempt jurisdiction will not be in a position to pass any direction in favor of the petitioner herein. The contempt application accordingly stands dismissed.
My lord, I am appearing for the petitioner.
Yes.
Order dated, my lord, 19th June 2025. Your lordship directed to sub copy. Upon my lord, Mr. Sundipon Banerjee, who appeared for the Howrah Municipal Corporation, I have served and also served notice upon the learned advocate who appears in the writ petition.
Yesterday evening, Lord, I was informed.
So far as my concern is that, my lord, this is not a
to make contact with my client, Lord, because kindly extend here.
This is my lord, for against an interim order for violation of the order.
against an interim order, and for which I am not responsible. I think my learned friend will.
No, he is not also not contender. Howrah Municipal Corporation is not the contender.
Contemner may be made a party.
7.
Main
7 is the my lord,
contemner is respondent number 7. I have been made a party.
Honorable Justice Thomas Secretary, as the lordship then was, my lord, directed pass an interim order restraining the respondent number 7 from creating any third party interest. My lord, after passing this order and in spite of due knowledge, my lord, they have transferred some of the portions and also made some construction. That's why, my lord, I filed this contempt application.
Yes, please.
But I have seen the allegation, Lord. The interim order was not to
Create third party rights, and you have done so.
That's the premises. That is there.
In the
order
premises.
itself.
Yes, you have done so.
It is alleged that one or two shops have been.
Whatever, 1 or 2, I do not know. Have you done so?
I will have to not take it. I have not given.
File your affidavit, please.
But so far as my concern is that I am not.
You are not not responsible. Very well. You stay if he has impeded
Yes,
you.
for me it is effective to be stayed personally.
Ashok Patro is the private respondent.
Yes, madam. That's not sir.
Against whom the allegation number?
Then where is the direction? Why was direction passed for service upon Mr. Sondipan Banerjee?
Yes, my
I
lord.
don't know. Previously, I served. Madam,
No,
thereafter,
no, but
since-
why was the where is the property within the Howrah Municipal Corporation?
Our municipal corporation appeared. They also filed affidavit in opposition. I have also filed the reply.
Is it within the Howrah Municipal Corporation area?
Property is in Howrah Municipal Corporation,
Is
but
it-
no allegation against me.
No, no, that I can see because you are not the contemner also.
Yes.
Contemner is Ashok Patro. What is your contention? Is any unauthorized construction made by the private respondent?
That was my concern at the time of hearing of the matter
Writ
at that point
petition.
of time.
Yes.
Without
So
sanction
that
plan.
remains.
That remains.
So the petitioner has his own goal, not there are many allegations of
What steps are you taking against this unauthorized construction?
That I will take instruction.
That is also madam without sanction plan.
Take instruction.
That I will take instruction.
Achha. The matter relates to
But in this content,
unauthorized construction at premises number 178 Benares Road. Police Station Lilua, District Hooghly, District Howrah, under the jurisdiction of the Howrah Municipal Corporation. Stop. The learned advocate representing the corporation is directed to place a report with regard to the steps taken against the detected unauthorized construction. Stop. The contemner, who is a private party, is also directed to file an affidavit disclosing his stand. Stop.
only one thing, right?
Yes.
So far in the interim order, no direction was passed upon me to take any steps. Even then also, if any steps have not been taken, I will take steps. That may be given.
Achha.
So far,
Released the matter on 21st of August. Affidavit of service is taken on record.
Justice Devamsa Bosawal, please to file a report. Howrah Municipal Corporation already filed the report.
That is there.
Yes, ma'am.
All right, let it remain. Next
There's
else.
a direction to file affidavit in opposition.
All right.
I have got the my lord affidavit reply.
All right.
Matter is now ready.
Very well. Next.
And for the petition. Matter is-
This is a contempt application where your lordship wanted to hear the.
Oh, this matter is coming up day after day. Now something has to be done with this. The Supreme Court is very strict
Yes,
with
my lord,
regard to
I-
unauthorized
the Supreme Court and
constructions.
the judicial bench order, my lord.
And Supreme Court says that it cannot be regularized and it has to be demolished and there is no way out.
My lord.
So it has to be demolished. This is the only order that court can pass.
And
Lord,
my lord, I have
indicate, my lord.
brought the judicial
Yes,
bench,
give-
legal bench.
My lord, I'll indicate, my lord.
The-
My lord, and the alacrity on the part of the petitioners is also, my lord, not lost without, my lord. My lord, those
The
judgments, my lord, will come to, my lord. I'll just place
before.
before, my lord, the factual matrix, my lord.
No, this factual matrix
My
has
lord, I
been
will,
placed
my lord,
time
I
and
will,
again.
my lord, pray, my lord, that, my lord, at least, my lord, that the certain orders, my lord, this matter has a different trajectory in the sense, my lord, this can be differentiated from the other matters where, my lord, the honorable division bench, my lord, was also pleased, my lord, to appreciate that, my lord, a practical solution has to be found out in the matter, my lord.
No, my lord, judicial bench.
So,
already-
my lord, these orders, my lord, of the honorable division bench, my lord, for my lord's convenience, I've just, my lord, prepared a compilation, my lord, so that I'll just place these.
All
orders.
passed in this matter?
Yes, ma'am.
What
All
about
right,
my-
these orders
No.
must be here.
Maybe, but just for my lord's
They
convenience, my
challenge
lord, I've
the interlocutory order passed by
my
your
lord,
lordship
this
in
first
contempt
order, my lord,
jurisdiction.
will be pleased to take, my lord, of 12. My lord, no, my lord, this alacrity on the part of the petitioner is not lost without sight. My lord, he is the land dealer. My lord, if I have to, my lord, he is the person who got us to purchase these lands. And now, my lord, since he runs a nursing home from there,
can
and
sound
now
also
since I
that
didn't, my lord, pay attention to
my
what he
petition-
demanded,
my-
this is what he's doing in court.
Yes.
My lord, let
please.
this also come, my lord,
We are the
before my
wrongdoer,
lord.
you
My
are
lord, I'll put it on
wrongdoer.
affidavit.
What?
My lord, he was the dealer who got us to purchase these lands.
Yes.
Nor we did not dance to his tunes. That is why he did
No,
what he's
the
trying to do, my
wrongdoer
lord,
is
in court.
shouting before this court.
I can put it on affidavit, my lord.
Yes,
My
what
lord,
you have
my
done.
lord will be pleased to take.
1 minute. You are putting it in affidavit will not improve your case.
No, my lord, not on that.
Fact remains there is an unauthorized construction which has been detected.
Great, my lord, I bow down, my lord.
Nothing else.
No, my lord, this petitioner is jumping all the time on this, my lord. My lord, his role, I can also, my lord, come before my lord.
Yes.
What is his role, my lord? This shadowy role. My
cannot.
lord will be pleased to take, my lord,
cannot.
12 December
He is the private
2023.
respondent and it is
My lord,
this.
12 December 2023, my lord. My lord, if I may
Yes.
kindly please.
Yes, yes.
My lord,
Well, kindly see
my
the
lord,
final order of the
my lord, the
division
my
bench.
lord,
But
in
but
the appeal, my
Margaret,
lord.
they challenge your
December.
lordship's order passed in contempt
Yes,
jurisdiction.
yes, you have annexed everything here.
Now, my lord,
It
this
is
the
here,
final
it is
order,
here.
This is the final
My
order.
lord,
for
my
this.
lord,
It is here.
my lord, the next page, my lord, page internal page 2.
Yes.
My lord, it appears, my lord, after in re mat such and such.
Yes, yes, yes.
My lord, raised at the instance has been, it appears from the records that some portion of the unauthorized construction raised at the instance of the appellants has been removed. However, some unauthorized portion, my lord, still remains. Mr. Such and such learned advocate representing the Nadia Jela Parishad on instruction says that the concerned locality is highly populated and congested. The buildings are situated in a very close proximity, leaving very little space between the buildings. As per the report of the executive engineer of the Jela Parishad, any attempt to demolish the remaining unauthorized portion may result in the entire building collapsing or damage the neighboring buildings or even may pose serious threat to human lives. Hence, letters such and such were written by the Jela Parishad through the executive engineer, PWD, Government of West Bengal, Nadia Division, seeking his intervention and advice in the matter. Next page, internal page 3.
Yes,
As regards
yes.
how to demolish the remaining unauthorized portion without causing loss or damage to the neighboring properties or without putting at risk human life. We are facing a practical problem. Unauthorized construction must go. However, the authorities must also ensure that no undue incident happens causing loss of life or damage to property in the course of removing such unauthorized construction. We feel that such and such may, my lord, presence may assist the court in coming to a practical solution. So, my lord, the intention of the Honorable Division Bench was for a practical solution. My lord, the next order, my lord, 15 December 2023.
It was disposed of.
Yes.
My lord, appeal was disposed of, my lord, in 2024, my lord.
Yes, the date is.
My lord, 15/6/2024.
All right.
25/6, my lord.
25th, 6,
My lord, the next
2024.
order, my lord, 15 December.
Yes, yes. Don't read all the orders.
So, my
but
lord,
then
just my lord, just to indicate, my lord, because several reports were filed.
Yes,
pursuant,
yes.
my lord, these reports were pursuant to the orders, my lord. My lord, I just,
25th of June 2024.
my lord.
Please read that.
My lord, I will. My lord, if my lord permits me, my lord, to go through, my lord, two more orders, my lord.
No, I have read it just now.
My lord, 15 December order.
Yes, yes, I have
So,
read
my
it.
lord, 15 December. I'll just, my lord, trouble my lord with one portion, if I may please. My lord, due local inspection, my lord, as to how demolition of the unauthorized portion can be affected without adversely affecting the authorized portion. My lord, without adversely affecting the
And without affecting the stability of the building concerned. Tell me one thing. How far is the next building at the adjoining building to this unauthorized construction? What is the distance?
1 foot.
No.
1 foot?
1 feet.
4 feet from his,
No.
my lord, house.
1
4 feet from my lord, there's a road,
No.
PWD road, and then my lord, my land starts 4 feet from his house.
This is my lord.
Leave his house. Is there anything else
My lord,
by
I'll
the
indicate,
side?
my lord, one is 4 feet. Then there is the front portion. My lord, there was certain construction which is removed, my lord. And then behind my lord, at the back side, there's 3 feet space left. And my lord, on one side, there was an old building. So my lord, since there was an old building, so that has come up, my lord, the wall is next to the wall of the old building because otherwise, my lord, the construction, and they are not complaining also. My lord, the construction, the old building, my lord, would have been in trouble, my lord.
Not that.
If the construction.
I can show that there is only 1
My lord,
feet
my lord.
gap and my lord, kindly see.
You are there in one side.
Number 5.
Yes.
My signature was surreptitiously procured by the petitioner. My building is just and next door.
But now this is
respondent.
how
And you are not
I
agreeing.
Principle of one issue. If his building is directed to be demolished totally, my building will suffer definitely.
All right.
I can't escape.
All right.
Well, kindly.
That is why.
But now, what happened? How? I do not know. Under what authority he is appearing, I do not know. That is another question. I do not.
Come hand in glove with this person.
Now he is.
Similarly, I can't come hand in glove with petitioner also.
But
This
kindly.
petitioner even doesn't have any sanction plan in respect of his building.
In the contempt, how many petitioners are there?
My lord, 7, my lord, subject to.
My lord, total 7.
7, my lord.
Contempt.
Contempt 7.
And who is he representing?
Number 5.
5.
Number 5, my lord, kindly see, writ petition was filed, order has been passed, nothing was mentioned. Now he is coming now today, he is saying that the petition number 5 did not put his signature at this stage. Well, the division bench, before the division bench, nothing. Then my lord, kindly see how he mixing with the private respondent, making this allegation. But kindly see the division bench final order. What
I have
division bench-
seen the division bench's final order.
My lord. Now, my lord, the division
Tuhin
bench-
Shah.
Tuhin Shah.
Yes.
He's the one of the petitioner.
Is, my lord,
How he can say this now?
was also appreciated by the honorable division bench that his building was
No, nothing. No mentioning is there regarding his house.
based on pillars. If all the
No,
pillars
there is a direction of the division bench to ensure that the adjoining buildings are not.
Kindly see the final order. This is the interlocutory order, my lord. Kindly see the final order. In the final order, the division bench specifically mentioned that unauthorized portion to be demolished. Well, may I read this?
Yes, I have seen it.
My lord. Then division bench, my lord, when I have mentioned before the division bench, president of my lord, Jamal
Paragraph
Bakshi.
number 7.
Yes.
They had issued several directions for
Can I see?
demolition. These directions, sir, we have no reason to interfere. Now we direct the reports to be
This is the
placed
interim order.
for demolition of the additional area unauthorizedly constructed. And appellants are at liberty to intervene and assist the court in demolition of the area unauthorizedly constructed. The division bench is also saying for demolition of the unauthorized construction.
Yes, my lord.
Right.
My lord, kindly see.
So what more remains? A few pillars.
See, my lord, out of 24 pillars, 16 pillars is unauthorized.
Yes.
But this is the report. My lord, your lordship already got the report.
Hmm.
But kindly see, but more than double portion is unauthorized.
Hmm.
But this is the report they have said. May I read the report last paragraph? The sketch map of the present structure has been prepared by the engineer. The map of the building has been prepared, which shows the demolition line and already demolished part. The original approval plan was without any basement, but in the field, a basement has been constructed. As technically demolition of the basement is not possible without demolition of the whole structure. Particularly, the basement has been made unusable by filling earth into its totality. The total number of concrete column of the building is 24 as per field inspection, but total 19 column have been shown in sanction plan during the construction of the building. Sri Vishwanath Ghosh and Sri Ranjit Ghosh constructed 16 concrete column
My lord,
outside the sanction plan.
My lord, should I give a
Kindly
copy
see.
of what he's reading, my lord?
It must be here.
My lord, my lord, I just.
What is the date? Give the date.
My lord,
the
it's
date
on
of 9th
proceeding of 9
January
January 2024. My lord, person
All right.
15 December.
Thereafter also several reports are over here.
That is report is another report is there, but
My lord,
so far as the
my lord, because I would also pray for relying upon this.
so far as unauthorized construction is there, my lord, out of they have mentioned, my lord, out of total construction they have constructed phase 2. My lord, kindly see. But they have constructed the sanction plan is 539 square meter, but they have constructed, my lord, more than double 1098.67 square meter, double the, my lord, whatever sanction, more than unauthorized portion is there. So they have constructed at their own risks. Now, my lord, when the demolition order, your lordship has to pass the demolition order. Now they came and wanted to put into their leg in the contempt petition. And that ultimately they preferred appeal against the interlocutory order passed by your lordship. But when the matter came up before my lord Justice,
my lord, since
Jamal Bakshi, division bench, as soon as I mentioned that
yes,
my lord is perusing that report, my lord. My lord, internal
But
page
as
two,
soon
my lord,
as
there is a
mentioned-
table. If I may just
1 minute. You do not make any further submission. It is he who has to defend. Yes.
If my lord is pleased to take paragraph 6, my lord.
Yes,
It
please.
has been discussed such and such, my lord, paragraph, my lord, subparagraph 8. My lord, there is
Yes.
a table below that.
Right.
My lord, unauthorized area is 292.26 square meters. My lord has been pleased to take.
Hmm.
My lord, I have demolished the entire third floor, which is 228.29.
Hmm.
My lord, my basement has been entirely filled up with soil. My lord, I will show those reports also which have been filed, my lord, pursuant to my lord's directions. So, my lord, after that, my lord, and my lord, portions, my lord, of which was on the road, my lord, that has also been removed. So, my lord, now it is very a negligible portion, my lord, which again, my lord, if we have to, my lord, the entire building will come down, my lord, and also the, my lord, adjoining premises will get damaged. My lord, from 292.26, my lord, we can deduct, my lord, the entire third floor, my lord, of 228.29. Subject to my lord's directions, my lord, this was demolished, my lord. My lord, basement was covered. My lord, so therefore, my lord, subparagraph B, it is clear that construction has been made on such and such, sanction plan was such and such, my lord, total construction area was such, out of which 267.41 has been demolished, at present 292.26. My lord, after this report, my lord, it was, my lord, next, my lord, paragraph C, my lord, the question, my lord, if I may place the first two lines, area in excess of the sanction plan exists. The question arises whether this excess area can be demolished without creating risk to the existing structure within the sanction plan. My lord, C, my lord, sketch map has been prepared by the engineers. Map of the building has been prepared, which shows demolition line and already demolished parts. My lord, D, original approved plan was without any basement, but in the field a basement has been constructed. As technically demolition of basement is not possible without demolition of the whole structure, practically the basement has been made unusable by filling earth into it totally. Total numbers of concrete columns is 24 as per field inspection, but total 19 columns have been shown in sanction plan. During construction, such and such constructed 16 outside the sanction plan area. Therefore, 8 concrete columns will remain inside the sanction plan area of the building. Demolition of these 16 concrete columns outside the sanction plan area is technically not possible without damaging the structural stability of the whole structure. In the approved plan, there was no cantilever projection of the roof floor slab. All the projected cantilever part has been demolished except at the east side. The projected cantilever part at the east side couldn't be demolished as there is an existing common wall with the adjoining building, which is my representative. Demolition of this part may damage the adjoining building also. Walls within the demolition line have been demolished as far as possible. Therefore, going such and such, that further demolition outside, in bold, further demolition outside the building, sanction plan area without causing damage to the stability of the whole structure is beyond our technical expertise. Pursuant to my lord's directions, a report was filed, by the district engineer Nadia Jila Parishad. This was as per my lord's order of 21st November 2024. There area demolished with pillars above G+2 level have been shown, and area not demolished. After that, this entire area was demolished. Pursuant to my lord's order, my lord. So, in my most humble submission, my lord, we've been trying to.
Not demolished, my lord. Not demolished. But,
I've heard the submissions made
they
on
say
behalf of.
They have said the basement has been filled up, not filled up. Only they have poured only 20 to 30 track of mud, soil to the, and only, my lord, they have blocked the door only. Nothing. They have not, my lord.
What will they do? What further they will do?
But they have to fill up the entire, my lord, basement.
Yes, they have not filled up. You
No.
say the report says it has been filled up.
But what they have done, well, honestly, I'm saying that only 20 to 30 track soil has been put in, and they have constructed obstructed the door only. The
Yes.
door they have obstructed the door, not they have filled up. It requires more than 400 tracks because the basement is big, because whole building, those total building, my lord, basement is there, unauthorized basement is there. And now they have filled up only, pouring only 20 track of
Upon here parties, it appears that the authorities have that certain portions of the unauthorized constructions have been demolished, but unauthorized construction which according to the authority cannot be demolished as it would make the entire structure unstable and may cause damage to the adjoining premises. কি বললাম শুরুটা হ্যাঁ
May I refer the judgment of the Supreme Court of our High Court But this cannot be, your lordship knows. Your lordship's order, parent order cannot be changed in any manner whatsoever. Cannot
Still
modify
remains.
the order itself.
Still remains. Stop. ঠিক আছে? The petitioner submits that the entire unauthorized portion is liable to be demolished. Stop. The petitioner refers to, show me the judgment.
I'm saying
The judgment delivered by the Honorable Supreme Court
I'm giving
in the matter of
2006 1 SCC 613 paragraph 2 and 6.
name of the parties.
But name of the party is the Union of India versus Subedar Disase PV report. Yes, but I'm giving the book. I'm giving.
এই ইন্টারনেট
Is that-
কানেকশন এসছে এখনো আসেনি না 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 সে তো ফোনে দেখতে পারবে কিন্তু ইন্টারনেট কানেকশন দেয়নি এখনো কাজ চলছে
613, 216 paragraph.
আচ্ছা ঠিক আছে হোয়াট ইজ দ্য ইস্যু ওভার দেয়ার
Issue, I'm giving you. এটা কোন ইয়ে লেখা?
আচ্ছা সাজান সাজ ঠিক আছে তারপর হচ্ছে
one SCC. But I'm giving this. One SCC.
the
Section 9 একটা order challenge করে।
reliance has also been placed on the judgment delivered by a coordinate bench of this court এটা বলে দিচ্ছি আগে এটা লিখে নিন হ্যাঁ bench of this court on 9th January 2025 in Mat 397 of 2024 with Can 2 of 2024 397 Can 2 wherein the court held that the scope of contempt jurisdiction is to see whether the order of the writ court has been complied with in substance or deliberately flouted, leading to an inference of a willful থেকে quotes শুরু হচ্ছে willful, deliberate and contumacious quotes close violation of the order of which non-compliance is alleged.
Fourteen, 2014. SCC.
While dealing with an application for contempt, the court cannot traverse beyond the order. It cannot test correctness or otherwise of the order or give additional direction or delete any direction. ঠিক আছে আচ্ছা এইটাতে which paragraph did you rely?
This paragraph 2 and 6.
আচ্ছা wherein the court held that it is not permissible for a court sitting in contempt jurisdiction to examine the correctness of the earlier decision which had not been assailed and to take a different view from what was taken in the earlier decision. If the party concerned is aggrieved by the order, it should always either approach the court which passed the order or invoke jurisdiction of the appellate court. Stop. Rightness or wrongness of the order cannot be urged in contempt proceeding. Yes, sir. Paragraph. In the instant case, it appears that the authority has opined that further demolition may cause damage to the adjoining structures and may not be feasible. Stop. Whether the said decision of the authority is proper or not has to be adjudicated by a competent forum. Stop. The correctness of the decision of the authority cannot be adjudicated in the contempt jurisdiction. Step. In view of the above, the contempt application stands disposed of. It will be open for the petitioner to challenge the action of the authority in not demolishing the entire unauthorized construction on the explanation provided by them before the competent forum. Disposed.
Then they will not demolish the building.
You get it done by the writ court. That will be better.
Writ court, but can I go to writ court again?
Yes, yes. That portion you can go. Where the 7 or 9 engineers have come to an opinion that further cannot be demolished.
In view of the order of the division bench, but practically division bench in final order, my lord, they have already, my lord, passed order. The entire jurisdiction has been given to your lordship to decide the issue.
Now this cannot be decided in the contempt.
Division bench, but kindly see. Then
next, please. Yes.
My lord, kindly peruse my lord's last order dated. May 26th.
Yes.
But there was a direction that identified
Jana Babu, this will be the. Yes.
Kindly peruse my lord last order.
Yes.
The proposal is here but from the municipal.
Give. You have identified some place.
बड़ा कॉपी दे दो ना
ये दे दिए
You have a copy? See one thing. It says that the saplings will be distributed. Distributed to whom?
Distributed, Milord, they will be planted, Milord,
In three
places.
but the municipality will plant it. Not rely upon somebody else to plant.
Municipality will be planting, Milord, it will be distributed equally, Milord.
All right. Please come.
issue.
A report has been forwarded by the chairperson of the South Damla municipality signed on 9th July 2025, wherein 3 different spots have been identified for planting the saplings, for planting 100 saplings of mahogany, shishu, mango, akashmoni, etc. They can even. The project is reported to be completed within 31st July 2025. Stop. 31 July. The contender is directed to proceed to act in accordance with the report. Stop. Let a further report be placed before this court on 28th August 2025. Stop. Photographs of the plantation that has been made shall be produced before the court on the adjourned date. Stop. The saplings shall be geotagged so that the same can be monitored properly. All right.
My lord is taking help of technology.
You take help of this. Give a copy to him.
Yes.
Keep an eye whether these are being done or not.
Yes,
if
yes.
it is not done, please report.
Yes, absolutely. Now I understand why the price of mango is so high. 100 rupees for a tree.
Yes.
I beg to appear, ma'am.
335.
My lord.
All right. Yes. Your other side is here.
But I have, my lord, communicated after yes, my lord, this.
Thing is, you are mentioning for upgradation. Your other side may not be aware that you are upgrading the matter.
My lord, kindly appreciate this.
What?
I have, my lord, made my WhatsApp communication in that.
When did you communicate?
My lord, after my lord mentioning today.
Today?
Today, my lord.
To whom did you communicate?
Chairman of the Pujali municipality.
And the chairman will, today morning you communicate and the chairman will be represented. What is the allegation?
My lord,
What is the allegation?
my lord, your lordships, my lord, passed the order.
Yes.
My lord, my allegations, my lord, on 14th of June 2023.
Yes.
My lord, constructing the private respondent, the illegal, my lord, wall, and completely blocking my ingress and egress. And my lord, this hearing has not yet been, my lord, conducted.
Yes.
Repeated occasions, my lord, only that point, my lord.
Next Thursday upgrade.
My lord.
Yes, serve notice.
My lord.
Yes, call the next matter.
I am for the petitioner.
Hey, Pradeep, write one line. The matter citing urgency. List next week. Notice. Communicate notice be issued. Yes, please.
I am for the petitioner.
Yes.
No, I am for the arrest committee.
Order complied?
Order has been passed for demolition, but in 160A as per Panchayat Act, hearing officer is required.
What is required?
Hearing officer.
Yes.
In the Jila Parishad. We have notified more than twice.
No hearing officer is there.
There we have requested the Secretary Government of West Bengal Department of Panchayat Rural Development Department to take steps outside state, outside the district. But no steps till date. We so many matters are pending, but in such situation, 3 or 4 content matters is pending. But what to do, we are not in position to follow the rules. If we done something, subsequently we appointed secretary of the Jila Parishad to act as hearing officer. That order was passed by the honorable. Because the secretary is also magistrate. He has some experience. We want that he would act as hearing officer. But the retired persons are not coming for to act as hearing officer. This is the problem. So I will kindly see the order. I have passed. We have the Jila Parishad passed.
In the meantime, private respondent raising construction matters, raising high building.
If you not say direct,
the
we can do but reminder has also submitted. This is not previously.
With reference to the work done.
One content was pending as the matter of time.
This private respondent is also requested to act in terms of the above order. Who is this private respondent? He is making the construction. Private respondent is making construction. Nabukumar Maiti.
Yes, ma'am.
He is making construction. What is to be done?
Your lordship is ready to comply with your lordship direction.
Secretary, yes, please.
Allowed.
No, there is no hearing officer. Who is going to hear? This is the problem.
Your lordship order should be complied.
By whom? It has to be complied by a particular person.
Notice for hearing.
There is no hearing officer. Difficulty is this. So, Secretary, if the
will not comply.
Secretary is the Purva Mendipur Jila Parishad, can he comply? Can he? Is he acquainted with these matters?
Lord, he appointed we have once upon a time we appointed him. Jila Parishad appointed him as hearing officer, but that was also passed by the honorable court.
Obviously, because he is not the competent authority.
He is not a retired person.
Right. Not only retired person, he is not the competent authority also. 1 minute.
Towards side, we have notified. One person was agreed, but subsequently he appointment letter was issued him, but he disagreed. No, I will not.
Please take down. It appears from the submission made on behalf of the parties that the that the order of the court cannot be complied with in view of non-availability of hearing officer as required under section 160 caps A within bracket 6 of the Panchayat Amendment Act. Oh, 160A.
168.
160A within bracket 6 of the West Bengal Panchayat Amendment Act 2017. ঠিক আছে? Let a notice be served in the office of the learned government pleader. Stop. The stand of the Department of Panchayat and Rural Development with regard to appointment of hearing officers shall be placed before this court on the adjourned date. Released next Thursday.
In the meantime, no further construction. Otherwise, they are during the pendency.
There is already an order not to construct.
Further new construction.
Yes, I can understand. Call the next one. Immediately communicate this to the GP's office. Let us see. আচ্ছা এটাকে একটা কাজ করুন তো জিপি না করে এজি কে করুন in the office of the learned advocate general.
Your leadership in 451, Mr. Mukherjee is leading us.
I am appearing on behalf of the respondent.
Yes, ma'am.
We were supposed to, my lord, file the affidavit of opposition in the matter, my lord, sometime in the first week of March, my lord. The opposition is ready. May I hand up an advance copy, my lord?
But we are in the mid of July.
My lord, there is some delay, my lord. I will be candid to your lordship, my lord.
Yes.
Your lordship will kindly condole the delay, my lord, in filing. My lord, this is an important matter. May I hand up copy of the opposition?
What is this? This is a writ petition.
Yes, my lord, your lordship recalls, my lord, this is, my lord, the doctor's choice. Your lordship's, my lord, first order is also there. My lord, 12th of February, my lord, they were selling, my lord, a product, my lord, by saying it's doctor's choice, which cannot be done, my lord, for food, my lord.
This is a oil or
The
what?
Food Safety Act.
It's oil, my lord.
Oil?
Edible oil, my lord.
All right.
Edible oil.
Different types of oil, my lord. Mustard
All
oil.
right, yes.
So, my lord, we had mentioned because, my lord,
Hearing.
my lord,
Is it for hearing?
No hearing. This is the application.
my lord, this is an application we made. My lord, 2 prayers we had since they were not filing their affidavits.
That has come in.
Now, my lord, one is, my lord, the affidavit has come. Second, my lord, there was a document, my lord, which we had handed up, my lord, during the last hearing before your lordship, my lord, to show what they had, my lord, written.
Yes.
My lord, that, my lord, we have included here, my lord, so that it's taken on record formally. Your lordship has said
All right.
16, my lord. Kindly have a look at it, my lord.
And has that been handed over to your learned friend so that he can?
Yes, my lord, they have, my lord, they have.
The application, my lord, they have. But if your lordship formally takes on record, my lord, then that in that event we will, my lord, later deal this document. My lord.
You have not dealt with.
We have not dealt with this particular document. But in any event, my lord, this is a.
Which document?
This is
My lord,
the,
kindly have a look, my lord.
This is the document seeking opinion, my lord, from the
My lord, what has happened? My lord, the only reason, my lord, today jurisdiction is not being exercised, my lord, under the act, my lord, is, my lord, that this is a trademark and we don't have jurisdiction. My lord, the definition, my lord, if your lordships have, my lord, a look at, my lord, the definition of label, my lord, it includes, my lord, a brand, my lord, a mark, my lord, everything. My lord, this is, my lord, under, my lord, the.
No, today we are not hearing,
Yes, my lord.
right? So let the affidavit in opposition be taken on record. You file your reply
Yes,
within a fortnight.
Yes, my lord.
All right.
My lord, the affirmation has not been done. So, my lord, the
Affirmation?
advance copy, my lord, I have. My lord,
You are
the
providing advance copy.
copy, my
When will you affirm?
lord. Today itself, my lord.
It's already 4:15.
I am told that client is here, my lord.
They are in the line.
My lord.
Very well, ঠিক আছে। তাহলে ফাইল হবে না। Advance copy has been served. Leave to file in the department.
I will do that.
And reply within a fortnight. and the document relied upon by the petitioner.
Yes, my lord, it's at page 16. It's already in the records. My lord, we had handed it up
All right.
during the course of hearing.
Then what is the use of recording it further?
My lord, because my lord, nobody was coming up. My lord,
Yes.
my lord, kindly.
So now they are aware of the document. Then we are not recording.
We
Leave
will
to
contact that
leave
this
to mention
authority
the
does not
matter
have
for
jurisdiction
hearing.
to refer the matter to the petitioner.
Leave to mention the matter for hearing before any other bench having determination.
My lord, your lordships, my lord, not taking up. My lord, I know, my lord, but my lord.
And these matters are so time consuming, my list
this
gets
won't be,
blocked.
my lord, I can.
No,
This can
please,
wait. My lord,
sorry.
this matter can wait because we are registered marks in 1999. My lord, 1999 registration, they have now come up. My lord, they have come up after, my lord.
My lord, it's a.
Decades, my lord, I think.
My lord, doctors have moved this because of, my lord, what is happening.
That
Doctors
does not
said-
appear, my lord, from the writ petitions.
That's the
Yes.
society.
All right. Call the next one.
My lord, then kindly, my lord, just for sake of, my lord, if your lordships, my lord, giving us liberty to mention, kindly give me prayer A also, my lord, so that there's no.
What is prayer A?
Is to bring on record the letter at page.
Yes, prayer A made in the application stands allowed.
Obliged.
449. Great.
Yes.
So I appear on behalf of the petitioner.
Yes.
Being led by Mr. Anirban Rai, he's appearing online.
Yes.
So this is a restoration application. The writ petition
I
is
am the
dismissed.
Union of India.
With my writ petition, tell Mr. Subbibi.
You don't appear at the time of call, and then you mention the matter for citing urgency and come up for restoration.
Urgency, Your Lordship, I filed a restoration application. Your Lordship, it was my fault. We didn't appear. Your Lordship,
Yes, so if it is your fault, take the responsibility.
I do take my responsibility. Your Lordship, we have failed to appear when the matter was called on, Your Lordship, but we have immediately filed the restoration application. My Mr. Ray is online, Your Lordship.
Registration it is our fault. I can't say anything else. It's our fault. Lawyers, we miss. That is our fault.
And so many, not one.
Lordship, I am aware. I'm aware. There
Then?
are many.
Yes, so what is to be done?
Lordship,
What is the writ petition about?
The writ petition involves a question where an application under 434 of the Companies Act for winding up, which was pending before this court, was transferred under law. Because after the CIRP, it goes to the CIRP. After the IBC, it goes to the NCLT. But what they have done, once it went there, immediately an order was passed under Section 7 without any Section 7 being there. It was contrary to the filing, and it was without jurisdiction. Therefore, we have come before your lordship seeking for a for adjudication on that point, because whether the NCLT can assume jurisdiction without following the transfer rules. Under the transfer rules, it has to go there, and again, fresh CRP process to be started. But what the tribunal did, it immediately, without even hearing us, no notice given, pushes me into resolution process, This is the scope of this application,
Well, then the matter has to be decided. Let it
Yes,
be
yes.
30th June 25 restored, recalled and restored and can disposed. List in the combined monthly list of August. Yes, next.
My application. Lordship was pleased to issue rule in this matter, and thereafter on the returnable date, when the alleged contender appeared, your Lordship was pleased to direct him to file a report how it has been complied.
Where is your other side?
Mr. Subir Bhattacharya is appearing. I had a talk with him personally. Told me he will be coming, but now I don't find him. He to kindly take it around next Thursday.
Right? It was your responsibility to bring your learned friend.
I know, my lord. That is why I told him. He agreed he'll be coming. But what can I do more, my lord? The next Thursday, my lord, I accordingly inform him again. Lordship's direction was to the administrative secretary of the comprehensive area
Yes.
to forward my
Edition-
application to the Honorable Governor. That is the complaint of the under Rule 34(1) of WSR.
And the state does not have a role over here. The matter has been mentioned, citing urgency. Let notice be served. Upgrade next week. Yes.
Grateful, Lordship.
Lordship had mentioned the matter. Lordship had asked me to read my learned friend, but he
No role.
he has not been served. But
I have not been
Lordship, this is the
can
Devin?
contempt application, my lord.
Lordship,
Who is the contemner?
is
Executive engineer KMC.
executive engineer KMC.
She is not appearing for KMC. What is the
But
use?
the department told me that I had served on 4/4, Lordship. May I then serve again and let it be upgraded for the next Thursday, Lordship, but whatever, Lordship, because this is my affidavit of service, Lordship. Lordship, I have served on 4th
What
of
was the
April.
direction of the court?
Lordship, the direction of the court was to come, Lordship comes to page 101. Last but 3 paragraphs, Lordship.
Yes.
A spot inspection shall be conducted to ascertain the nature and extent of unauthorized construction. The event therefore should respond.
Has the spot inspection been conducted?
Lordship, it has been conducted in a very whimsical way. No report has been served. Notice of hearing was given to me, but they could not identify the alleged person who has actually encroached and done the needful action. Lordship, in my deed, the measurement is something else, and they are telling me it is something else. There is a big dispute regarding. Let the contemner come and place it before your Lordship.
Very well. Same order. Citing urgency mentioned. Next Thursday upgrade.
Lordship, may I serve it again, Lordship?
Yes, yes, please serve.
Deeply obliged.
Next.
My lord, I beg to appear on behalf of the respondent. My lord, I object to the extension of interim order. I am ready with the hearing, my lord. My lord, kindly
My
have-
application,
the delisting had been done properly, following all the rules. So we,
May I, my lord?
my lord, we are against, my lord.
Let him place at least
Milord,
what he has
Milord,
got to
Milord.
say.
But kindly have a look at page 24. Lord, my delisting was an issue because this was done beyond the period regarding which I had a defect liability. That period was over. Goods were found. Your Lordship will have a look at page 12. 10th March Unbelievable. Page 12, 29 January 2020.
Page 12 of what?
Of the application, not sorry.
Can 2?
Yes, not can 2.
Yes. Page 12.
29 January. Lord, my learned friend was also here. There's a detailed order where your Lordship has considered why at paragraph 4 from the documents annexed to the writ petition, there is nothing to suggest the defect which the respondents found with the goods of the petitioner was intimated within the aforesaid period of 30 days. The authority found the goods supplied by the petitioners to be defective and has delisted the petitioner for a period of 1 year. Out of the 1 year period, nearly 4 months are over. In the meantime, the appeal preferred by the petitioners to dispose of by passing a one-line order without giving any reason. Paragraph 6, my lord, prayer has been made by the petitioner to permit them to participate in the tender which has recently been floated by the respondent on due to close on 30th January 2025. Lord, your Lordship discusses how the order was cryptic and kindly have a look at paragraph 11. As an interim measure, the petitioner shall be permitted to participate in the ongoing tender process, namely so-and-so floated by the respondent. My lord, the same thing, your Lordship will kindly have a look at the order of 10th of March, which is not a part of the application, my lord, but your Lordship
But
has
it must
passed
be
that.
here. Yes, 10th of March.
Because I filed an application, my lord, saying that there are other tenders which are ongoing in this writ only, my lord.
Yes, yes.
Paragraph 4.
Yes.
In the meantime, the petitioner shall be permitted to participate in the future tender processes, subject to the petitioner being eligible for the same. So however much he clamors now, these two interim orders are there. He has not preferred an appeal, is accepted. Two things have now happened. They're not allowing me to participate even in matters where I'm otherwise eligible. I'm not being allowed. Secondly, my lord, in tenders where I've been declared as a L1, if your Lordship looks at, my lord, page 15, I'm sorry, page 16, my lord.
Yes.
The copy has not been served. The copy has not been served.
Can 2 not served?
No, my lord.
No, no, it's been served. No, it's received by him on 7th of July 2025.
Yes.
হ্যাঁ হ্যাঁ
Page 16.
এটা কোথায় দেখা যাচ্ছে
আমি তোমায় দিয়ে দিচ্ছি আমি জাস্ট
Page 16, are you relying upon list of tenders participated?
Yes, Manoj. So these are list of tenders participated showing L1 and L2 status.
Yes.
Your Lordship will find for the first, all of them, 1, 2, 3, 4. Then again at the bottom, again CR stores, L1, and all these have been found to be L1.
Yes.
They're not issuing the tender contract to me now with the observation that court order submitted, not yet finalized or decided.
Hmm.
So despite the order where I'm participating, and now they're,
সরি আরে আমাকে অ্যাপ্লিকেশনসটা দেয়নি তুমি দেখো এক লিখেছো ওতে can 1 লিখেছো in my application you have stated as can 1 not can 2.
No, that must have been a misprint. Or just sort that out.
So please.
Have you? No, it was served. No? You've not given can 2? Can 2 has only been given, it's been numbered as can 1.
Let me see. Let me see.
That's one bit of it. No? The second your Lordship will see where page 17 onwards, where I'm not even being allowed to participate in terms of your Lordship's order now because it is pending. Also page 20, kindly see. Financial position so and so, RA complete, participated, not eligible to participate in RA due to delisting. This is absolutely in the teeth of your Lordship's order. Contempt I'm filing separately, my lord, but page 20, kindly see, not eligible to participate in RA due to delisting. Participate in RA, not considered not to participate due to delisting. Today my learned friend comes and screams in
Yes,
court.
please.
My lord, as to this, my lord, I have to take instruction. It had been served only yesterday. But my lord, I would request that delisting has been done properly. Though this order is there, so there is no appeal, my lord.
So listen, it is your order. You will always support it. It goes without saying. Now, whether it is proper or not, it is before the court. So by the time the court decides, why are you stopping him? There is already an interim order.
I have to come up with instruction because it has been only been told over
No
court
question
and
of
has been
instruction.
served.
As long as the interim order remains valid, you have to act in accordance with. Otherwise, you prefer an appeal. Or you get the matter heard because you are suffering an interim order and they are enjoying it. Why don't you take steps to get the matter heard?
My lord, kindly fix it any day. I'm ready to.
This bench is not hearing matters under the hearing group. Motions I'm trying to finish up as much as possible. Right? So this matter requires hearing and you have filed your opposition and everything, reply is also ready. So it's a hearing matter. Why don't you take up before any bench having determination, get it heard and finish it off? Right? In the meantime, do not stop the petitioner because you'll be
Let me come up
flouting
with
the
the
court
instruction.
order.
Let me come up with the
What instruction will you take?
Lord, I don't know. It is the record speaks of that they are not being allowed in spite
Please.
of the order.
Yes.
My lord, but
And in matters where I've been given L1, my lord, pursuant to your
Please
Lordship's
come,
order,
Pradeep.
the tenders be issued in my favor. They don't challenge the order, nothing.
By interim order passed by the court, the respondents were directed to permit the petitioner to participate in the ongoing tender processes.
Initials to that.
Stop. The petitioner has filed an application to bring on record that despite being the L1 bidder, contracts are not being executed. With the remark, participated/court order submitted, not yet finalized/decided. Stop. Paragraph. Remarks are also made that the petitioner participated/not eligible to participate due to delisting. Next, the act of the authority is contrary to the direction passed by the court. Stop. The petitioner is protected by an interim order which has not been appealed before the superior forum. Stop. The authority would be bound to permit the petitioner to participate in the tender processes till the order passed by this bench is either set aside / varied or modified by any superior forum. Stuff. Next, the authorities are directed to take steps accordingly. Can disposed. Leave granted to the parties to take steps for getting the writ petition heard before any other bench having determination.
Only one request, no, Lordship will direct them to issue the work orders in terms of that order. So that's my specific prayer in the application.
As the petitioner has been found to be the L1 bidder in many of the tender processes, necessary subsequent steps in furtherance to the same shall be taken by the authority. Stop. Next. Yes, call.
Very great.
519.
This is my application.
Yes, please.
My lord, your lordship, my lord, had passed and my lord, this is my lord, may I just indicate? This was your lordships would recall, my lord, 4 times we've, my lord, been before your lordship. My lord, this related to, my lord, banning. My lord, my client, my lord, was banned, my lord, by Coal India for 2 years, my lord, for, my lord, dealing with, my lord, their, my lord, tenders, which are, my lord, of 2 categories. One is bulk explosives and the other, my lord, is cartridge explosives. Now, your lordships, in the first round, my lord, your lordships, my lord, passed an order where we challenged the, my lord, principal banning order of 2nd July 2024. Your lordship's order is of 20th January 2025.
Yes. Yes.
That's, my lord, at page 910, my lord. Or 976, Annexure 1, page volume 5, my lord, page 976.
There is an application. The application runs into so many volumes.
My lord, we've annexed the whole, my lord, because of the...
Whole means the whole writ petition.
Yes, my
all
lord.
over again.
No, my lord, I am, my lord, I am
ready for hearing.
No, that I know. But my lord, what has now happened while it's pending, my lord, they have issued a pre-NIT.
All right.
For, my lord, discussions, which means, my lord, that for, my lord, the bulk explosives, the notice inviting tenders, my lord, will happen anytime. Which is why we moved this, my lord, so that, my lord, this order which your lordship passed, my lord, to protect me in the first instance, my lord, is passed here. I'm just showing your lordship, my lord, that order. My lord, kindly come to, my lord, page 976.
Give me the order date. I'll check up from...
My lord, it's 20th January 2025. Separately, Ache. You have it separately.
529 writ petition.
Yes, my lord, it's also at page 529, my lord.
525, 9 of the writ petition.
এত মোটা করে
Yes.
My lord, kindly see, my lord. Kindly come straight away, my lord, to the last page, 976.
Yes. Yes.
978, my lord.
529 you referred?
Yes, my lord. 529 is also at 531.
531, yes.
Kindly have a look at para 11, my lord.
Yes.
In the meantime, if any NIT is published, then the petitioner may be permitted to submit their bid, and the fate of the bid submitted by the petitioners will be subject to the fate of the representation filed by the petitioners seeking review of the order of ban. So, my lord, we had applied for review. My lord, an order was passed. My lord, it did not address, my lord, the issue of proportionality at all. Your lordship, my lord, set it aside. And my lord sent it back again. Now, my lord, they passed an order giving an interpretation which is contrary to your lordship's order. So we came back, my lord, before your lordship. That point of time, my lord, only, my lord, the tender relating to, my lord, cartridges, my lord, was an issue. But, my lord, the tender had already been opened. My lord, the day they rejected, that same day, my lord, they opened. Technical, my lord, I was out. So your lordship, my lord, said there was no scope for an interim order when entertaining the writ. So, my lord, we had gone up on appeal. Then, my lord, this happened. When we moved, they said appeal is pending. So, my lord, we went and obtained leave, my lord, your lordship will find from, my lord, the division bench, my lord, to proceed with this application before your lordship. Now, my lord, all that we are saying, my lord, is this NIT which is going to come out anytime. My lord, your lordship has held, my lord, already that the validity of, my lord, the order has to be decided. Your lordship, my lord, has provided for it. They were slightly out of time with their affidavit. Main affidavits are all ready. My lord,
So now it has to be heard.
yes, but my lord, the NIT, if it happens, my lord, then I'm finished because the next 2 years, there's no tender. And this will get finalized, my lord, only in September. My lord, the process starts from now. It gets finalized in September. We'll go and mention, my lord, your lordship, my lord, has indicated it has to, but till then, my lord, without prejudice, let us, my lord, file.
My lord, may I now, my lord, make my submissions?
1 minute. Without prejudice, you will file your applications or they will consider your.
Yes, my lord, that NIT, once it is published, it's not yet published, my lord.
All right.
The pre-NIT has come,
Yes.
my lord, which suggests, my lord, that terms and conditions are settled, my
Yes.
lord, with, my lord, the persons who usually bid. And on that basis, my lord, the final terms and conditions will be settled and, my lord, bids will be invited. I'm out of the, my lord, consultation process. That's pre-NIT. I'm not saying anything about it because the day has come, my lord, and gone. My lord, we had moved, my lord, we couldn't. Now, my lord, all that we are saying is, my lord, when the NIT comes, my lord, paragraph 11, if your lordship sees,
You
that
will be
protection.
permitted to participate.
Yes, without prejudice.
I
My lord, they don't have to give it to me, my lord.
I understand.
My lord, paragraph 11 is, my lord, when your lordship was considering, my lord, that, my lord, pending review. Pending review, my lord, they should be allowed to participate in the tender processes. That was your lordship's order. Then, my lord, the review happened. My lord, banning order was passed.
1 minute. The tender has not yet been floated.
No, my lord. Here, my lord, may I say, my lord, the same issue was, my lord, subject matter of, my lord, this application, my lord, this petition when my learned friend moved for an interim order. Your lordship was pleased not to grant an interim order. Against that refusal to pass an interim order, which was in respect of the cartridge tender, there is an appeal preferred. Now, my lord, they are banned. The banning order is in, my lord, existence. And your lordship has, my lord, refused
No,
to...
the court has to see whether the ban order is
Yes,
proper
my
or
lord,
not.
No, lordship has already decided this. Please see your lordship's order of 10th April 2025.
Now, which page do I get
Well,
that?
your lordship's first order was 20th January 2025, where your lordship said, well, allow them to participate without prejudice.
All right.
Pending review. Now, my lord, then the order is passed in review, and that is challenged. Then your lordship will find this order at page 684. Well, this is, my lord, a very detailed order that your lordship has passed after considering the matter at length.
Yes.
To interfere with the banning at all. But, my lord, only thing that your lordship has said that please consider the doctrine of proportionality. Kindly come to page 697.
All right. Yes.
697, my lord, only thing.
Right.
Paragraph 46 is the only paragraph I want to show your lordship.
Yes.
The chairman CIL is directed to reconsider the prayer of the petition afresh only on the point of proportionality of the order ban of enforced. Because we have imposed a ban of 2 years. Now, it is only on the question of whether it should be 2 years or less than 2 years that your lordship directed. So the banning order was not interfered with. Now, my lord, we have considered this and said, no, the ban must continue for 2 years. Why? The justification is, my lord, today, if, my lord, the ban is not for 2 years, they will be allowed to participate in the tender, and the banning order will have no effect at all. Because, my lord, tender is, as my learned friend pointed out, 2 yearly basis. So, my lord, if today this ban is, my lord, not imposed, my lord, for the period for which the ban has been imposed, then my learned friend will merely participate in the tenders, and, my lord, the banning order will have no effect at all. And, my lord, this is, my lord, the point which was challenged.
What is the frequency of this floating of NIT?
My lord, it is, my lord, it happens once bi-yearly. It may be, my lord, at the end of the second year, or, my lord, in the middle of the first year, or, my lord, 1.5 year. My lord, but every 2 yearly, my lord, there is, my lord, this tender, my lord, floated for explosives. Now, my lord, we have said that if today the banning order has to take effect, and, my lord, some penalty has to be, my lord, ultimately visit my learned friend's client, then, my lord, it must be effective. And, my lord, if today I reduce the banning order period, my lord, then, my lord, they will be allowed to participate in all the tenders. Then, my lord, what is the purpose of banning at all?
All the tenders, you do not have much tender to float.
No, my lord, there are, my lord, biannually, one for cartridges, one for bulk explosives.
Right.
These are the, my lord, tenders that, my lord, they are seeking to participate.
He has already lost one.
No, no.
I have lost.
That is not, my lord. Cartridge and bulk are, my lord, a part of the same, my lord, process broken up in 2 parts.
All right.
Well, that is how it happens.
No, so the one he has lost?
No, not lost. He's challenged that. The challenge
That is his, he has not even found to be successful.
Work orders given.
Work order also given. So he is lost.
That's right.
That is gone.
Now, my lord,
So will that ban not be enough?
No, my lord. With the greatest respect, your lordship has not interfered with the banning order.
I understand.
Your lordship has only said consider whether it should be for 2 years or less. My lord, we have
If it is
considered,
lessened, then he gets a chance.
my lord, if it is less than, my lord, then it has to be less than 1 year. Because, my lord, we are in the cusp of, my lord, the first year and the second year now. My lord, the question is, my lord, then, my lord, your lordship will have to hold that, my lord, the banning order, my lord, for 2 years is not justified. It should be reduced to, my lord, 1 year or less. My lord, that is, my lord, the difficulty. And, my lord, that is exactly what my learned friends sought from your lordships. At the ad interim stage, refused, appeal preferred. Now, my lord, really what your lordships are now being sought to do is to review your lordship's earlier order. My lord, because the question is the same. The point is the same. Now, your lordship, my lord, if your lordship has to now hold, my lord, that yes, I will pass an interim order now, then naturally the question will be then if the facts remain the same, if the, my lord, ultimately banning order or the effect of proportionality remains the same, why not the earlier order? My lord, with the greatest of respect, my lord, this respectfully cannot be done. And my
By
lord,
way of an application, it cannot be done. It has to be heard.
my lord, affidavits are complete.
Yes, I understand.
My lord, may I just take 2 minutes? My lord, para 45. My lord, the same
Yes,
order.
45.
My lord, kindly see last sentence. Banning order was set aside. The impugned order is liable to be set aside and is accordingly set aside. Yes. This is, my lord, the review order. This is the review order, my lord, not, my lord, the first protection which your lordship gave. So, my lord, that there was no banning, my lord, the review order had been set aside. Now, my lord, your lordship directed by this order that, my lord, as per, my lord, the purchase manual, 2 factors have to be taken into consideration to justify, my lord, that banning, my lord, the period of banning. Why the maximum? Because maximum is 2.
Yes, this I can understand.
Yes.
But I don't think there is any scope for passing order in the application. You can get it heard somewhere else.
This is the only issue in the writ petition
Because
now.
that will go back, whatever order is passed will go back to the order which is under challenge.
My lord, may I put it this way? My lord, the order under challenge, I'm banned as of now. My lord, by, my lord, the time they finalize, if the writ petition has been heard and I succeed, then I shouldn't, my lord, suffer. I'm only saying allow me to just participate. That's all. That is paragraph 11. Because, my lord, I didn't.
1 minute, let me just think. Suppose an order is passed permitting him to participate subject to the result of the writ petition. Then what happens?
Then we can't, my lord, proceed to finalize the tender. Effectively, my lord, that will stand in the way.
No, you can. If nothing happens in the meantime, and liberty will be given to both the parties to get the matter heard. So you will also be trying to get it heard so that you can proceed with the finalization of the tender.
Will be to court that, my lord, please stay the tender process, or at least, my lord, representation will make the tender process should not be finalized because the petition is going to be heard. My lord, that is, my lord, going to, my lord.
What is going to happen? Suppose the writ petition is decided in favor of the petitioner, he'll lose the
In
chance.
that case, the ban will be reduced maybe from 2 years to 2.5, my lord, 1.5 years.
He'll lose the chance because the next tender will not be floated within a period of 1 year.
No, my lord, then your lordship has, my lord, had to, my lord, interfere with the order of banning as wrongful. My lord, that your lordship has not done.
That is subsequent.
No, that is already a, my lord, fait accompli. There is no appeal against that order. Your lordship's order of, my lord, upholding the banning order, my lord, that is not appealed against. That has attained finality. Now the only question is, my lord, as to whether the period of ban should be for 2 years or less than 2 years.
As of now, NIT has not been published. It will take some time for you to finalize it.
Yes.
In the meantime, get the matter heard and let him participate.
If today,
no right in favor of the petitioner if he participates, and his participation will depend upon the fate of the writ petition.
But it will not hold up the tender.
Your lordship provides that. It
All
won't
right.
hold up so that we can both, my lord, accelerate the hearing.
All right. That also I can provide. Please come.
My lord, of course, he can participate, but, my lord, his bid cannot be considered, my lord, until he obtains an order in, my lord, the main.
Yes, your lordship will make it clear.
It is subject to the result of the writ petition. Achha. An interim application has been filed by the petitioner seeking a direction upon the respondents to permit the petitioner to participate in the NIT, which is due to be published soon, published in the near future.
My lord, for bulk explosives.
For bulk explosives. Stuff paragraph. The petitioner has been banned from participating in any tender process for a period of 2 years. Stuff. The said issue is to be decided by the court. Stuff. Paragraph. In the
But not
interregnum.
that issue. Well, banned for a period, only the period of banning. Well,
proportionality.
otherwise, well, it will send a
Correct.
wrong impression.
কি বললাম?
Been banned from participating in tender process for a period of 2 years.
2 years stuff. Whether the banning period can be the maximum period of 2 years or not is to be adjudicated. Stuff. Pending adjudication of the writ petition, comma, as an interim measure, the respondents are directed to permit the petitioner to participate in the future tender process subject to the result of the writ petition. Stuff. No right will be accrued in favor of the petitioner only by way of mere participation in the process. Stuff. The pendency of the writ petition will not stand in the way of the respondent authorities to finalize the tender. Stuff. And anything else that both parties are here?
সেটা তো বলে দিয়েছে, bid consider করতে হবে না। I think
My lord, I think both of us will be happy with this.
Both will be protected.
Yes. My lord, Lordship sees, my lord, both of us are smiling. And we've got your lordship also to smile at the end of the day. My lord. You see the
My
pressure,
day
my-
has not ended, sir.
No, I know.
It will continue for
My
at
lord, may I
least
file the
4 more hours.
my lord, may I file the affidavit of
Please
service? My lord?
So the application can be disposed of?
Yes, yes. Obliged.
এটা ফেরত দিয়ে দিন, এটা তো আছে।
And my lord, your lordship, that earlier liberty your lordship had given it to my lord mention
Yes,
before. My
liberty
lord.
granted to both the parties to get the matter heard before any other bench having determination. Okay. Affidavit in opposition, where is your reply? Have you filed a
both
reply?
filed. Affidavit opposition and reply both, my lord.
Reply will be filed by the petitioner.
No, no, reply not. This is affidavit of service. Opposition to whom?
Opposition to the can or the writ?
Oh,
To
to
the
the
writ.
writ petition.
Writ. What about your reply?
My lord,
Is it
we
ready?
have it here. My lord, yes, yes, it's all ready.
আচ্ছা, তাহলে ওই
My lord,
opposition and
may we
reply
file it, my
filed.
lord? It's just
Yes, yes, let it come.
yeah, obliged.
ঠিক
my
আছে?
lord.
Taken on record. Yes, call next. $520? Yes, please give. He mentioned it in the morning and then it was mentioned in the morning. I could see the learned counsel here. চলে গেছে. Anyway, none appears for the petitioner. লিখে নিন। আগের দিনে ছিল না, কিন্তু এটা তো মেনশন করেছিল সকালবেলা। It doesn't matter, লিখে নিন একবার। None appears for the petitioner. Released next Thursday. And not Thursday week. Make it Thursday week. ঠিক আছে, হচ্ছে 31st. Yes, 521.
My lord, I am appearing on behalf of the petitioner, my lord. That is first time appearing in this matter, my lord.
What happened to your hand? Slipped?
Yes, my lord.
Monsoon?
Dislocated.
Monsoon season, you slipped?
Yes.
Dislocated? Take care. Serve. Come back. When are we? 14th of August. Yes.
My lord.
522, my lord, I appear for the petitioner applicant, my lord. The first time, my lord.
Ariel, serve.
523. No, I am for the applicant, my lord.
Same?
Same, my lord.
Yes.
I'm appearing for the petitioner first time, lordship.
Again.
525, my lord, I appear for the petitioner, my lord. The first time. Great.
My lord, though it is first time I served upon the contempt, my lord, due to urgency, it is the electric connection. My lord was pleased to direct them to give electric connection within 3 minutes. That has already been elapsed. On the basis of the submission that it is the my lord, harvesting period, my submersible pump could not be affected. That is why my lord was given the ultimate time 3 months. That has already gone. No
Similar
compliance.
circumstances, similar place.
My lord, total violation and every day, my lord, it has
Let
been, my
me
lord,
hear.
my lord.
At least 5 applicants were there from the same area.
and will all were restrained by the local people. None of the connection has been given. In one matter, contempt was filed also. Perhaps my learned must be knowing. My lord was pleased to not modify or something, some other orders have been.
I don't know.
Direct the district magistrate to consider.
Something, and my lord, in one matter, appeal. So, my lord, let me have a copy of that. My lord, I will take details instruction.
All right.
Yesterday
No
night,
such, I do not have any knowledge. On the basis of
Sir,
I have complied all formalities. There is no such allegation on the basis of baseless.
7th August.
Let me have a
7th
copy.
August. Let a report.
They have not received yesterday night. Report করতে দিয়েছে।
A report. ঠিক আছে? Yes. Next.
14th.
7th.
Well, next day?
7th August.
7th August.
Report. ওই তো কন্টেম্পট ফাইল করবে রিপোর্ট।
আমি
File a report.
I will.
Yes.
Certainly I will, but I must get a copy.
Yes, he'll serve.
Already I served. Again I will serve.
Yesterday night at 10:30, I have taken instruction. My local office, the contributor has not received.
Firstly, he is not supposed to serve in advance.
Certainly.
So now he will serve.
I will serve.
Lordship.
Yes, next.
I pay for the petition. This
Yes.
appearing for the first time, my lord.
Please serve. 14th of August it will come.
My lord, may I take the indulgence, my lord? In a very unprecedented position, my lord, I am mentioning this matter for a leave, my lord. Already in the morning, someone has mentioned this is regarding the Sunrise Towers Association. On 20th is the AGM and election, my lord.
Yes.
My lord, I am filing my
tomorrow.
Lordship, I am also filing my writ petition, my lord.
Why? You are opposing that, or are you?
No. I have a different cause because I was the ex-president.
Yes.
The illegalities that has happened there, including misappropriation of money, and they have restrained me from.
Are you a party in that writ petition?
No, my lord. I'm
You're not a party.
But Sunrise Association is the same party with the same president, treasurers, and all the office bearers.
So tomorrow, if any order is passed, then what is going to happen?
My lord, I have been restrained from participating in the election, my lord.
You have been restrained.
I've been restrained.
The morning, the matter, it was same thing. The person has been restrained.
Probably, my lord, because they're all owners.
Very.
Leave may be granted. My lord, my clerk is already present, my lord. There, I will file it, my lord. I will already serve also.
All right, go. Leave. Tomorrow. কালকে যে
Lordship, item number 280, Lord. Water connection, Lordship. Kindly upgrade.
Who is your other side?
KMC. I will intimate.
280.
280.
তুলে দিন ওপর দিকে।
My lord, 514, my lord. Restoration, I have said the copy upon the opposite party also.
Who is your other side?
My lord, I have sent it to the post also. I'm not able to get contact with her.
Learned advocate?
No, Mr. PC Bhattacharya, my lord.
If you can get the phone number, then call up. Because in case you want upgradation, you have to bring your other side. This way you cannot come with a letter. The respondents will not get to. For you it may be just a restoration, but for other side there are other interests. So I cannot permit. You have to serve.
But item numbers 429 and 430, Lordship will kindly upgrade the madam lord. Unauthorized construction, madam lord, services.
Well, unauthorized constructions, I'm aware. Yes.
Due to other side was present here, just he leave, Lordship.
So when he was present, you should have mentioned. After he has left, you come and mention.
He knows, Lordship. He knows. Kindly fix it up next week, Lordship.
Which one?
Next 502, Lordship. Contempt matter, Lordship.
Why will it be fixed up? Then what is going to happen to the list? The entire
Lordship. Just marking, my lord. Every Thursday, Lordship, in the morning, my lord has taken the mentioning.
I tell you, you bring your other side, I'll take it. But then I'm not going to change the position. Sorry, I'm not going to change the position in the list. You bring your other side, I'll take it. Again, my lord, what? It's 5 o'clock nearly.
My humble apologies, my lords. On Monday, there's a huge
possession which is taking place. So it will be very difficult for us to come to the court on Monday.
Join online. Virtually you appear, no difficulty.
Grateful, grateful.